Rise for the jury. All right, where?
Yes.
President County for your honor.
Thank you, Deputy Scott. Welcome back, members of the jury. We're ready to resume the evidence in this case, and it is now defense opportunity for cross-examination. So the floor is yours.
Thank you, Your Honor. If I may, I'm going to have my associate Alex Martinez distribute some binders similar as we did with Mr. Norton. Alex. Ready to proceed, Your Honor.
Floor is yours.
Good morning, Mr. Ballard. How are you today?
Good.
You recall you're still under oath.
Yes.
Okay. You started your testimony yesterday talking a little bit about your qualifications. I want to ask you a little more about the qualifications to become a professional engineer in the state of Georgia. Could you give the jury a rundown of what you need to do before you become a professional engineer who can affix a stamp?
Sure. You have to have passed an engineering training exam before you start practice or sometime during your practice. You have to have either 3 or 4 years of relevant experience and references for that experience. You can reduce that time by a year if you have an advanced degree, and then you have to take a test and pass the test. And if you meet all those qualifications, then you become a professional engineer.
And a professional engineer, a lot of times we see after a signature line, a comma PE, that means professional engineer, right?
That's correct.
Okay. And there's no different licensing or testing qualification process for different disciplines. You're either a professional engineer or you're not, right?
That was true back when I took the test. I'm not certain that that's still true today. I'm not up to speed on that.
Okay. You're not aware of any specific designation that allows someone to practice as a structural engineer as opposed to a geotechnical engineer, for instance?
I'm not.
Okay. We talked a little bit at your more recent deposition, Mr. Ballard, about an emergency petition that was filed with this court on the eve of Music Midtown in 2023. Do you remember that discussion?
I do.
You were not consulted as part of that emergency petition. In fact, you didn't know it had been filed until I told you at your deposition, right?
That's correct.
Okay. You did not advise.
Correct.
So you don't know if the void area has grown or shown any signs of further problems over the past 6 years?
I do not know.
Okay. And certainly you would not have the opinion that there is a grave danger to the public associated with the community center.
I have no idea.
You would not feel unsafe going and eating at the Shake Shack at the community center, correct?
That's correct.
Correct. You would not feel unsafe.
That is correct.
Okay. You're not offering an opinion that the repair performed by the city's contractor was not an appropriate repair of the void at issue in this case, right?
Ask the question again.
Sure. You don't have any opinion whether the sinkhole has been properly repaired.
I do not have an opinion.
Okay. You've never, throughout your course of work on this matter, advised Be Our Guest that the community center is unsafe to build and operate a restaurant in, correct?
I have not.
As you sit here today, you continue to believe that the city of Atlanta's 100-year-old sewer immediately beneath the sinkhole or void location was the cause of the loss of ground.
I do, correct.
And whatever caused that sinkhole could have been repaired in the past, long time ago, right?
It's possible.
Do you understand, Mr. Ballard, this is a combined sewer?
I do understand.
Could you tell the jury what a combined sewer is?
Yeah, 100 years ago when the sewer was built, we did not have separate sewers for sanitary and stormwater. And so they combined them into a single sewer. And that's what these combined sewers are supposed to be. I don't know if it still operates that way today or not, but that's the original intent.
There's been some discussion of back in the early 90s, every time it would rain an inch or so in the city, a lot of sewage would end up flowing into Piedmont Park. Are you aware of that?
I'm not.
Okay. So you're not aware of what has been done to make it so that doesn't happen today?
I'm not.
Who is Jonathan Sharp?
He is a engineer that works for the same firm I work for.
Okay. And am I correct? He was sort of the day-to-day guy for the Be Our Guest project?
That's correct.
Okay. And I say day-to-day, Piedmont Geotechnical, your former firm, they were engaged on this project before there was any evidence or anyone was concerned about a void, right?
That's correct.
What type of services was your firm providing?
During the construction, there would be various structural items that would be built, and our firm was responsible for inspecting those items to confirm they're built in accordance with the plan. We test the strength of the concrete that's placed. We check the reinforcing steel that's placed to make sure it's correct. We check steel beams, if there are any steel beams to be erected, and make sure they're bolted or welded correctly.
And that's all normal part and parcel of a construction project.
That's correct.
And do you get involved or did you at that time period, 2018, were you involved in that sort of day-to-day compaction testing, concrete testing, those types of things you just testified about?
So neither Jonathan or I are involved in that day-to-day. We manage the people that are doing it day-to-day. And yes, I was still running various construction testing projects day-to-day at that time.
Okay. But you're not out in the field typically doing that type of, I'll call it run-of-the-mill testing.
Occasionally.
Okay. You never did that at the community center or Be Our Guest project, did you?
No,
You were called in for your expertise once the void was discovered, is my understanding.
that's correct.
Let me show you, we've presented you with a binder, Mr. Ballard. I promise we're not going to go through all of it. If you wouldn't mind, though, going to tab 6. Have you seen this document before, Mr. Ballard?
I have.
Could you describe it?
It's a telephone memorandum of a conversation between Jonathan Sharp, who was our project manager on this project, and the superintendent for the contractor.
Okay. And I think you told me at your deposition that these types of telephone memorandums are prepared in the ordinary course of an engineer's business.
Especially for something that's an unusual item.
Okay. And this void we're talking about here today, it's a somewhat unusual item.
Yes.
Let's explore that just a little bit. Sinkholes happen in the city of Atlanta, right?
They do.
And it's not that uncommon that a sinkhole is identified and repaired, right?
So as a reference, in 40 years of work, I probably have had that kind of thing happen on a project less than half a dozen times. And I don't recall it ever happening underneath the building.
Okay. But in the city streets and just people's yards, et cetera, I'm not being as specific as what we're talking
Sure.
about here. I mean, there is sinkhole activity and a lot of it is associated with the city's aging sewer infrastructure. Would you agree with that?
Yes,
There are old City of Atlanta sewers running all over town, subsurface, right?
that's correct.
There might be one underneath this courthouse.
There might be.
The item behind number 6, this telephone memorandum, is this something you considered informing your opinions in this matter?
Perhaps.
You don't know?
Well, I would have come to the site and seen the condition myself and not had to rely on Jonathan's telephone memorandum with the superintendent.
I think you've been to the site, Mr. Ballard, twice, if I recall correctly.
It's either 2 or 3 times.
Okay, you tell me about that. Did you go to the site before the slab had been removed?
Yes.
Okay, what did you observe?
The piece of slab had tilted and fallen into a hole.
Did you reach any conclusions or form any opinions just from that observation?
Other than we had a sinkhole underneath the building.
You used quotes there. Why did you use quotes when you said the word sinkhole?
From a ground engineering standpoint, it's not truly a sinkhole, but we can call it that. It's the same sort of effect.
Sure. The same type of mechanism is causing a sinkhole or a subsidence or void. There's a pathway of water and there is a space to accept sediment and water.
Correct. Correct.
Are you familiar with, in connection with that mechanism, are you familiar with a reference to a throat?
Yes.
What does that mean?
That's usually referred to in a true sinkhole condition where a sinkhole forms because there's rock underneath here and it's granite. In different parts of the state, there's rock underneath the ground and it's limestone. Limestone dissolves as groundwater goes up and down in it. It will create at the top of that a small diameter hole, and then the soil above it tends to want to funnel through that throat down into the void in the rock.
And have you ever been involved in repairing or investigating a sinkhole, an actual sinkhole in the technical sense?
Yes.
Okay. Have you been involved with that many times, or are you thinking of a specific time?
A handful of times.
What do you do to repair a natural freeze?
If we can reach the top of rock and therefore we can reach the hole that's allowed the things to fall in it, then the top of the rock can be choked off. The hole in the top of the rock can be choked off by some method, by either placing larger stone and then smaller stone and then smaller stone over the top of that, or by some other method.
You're not trying to repair the actual cavern. You're trying to stop the flow of water and sediment into the cavern, right?
That's correct.
Okay. And you deem that successful when you know that you've choked off the throat?
Correct.
Coming back, I'd like to move for the admission of what's been marked as Defendant's Exhibit 501.633.
Objection to 501.
Just a moment, we're trying to figure out which one that is. This is.
Behind tab
Yeah.
6.
Object on grounds of hearsay, Your Honor.
All right. Is this, I'll let you state your exception. Do you believe that exists?
Yes, Your Honor. We believe that this is a business record prepared in the ordinary course of an engineer's business. Mr. Ballard has testified as such. And moreover, I'm not offering it for the truth of the matter.
So to that end, I don't think he would qualify as the records custodian or be able to, I don't think he expressed knowledge of this particular memo's.
Well, it was in his
Course.
file. It was prepared by his employee, and it's something that was provided to us as something he relied on in forming his opinions.
I thought his testimony was he wasn't sure that he'd actually looked at it in forming his opinions. If you want to clean that up, maybe. I didn't hear that.
Well, that's what I'm saying is it was provided to me as something he did consider. Mr. Ballard, let's clear that up. If you don't remember, you don't remember. do you know if you considered Mr. Sharp's memorandum informing your opinions in this matter?
I broadly considered everything that was in our file, not specifically this or anything else, but broadly. Yep.
Okay.
All right. So on hearsay grounds, then I would deny the objection, and 501 would be admitted.
Judge, we also
Okay.
argue that it's not been authenticated. We've not reached a stipulation. We've tried on business records admissions, and I don't think that's been satisfied at this point.
Okay. All right. And again, if you want to tie that down, Mr. McLaren,
Sure.
Again, it was a little loose there.
Mr. Sharp is a engineer who reported to you during the time period of October 2018, correct?
That's correct.
Okay. And you said it was important to document via memorandum discussions with folks who were on site in an unusual situation such as this, correct?
That's correct.
Okay. And Mr. Sharp is a truthful person.
True.
You would not expect him to make up something that he heard on a telephone call that he put in a engineering memorandum.
I would not.
Okay. This is on a form, Piedmont Geotechnical Consultants, Inc. It's got some check boxes, record memorandum, meeting or telephone. And then it has various fields that can be entered. Is this a form that you are familiar with?
Yes.
Is it a form that you were involved in creating?
I don't remember.
Okay. Your Honor, I think we've laid adequate grounds at this time for the admission of the proffered exhibit.
All right. I agree. I think this witness has identified the record as one of the types regularly made in the regular course of his business, even if he did not personally create it. So objection is noted and 501 is admitted.
And again, for the record, Your Honor, what we've got going on here, the reason I've got 501.633, we had a broad disclosure of deposition exhibits in the case. So I just wanted to make the record clear. I'm not asking for the admission of all of 501, just .633.
63. All right.
Okay, if we could publish this for the jury. Are you able to read this document, Mr. Ballard?
I can.
Okay, I'd like to go through it. It looks like, if I understand, this is the record of a conversation between Mr. Sharp and Chris with J.M. Williams. Do you agree with that?
I do.
You know who Chris is?
I think he's the superintendent of J.M. Williams.
Okay. And you would expect that superintendent to be on site daily?
Yes.
And they're talking about his recollection of the subsidence area progressing. Do you see that?
I do.
We've used this term. What is a subsidence?
It's the hole in the ground.
Okay, it's just the ground is subsiding.
Correct.
And it looks like he's focused here on any growth or movement of the subsidence area. Do you agree with that?
I do.
He says the sides were sloughing towards Willie's. Did you ever personally observe any sloughing of the void?
No, I would not have been out there when this was happening.
Let's pause because I didn't continue my line of thought before. You were on site once before the slab was removed. That would likely have been shortly after the discovery. Do you agree?
I agree.
You said you had been to the site either one more or two more times. Tell me what you remember.
The final time I remember that the hole had been filled in. I remember seeing that. What I don't remember is if I saw the intermediate step where the slab had been removed, the city's contractor had installed some forming and had done some excavation. I don't recall whether I saw that in person or saw it on photographs. So it's either two or three.
Okay. You've definitely seen that on photographs, right?
I have.
And your memory is you don't know if you saw that actually in real time.
I don't recall.
Let's come back. It says that there's some sloughing towards Willie's, and that the slab had tilted down more, maybe 1 to 7 inches. Is that what that says?
Plus or minus 7 inches.
Plus or minus, thank you. Then he mentions some City of Atlanta dye testing. Do you see that a few lines down?
I do.
Okay. And he said that the City of Atlanta dye tested the sewer by filling the subsidence area with water and dye, and that dye was seen in a manhole. Did I read that correctly?
I said, yes, correct.
How does that work? What are you looking for in a manhole when you're doing dye testing?
Well, can I point out that that's inconsistent with what the city's report itself said?
Sure.
But here, what they've done is they're trying to define whether this hole is connected to the sewer. So the hole is above the sewer, they fill it with water, and then they fill that water with dye. In this case, it was orange. And then they look in a downstream manhole, and if the water with dye shows up in the downstream manhole, then they've sort of proven that the water goes through the subsidence, goes through the top of the sewer, goes downstream. And so that's what they're attempting to document here.
Sure.
The superintendent said, and we're getting this third hand, that they did see dye in the downstream manhole, but the city report says that they did not.
And you've testified, I believe, yesterday that you deemed the city's report on that and other issues inconclusive.
Correct.
You're aware, Mr. Ballard, I think you've even had some involvement with sinkholes that have caused injuries in the city of Atlanta, correct?
I have.
And the city of Atlanta has had to defend against lawsuits associated with sinkholes. Are you aware of that?
I'm not.
Does that surprise you?
I'm just not aware of it.
Do you have any reason to believe that when the city wrote its memorandum saying that there was no indication its asset caused the loss of ground, do you have any knowledge that the city is concerned about liability?
No, I have no knowledge.
In your opinion, was there any reason the city should have affirmatively taken responsibility for this?
Ask the question again.
Is there any reason, in your opinion, the city should have affirmatively taken responsibility for this loss?
If their contractor and their tests have not identified the sewer as a source of the problem, then I can see where they would say it's not the source of the problem until you prove otherwise.
And you deem those tests inconclusive?
Say that again.
And you deem the testing that his contractor did as inconclusive?
I do.
So we don't know if the city caused it or didn't.
We don't know if the source was the sewer or not.
But in your professional opinion, you believe it was the sewer that caused this.
I believe it was.
And it's common in engineering to not be able to definitively explain why something has happened, correct?
Correct.
In a perfect world, we would know exactly what caused this, exactly how it was, right?
In a reasonable world, we would know that.
Okay. Do you agree that sometimes engineers have to operate based upon their best professional judgment?
Yes.
Okay. Carrying on in this email after the report of a positive dye test, again, this looks like it's focused on the growth, if any. There's discussion about, again, he said that the hole was noticed after the movement in the hole was noticed after the hole was filled with water and the soil saturated. Do you see that?
I do.
Do you have an understanding of what Mr. Sharp is reporting there?
Yes.
What is the phenomenon he's reporting?
Well, if you have a hole and you fill it up with water, and it's a large hole and it's a large amount of water, as the water drains out of the bottom of the hole, the soil on the side of the hole is now saturated and wants to fall into the hole. And that's what they're describing here.
So the fact that there was some sloughing after the city put water into the hole, that's not evidence that there is ongoing active sinkhole activity. That's just evidence that the city put water in, right?
I believe so.
Okay. I'm going to jump ahead, Mr. Ballard. You didn't have much involvement in this case after you issued a proposal to be our guest in April of 2019 to do some ground penetrating radar. Is that correct?
That is correct.
You gave a deposition in 2022 and one more recently, but other than that, you haven't really done anything to further investigate the sinkhole, correct?
That is correct.
If Be Our Guest wanted to know more about whether there was additional sinkhole activity at this site, there were things that could have been done. Fair to say? Potentially.
Right.
Okay. Tell me what you would have wanted to have done had you been asked. Let's talk about after the city put the gravel in. You
Okay.
agree with me that made identifying the cause far more difficult.
Far more difficult.
So despite that difficulty, there were still things that could have been done post installation of the grout to understand more about the subsurface conditions. Could you explain to the jury what could have been done?
So first thing that could have been done is the city contractor hammered the sewer, which would have been a perfectly reasonable thing to do. But the report that they provided had a single photograph in it of the sewer, not any of the video. And the photograph was of the bottom of the sewer, not the top. So it would have been reasonable to provide the video that they supposedly had or could not find. I don't know what the situation was, or have it re-videoed. The second step would be to do some type of ground investigation, like a ground penetrating radar. There are limitations, but we could have taken that as the next step. And if it showed something or didn't show something, there might have been a next step that could have been done. We could have investigated it by drilling borings through the slab to see what we could find. So it's an iterative approach. There are things that could have been done, starting with recamera the sewer or find the video.
And I think there's one more that you mentioned when we spoke before, and I'm going to butcher this. Electro reactivity.
So electrical resistivity. There are different indirect tools that we can use to investigate the ground to find voids, caverns, or sinkholes. Ground penetrating radar would have been one. Electrical resistivity would have been an alternative, maybe. I had a fear about that one and that the sewer itself might cause the data to come back corrupted. But there's some things that could have been done potentially.
And when you go about an investigation, you would agree with me that before you start doing destructive testing, it's reasonable to start at least with non-destructive testing.
In this case, yes.
Okay. And when you visited the site after the city had injected the grout, did you walk around the front area where the Walkers, the larger restaurant, was under construction?
I don't recall.
Do you recall seeing some steel beams that had been erected that were going to be, I guess, the beginning of what we heard called the atrium of the Walker space?
I don't recall.
Do you recall that there was plenty of soil in the Walkers area that had not yet been covered with snow?
No, I don't recall.
Okay. Let me see if I can refresh your recollection. We admitted yesterday an exhibit of some photographs from August of 2018. I'm going to see if we could pull those up. Yeah. And for the record, this is, can you scroll? This is defendants exhibit 73. Just going to have you, Mr. Martinez, if you could just scroll down so we could stop there. Are you able, Mr. Ballard, to identify what we're looking at here?
No,
You don't know.
no idea.
You don't know if that's the community center?
I don't know.
Okay. Let's go down a little more. I'm gathering that doesn't help. Tell me if we get to one, Mr. Ballard.
I'll do it.
Yeah. How about here?
Okay, I recognize that. No, it's not what I thought. I don't know what that is.
Okay.
You know,
What were you thinking when you?
I thought it was originally the hole in the ground with that piece of slab, but it's not. It's some other part of that construction, I guess.
Okay, but again, I don't want you to, if you don't know what we're looking at, I don't want you to know.
Nope.
Let's keep scrolling down. Keep going. That ring any bells?
Again, the only thing I can remember is walking into the building directly into the place that had the hole that was filled in.
If you wanted to take some borings in that area, to learn more about what's going on underneath, that wouldn't be a difficult thing to do, would it?
There's a lot of underground utilities, so it might be.
Okay, you would want to avoid those utilities, but those are generally known, and if you were able to avoid the utilities, there's nothing stopping you from taking some bore samples here.
So the work inside a building would have to be done in what's called a hand auger boring. Depending on how rocky that ground is, we may or may not have been able to get a hand auger boring through it.
Okay. You say that when you're inside, you need to use a hand auger?
Yeah, there's not enough roof space to do a regular soil test boring. We'd have to boom up, and there's just not enough room underneath the ceiling to usually do a soil test boring with a machine rig inside.
Okay. Let's keep scrolling down. You're not able to say where we are here.
No.
Okay. Fair enough. Bear with us just a moment. Maybe I'll ask it this way, Mr. Ballard, if you were standing on Piedmont Avenue looking at the community center, would you be able to identify the building if you were driving down the street?
Probably not.
We can, if you don't remember what the building looks like, that's fine. Sounds like it's been some time. You remember going into the specific area and looking at the specific subsurface issue. You don't remember what else was going on inside. Fair enough.
That's correct.
If there was an exterior area that was being built out as part of the sit-down Walker's restaurant and it wasn't yet covered, if you wanted to do a boring without the restriction of sounds like something needs to go up high in the air, you could do that, right?
As long as I could get a drill rig into it, if they're not walls or some other thing that keeps me from driving a vehicle into that area.
If you could get a Bobcat, you know what a Bobcat is?
I do.
If you could get a Bobcat in there, could you get a drill rig in there?
Drill rig's much bigger.
It is?
Yep.
How much bigger?
Twice the size plus.
You mentioned the hand auger boring process. Is that what I'm thinking? It's just something like this?
Sort of. Yep.
Okay. Are you typically able to get a good sample using one of those machines in the city of Atlanta, or sounds like if you're running into rock, you can't hit through the rock?
Yeah, not only if and then our data is not valid either.
Why not?
We do two things when we do a hand auger boring. We drill a hole by hand and then we put a sampler down the hole and run a test. And if we have rock, it'll create an artificial data point that's not useful to us, that not legitimate test.
Okay, because if you had more power, you'd have gone right through that.
Or the test would have, what we're trying to do is reveal the strength of the soil, not necessarily that had a piece of rock in it. It'll give us an incorrect answer.
You'd be getting at the strength of the guy turning it.
Yep.
Okay. Just to round this out, I think there was some testimony you offered about additional work that could be done. Now we're going to move into the more destructive. You could do some boreholes through the slab.
That's correct.
How would you do that if you couldn't get the drill rig in there?
By hand.
Okay. And is that something that you wanted to do or you think should have been done?
I think it could have been one of the next steps.
You would only recommend taking that step after trying to do some work that was non-destructive, right?
Correct.
And I think you said in your deposition that the GPR has some limitations in terms of it might only be able to see down 5 or 6 feet.
That's correct.
I take it to mean that if you'd have done GPR immediately before the saw cutting that caused the subsidence event here, you would expect GPR would have identified.
Correct.
You're not here to tell the jury that this building shouldn't be used.
No.
And the re-cameraing of the sewer, as I understand it, tell me how you would go about doing it.
The same way the city apparently did it before. You put a camera on a roller in the sewer and it tracks itself down the sewer and takes a 360-degree video of the sewer as it's moving forward.
I'm picturing, is it like remote control?
It can be.
Okay. And just to round it off, you didn't perform any of the ground penetrating radar that you proposed.
I did not.
Do you remember, was that because it was a cost issue for BRGS? Was this expensive?
I don't know why we did not do it.
If I were to remind you, and we can look at the proposal if you need to, I'm just trying to move forward. Does $4,200 sound about right for the cost of the GPR study?
Yeah, 5,000, something like that. Yep.
And again, that proposal was never acted upon.
Not by us. Yep.
Are you aware of anyone else who's done any GPR stuff?
I'm not.
And you were never asked to go out and do any hand auger boring or to bring the drill or try to bring the drill rig machine in to do any borings?
No.
You were never asked to re-inspect the sewer using the sounds like a robot or something with 360-degree cameras. You were not asked to do that either.
No.
Those are all things that if you wanted to know the cause of the sinkhole, or if there were other sinkholes, those were all things that you were able to do.
We can't do the camera, but somebody could have done the camera.
You'd get a subcontractor to do that?
We wouldn't do it. I mean, somebody else that understands sewers would do that, but we could look at the video.
Okay. There have been some statements over the years, and we'll probably see some documents, Mr. Ballard, where Be Our Guest is taking the position that the matter can very simply be remedied through a proper investigation by the Conservancy. Have you seen statements to that effect?
I think I have.
Do you agree with the statement that the Conservancy could very easily remedy this situation, i.e. determine the cause of the sinkhole by a proper investigation?
I don't know about easily.
It'd be difficult, wouldn't
It would be complicated.
You would have liked to have been on site before the city injected the grout to inspect the top of the rock sewer, right?
Somewhat of my background, yes. Either me or a geotechnical engineer working for the contractor that could have had some definitive opinion about it.
And again, your firm was on retainer or was working for BRS before the discovery of the sinkhole.
Correct.
And you were involved in trying to understand the cause of the sinkhole and what should be done to repair it, correct?
No,
Tell me, you were not involved in trying to understand how to repair it?
no,
Okay, you were involved after the repair in trying to understand if the repair was adequate.
yes.
And you've told the jury you don't have any opinion as to whether it was adequate.
The only thing I know is they filled in a hole.
Do you know anything about what they filled in?
I think they filled it in with flowable fill, or maybe it was a low strength grout. I'm not sure.
There's some references in some of your writings that they filled it in with cement.
Okay.
Cement's not the same thing as a flowable cellular fill, is it?
No.
Okay. What's the difference?
Well, cement actually is not even concrete. Cement's a piece of concrete. So that wouldn't have been correct anyway. But I think they filled it in with some thing that's lighter than concrete, and whether it has some strength, but I don't know. I don't remember. I can recall exactly what the material was they filled it in with.
And you would expect before fill was inserted into a void like this, you would expect there to be some engineering review of the mix.
Yes.
Do you know if that was done?
I don't know.
Do you know if the flowable fill mix was submitted to the city by its contractor for approval before it was inserted into the void?
I don't know.
You can't say one way or the other.
I don't know.
You do agree, Mr. Ballard, that the use of a flowable cellular fill is common in the repair of a void or a sinkhole?
No, I don't know that.
You don't know?
No, I don't know that.
I'm going to show you a document we've seen a few times before, Mr. Ballard. If we could pull up Plaintiff's 109. And this was used in your direct testimony yesterday, Mr. Ballard. Do you still have those documents with you?
No.
It's the city report.
I don't think I have a copy of it.
Okay. I think I've got an extra.
We set the exhibits up on the stand with the court reporter, Your Honor.
Oh, may I? You've reviewed this document, Mr. Ballard, correct?
I have seen it. Yes.
Okay. If you look, just want to quickly ask you about, we've seen this before, but if you look at the third paragraph, there's some discussion of CCTV inspection. Do you see that?
I do.
Okay. And it says the results of visual inspections did not indicate any structural deficiency concerning the sewers. And then it says that warranted repairs. Do you see that?
I do.
What would do you know what a structural deficiency is with respect to a sewer?
I'm going to presume here they're talking about an actual structural hole in the sewer, as opposed to some other thing where the sewer might be blocked and impede flow.
Okay. I had asked you about, and I appreciate your explanation for the jury of the combined sewer. Are you aware, Mr. Ballard, that in a heavy rainstorm, the sewer, obviously the volume of water you would expect to increase?
Correct.
Okay, and in a very heavy or significant rainfall, there could be more water than the actual sewer could take, such
Yeah.
that it became pressurized, right?
Yes.
And if there were a tiny little hole during one of those pressurization, heavy rain situations, that could shoot water up into the ground, kind of like a big water pit, right?
Yes.
And then when the rain stopped and the water levels dropped, it could pull down that water and there could be a loss of ground into the sewer.
Yes.
Do you think that's what happened here?
I don't know.
Do you think that that's a reasonable thing to conclude could have happened?
I think it's a reasonable thing to be concerned about.
And you would agree that if that were the case, the city's injection of that flowable fill would have could have clogged whatever little hole or repaired whatever little hole was allowing that mechanism.
I think could have is the right word, maybe.
Your Honor, yesterday we had some discussion about the admission into evidence of the exhibits to this City of Atlanta report.
Page 1 so far.
Yeah, I'd like to go ahead now and move to include all of plaintiff's 109.
No objection.
All right, 109 is now admitted in its entirety.
Like to go a little ways back, Mr. Ballard. This is the second to last page of Exhibit B. Now, just to help you, this is what I'm looking at, Mr. Ballard, this page.
Okay. Can you show me that again?
Yeah, it's this one.
Got it.
It ought to be on your screen now.
Okay.
And I think, is this the condition, Mr. Ballard, you were testifying, you weren't sure if you saw this with your own eyes or if you've just seen it in photographs?
Correct.
Okay, what are we looking at here?
Well, this is where the hole was formed, and the contractor has installed some protective means around the hole so workmen can go down to the bottom of the hole. And that's what we're looking at.
Are we looking at, if you know, the top of the old rock sewer that we've been talking about?
It doesn't look like it to me. It might be, but it would be very rough if it were. It appears to just be a bunch of loose rocks on the bottom of the hole. That's what I think it looks like.
The contractor was hired by the city to excavate to the top of the rock sewer. Are you aware of that?
I am.
Okay. And you can't say whether that's the top of the rock sewer or not?
I cannot.
If it is the top of the rock sewer, it looks to be, and I think you said, it looks loose and not, well, let me strike that. What would you expect to see?
I'm just not familiar enough with 100-year-old rock construction. It could have been just a bunch of loose rocks sort of gently mortared together. Or that could just be rock above the top of the sewer. I can't tell.
Okay, fair enough. And again, this is looking down after there's been significant excavation.
Correct.
want to look now. There's a diagram. It's a few pages back. I think it's the first page after the exhibit B dye testing. You with me?
Got it.
This is a record of dye testing performed in September of 2018, correct?
Yes.
And if you go to the next page, we've got another photograph of that same location, I believe. And you had testified, Mr. Ballard, you believe the dye the city was using was orange. You see that?
Yes.
Is that the orange you're talking about?
Yes.
This looks like an in progress dye test.
Correct.
Okay. And what is the date of this picture?
September 28, 2018.
Date of the picture.
That's what it says.
Does it say September 28 or September 24?
Mine says September 28th. This diagram is 24th. The photo is the 28th.
Right, but do you see on the photograph?
Oh, I'm sorry.
itself?
Yeah. Okay. Yes, I see that.
But the photograph was taken. the
Okay,
24th.
yep.
Looks like the
Report's 28th.
a few days later.
Yes.
All right, did you answer? And now I want to go all the way to the very last page. There we go. Are you able to tell Terry what we're looking at here, Mr. Ballard?
So we have 4 photographs. As far as I can tell, the top 2 are the same photograph. It's a photograph, supposedly, as best I can tell, of the camera as it's starting on its track through the sewer. The first photograph on the left is at the upstream manhole where they start the test. The second photo to the right, to me, is the same photograph. The next,
Maybe according to it, 10 seconds.
Yeah.
Yeah, okay.
all right, the next 2 photographs, the one in the bottom left shows the wheel of the camera vehicle as it's traveling down, identifying a specific place in the side and the bottom of the sewer at a very specific location where an additional sewer comes in. And then the last photograph of the right, I think, is probably the upstream or the downstream manhole, just showing a photograph of the manhole. So these 4 photographs are the only,
Can you tell, does it look like maybe a person was up there looking down?
I can't tell. Might
I
be.
can't either.
So the 4 photographs, this is the only photographs that we got of the entire video. The one at the top is simply the starting point. The one at the bottom right is of no value. It doesn't show the sewer. The only photo of the sewer itself, except at the starting point, is the one in the bottom left. And it shows just a single 1 linear foot of sewer at one specific place.
Can you tell, looking at the 2 top photographs, if there's been any repair work or mortaring over the years to reinforce the inside of the sewer?
I can't tell anything.
Put that one away. I'd like to show you what was marked yesterday as plaintiff's 144. Maybe I'll just bring these back to you, Mr. Ballard, and we'll ask you about a few of them. If you wouldn't mind, Mr. Ballard, if you could look for plaintiff's 144. It's an email dated Valentine's Day, 2019. let me know when you've
We're glad
got
to
it.
display these. These are ones that have been admitted.
Yeah.
We're glad to display these.
Oh, thank you. Like old times.
May take a moment.
Yes. Thank you, Lisa.
I don't think I have 144 unless it's out of order.
It may be out of order.
Okay.
You know what? Are you comfortable? Are you able to see it on this? Are you able to see it on the screen? If you're comfortable doing that, that'll save us.
Yes, I remember this.
Click that, little question. Or no, sorry. the other button. Yeah.
Oh. I could have done that yesterday.
Are you able to see plaintiff's 144, Mr. Ballard?
I can.
Okay. This is an email. It starts, or maybe ends, I should say, with an email from you to Ms. Drolette, and you're copying Mr. Sharp, who we've heard about, and Mr. Norton, who the jury was from. And you said, I think your acronym is, in my opinion, this letter provides those assurances to the best that Palmer can say. Never going to get that in any better way than this letter states. What letter are you talking
I presume it's the,
about? If you go back a little bit, we'll go back. There's an attachment, and it actually attaches the Palmer November 15, 2018.
so I have that in front of me.
Yeah.
Okay.
I'd actually, if you don't mind using the screen, I think you've marked up, if we could go down to the Palmer report. Oh, I'm sorry, it's attached just a few pages back. There we go. You recall that this November 15, 2018 was attached or was provided to you and attached as part of this email chain?
Yes.
Okay. And it looks like you marked it up or at least drew some boxes around certain areas. You recall that?
I do.
What was your purpose of doing?
Just to highlight things to me personally as I was reviewing the report.
And this is the letter that you were telling your client they weren't going to get any better than that. And your client was looking for certainty with respect to what caused this sinkhole, right?
I don't know that they were looking for certainty. I was just telling them that it's not going to get any better response than what Palmer has said here.
You don't know that VR Guest wanted a definitive opinion of what caused this sinkhole and a definitive opinion that the site was and would remain safe.
I don't recall that.
You just don't know.
I don't know.
And then you say, Lisa, if we could go back up to the very beginning, to the email, very beginning of the email. Oh, Anna, you're working. Thank you. You say, you conclude with subsurface conditions, there can never be a guarantee. With guarantee, of course. Remember why?
Yeah, because the Palmer report has some qualifications to it, and that's my way of saying in a different way, you're not going to be able to get a report that has not got some qualifications to it.
Right. I mean, that's normal in any engineering report, right?
In any ground engineering report.
Right, because you take a boring, you know what is going on in that specific location. You don't know what's going on 10 feet over.
Correct.
Okay. Would like to show you just briefly plaintiff's 97. And this is the September 18, 2018 Palmer report that's been admitted.
Is it in the stack?
It should be.
Which one? 97?
Yes, sir.
Okay, I have it.
My question on this one, it may be very short, Mr. Ballard. Do you know if you received this report sometime in September of 2018?
I don't recall.
Have you reviewed this report?
I have.
Okay. This report also provides some statements indicating there was connectivity to the Boyd location in the city of Atlanta, which were confirmed by dye testing, correct?
Correct.
Did you just completely discount this evidence of a positive dye test in reaching the conclusion that we don't know what the cause of the void was?
Ask again.
Sure. Did you discount the evidence of a positive dye test in July when coming to the conclusion that we don't know the cause of the void?
Well, he's misstated here because the city report said there was no connectivity.
So why is the city right and other people are wrong?
Because the city performed the test, they had the report. He didn't do anything independently except review that report. So I think he misunderstood what the report said, or I had misunderstood it.
Oh, you're not aware that someone was out there actually looking over the shoulder of the operator, looking at the CCTV image when the city was doing the report?
I'm not.
He has to be faith basis. He can ask any faith basis. He's got to prove it up.
Would like to go to tab 15 in your binder if we could, sir. This was admitted yesterday, but I'd like to admit it because we've done some work in an effort to make it more reasonable. We looked at this at your deposition in the same format. This is defendant's exhibit 1. And I'm going to go ahead and I'll give counsel a moment to review, but I'm going to go ahead and move for the admission of this. What we have done is we have taken this email where the print is tiny and made some effort to make it a little bit bigger. So I think that would be helpful for both you and the jury.
All right, to the extent this is duplicative of the previously admitted plaintiff's exhibit, I don't have the number handy. Is there any objection to, I guess, tendering of defendant's exhibit 1?
No objection.
All right.
Okay.
Then
And
this
for
is
the record, this is an enlarged version of plaintiff's 150, and we'll refer to it as defendant's exhibit 1. We can put that on the screen if we could, and we can skip past the first page that has the tiny print and move to the more readable version. And I'd want to start at the bottom. Looks like, Mr. Ballard, this is an email from Ms. Drolette to yourself dated April 2nd, 2019. Do you see that?
Yes.
Okay. And Ms. Drolette says, hope you are well. We are making headway. Can you provide a plan for addressing the sinkhole as it stands now? We are submitting the bids to the Conservancy. You see that?
Yes.
And I think you said, you don't know if Be Our Guest ever submitted any of your proposals for the GPR to the Conservancy?
I don't know.
She says, I know you mentioned boreholes or some sort of sonar, et cetera. The sonar, et cetera, can you use sonar or you think we're talking about the GPR here?
GPR.
And you respond a couple days later and you provide your thoughts, correct?
Correct.
Okay. And the first thing you say, I want to let you know how we were going to handle this and what assurances we will be limited to at the end of any investigation. What did you mean in terms of, you wanted Mr. Ouellette to understand, I'm paraphrasing, but the limitations of what you would be able to say?
So I don't want my client to expect that we have a single tool that we can go out there and come up with all the answers that I think we need. That this tool will be able to do certain things and it has certain limitations, and to know that before we go in.
Okay. Basically, if your client is looking for a full assurance that this is never going to happen again and needs you to sign off on safety, you're letting her know before we go down this path, you're not going to be able to do it.
At least with this one step.
You say, had the hole not been filled, then it was possible to be specific about the problem, risk, and solution. That time has come and gone. Did I read that correctly?
Correct.
You're not aware of any reason, if BR Guest wanted you or another geotechnical engineer to be on site during the city of Atlanta's excavation and before the installation of the grout. You're not aware of any reason that couldn't have happened, are you?
I'm not.
And are you aware that BR Guest was provided notice by the Conservancy that the city of Atlanta was on the site doing its investigation?
No,
You don't know?
I do not know.
All right, Mr. McLary, we're about 10 minutes over the hour. How much more time do you think you have remaining?
15, 20 minutes.
All right.
Looking down, you go on in this email to say you can do it. I'm paraphrasing a little bit, Mr. Ballard. We can do an investigation using ground penetrating radar. You say this can look down a few feet. Few is not more than 5 or 6. And if there are any voids of size, they can be detected and more boring work could be done. Do you see that?
I do.
Okay. And you don't know where that might lead. What do you mean by that?
This is in my mind, this is a stepped approach, and I just don't know which direction it's going to go after we do step 1. We find that there are voids, then we can do borings in that location. We don't find that there are voids, we might still want to recommend doing borings because they can get deeper than the GPR can look. Just don't know what direction we're going to go in.
Okay. And then you say we would want you to hire someone to independently camera the storm sewer. Now or in the past, they are the most likely source of the past sinkhole. Did I read that correct?
Yes.
What did you mean when you said now or in the past?
So it's possible that this sinkhole has had a failure in the past, and a failure would be another sinkhole, and that it had been identified and the sewer had been repaired, but the sinkhole had not been fixed. It's also possible this is a current and ongoing situation where the sewer has a defect right now. Could be either.
It's possible.
It is possible.
Then your last statement in this email, you say, if voids are not discovered by the GPR, all that can be said as no voids were discovered and thus no defects were identified in our work. We will not be able to say anything like the building is safe. Did I read that correctly?
Correct.
You would not expect any engineer of any discipline to issue a report saying the building is safe and will remain safe in perpetuity when there's damage.
Except that's sort of what Palmer did.
Well, Palmer said it was structurally sound and he expected it to remain structurally sound for the foreseeable use.
Okay. Yep.
Okay. And so you would not expect any engineer to give an unqualified building is safe. Okay.
Correct.
You would certainly not expect the city of Atlanta to give an unqualified, the city is safe, or I'm sorry, the building is safe report.
No.
Okay. Okay, want to turn to tab 19 in your binder, please. And I believe there's another document you looked at yesterday with Mr. Halsey. We've done the same exercise here to try and enlarge that. But I'll give council a moment to confirm that that is true before asking a few questions about this. This was plaintiff's 185.
All right, why don't you proceed with the assumption that it is identical to 85? And if you move to tender it, we'll take that up.
Sorry, I misspoke. It's defendants 185 is what we're proposing. So we'll find out the plaintiff's version.
At this point, is there an objection to defendant's 185?
They're representing us, so except it's already amended, we certainly don't object.
All right, and this is a duplicative of which one?
That's what I'm getting at here.
All right, we can clean that up later. Why don't you proceed with the next question?
But we'll get it to you later.
All right,
Um,
185 conditionally admitted.
Thank you. Mr. Ballard, this is another email chain between yourself and Mr. Ouellette and Mr. Sharp. This one is dated October 13, 2018, I believe.
I think so.
Okay. Permission to publish, Your Honor.
Okay.
So I want to again go down to the beginning of this email. The first email that I'm interested in is Mr. Ouellette's email to you dated Thursday, October 11, 2018. Starts with, "Hey, guys." Do you see that?
I do.
Mr. Ouellette's asking if anyone can meet her on the site. Does this refresh your recollection, Mr. Ballard, about whether you visited the site at Be Our Guest's request sometime around October 11, 2018?
I visited the site after the hole was filled in, so I presume that it's after this email.
Okay. Were you ever made aware of a meeting between Be Our Guest and the Conservancy to address issues related to the community center building maybe a day or two before this email?
Not that I recall.
Mr. Ouellette says she needs some help with the project. And it looks like she's looking for your advice regarding what the city did. Is that fair?
I think so, yes.
Okay. And then if you look, Mr. Sharp responds, and he says, I think what you're saying today, unfortunately from these, he's talking about reports and photos, we cannot determine the specific cause of the subsidence area or what future impacts to the structure there may be. Please let me know if you have any questions. Do you see that?
I do.
Okay. And then Mr. Ouellette responds the next day on the 11th, and she wants to confirm, I think, her understanding. She's saying, "Thank you for your time today. I really appreciate it. Are there any next steps we can take?" Do you recall a meeting with Mr. Ouellette on October 12, 2018, or around this time period to discuss these particular items?
I don't know if that's the one time I was on site after the hole got filled in or whether this is a response to a phone call or email. So I don't know. No, I guess in reading this, I believe this is the one time that I was on site after the hole got filled in.
Okay. And Mr. Olet wanted you to issue a report with your opinion that you didn't think the community center was safe, didn't you? I'm looking down at the third line of her email. She says, without identifying the cause, you don't think it was safe. You see that?
I do.
Do you recall, Mr. Olet, or someone from VR Guest asking if you could issue a report that said this community center was not safe?
I don't recall other than what I read here.
And you were not willing to issue a report that said the building was not safe?
That's correct.
Okay. What you were willing to say is what you said in response, correct?
That's correct.
And I recall, well, let me just go and have you confirm, if you could read into the record, Mr. Ballard, the very last sentence in your response email.
I said, we have no further engineering opinion regarding the safety of the current condition or whether you should or should not go back to work.
Okay. So there was some questions yesterday about red lights and green lights. Do you remember that?
Yeah, a little bit.
So you weren't putting a red light in front of VR Guest and saying, don't go back.
No.
Do you recall being on the site, Mr. Ballard, when a TV news crew was there?
I do.
And VR Guest had asked that you be there,
Correct.
and you didn't want to be there. Fair to say?
That's correct.
And you said on that news footage that the area in question is safe, correct?
I don't recall that.
Let's look at that. Your Honor, I would like to show this video. I'm not asking that it be substantively admitted as evidence. I'm using it to refresh the witness's recollection as to what was said by him during this particular footage. It's a maybe 10, 15-second clip.
Let me start. Is there an objection from plaintiff as to procedurally how we handle this?
If we would do that, we would ask that the footage be played as entirety then, not just that small clip.
Okay. I mean that could be a valid issue here. It's more so for now, for this clip to lay I guess to refresh his recollection, to have it shown to the jury.
I'm a little concerned with making any representation of the entirety because I don't know what was shown to the public. I know what I've got.
Well, are there other statements he's made that are on this video that you're contending
That's our understanding, yes. And I'll make
need
sure
to be
this is-
considered here?
We have context for what was stated.
All right, I think we need to lay the foundation for that. Why don't we ask everything else other than this, and let's come back to it. Okay,
This is my last.
this is your last question. All right,
And Your Honor, to be clear, I think anything that's said.
I understand the grounds. All right, members of the jury, I think we need to take 5. Just put on the light when you're ready to go, all right?
Doesn't remember. Rest of the video is yours. So it is one statement.
We understand we still objected. We're going to show it. We're going to show the whole piece of context. We'll complete this.
You can argue that for the judge,
That's
but you
fine.
can't ever come to hearsay to the other parts of the video.
But
You can't remember the statement, so it's a process.
All right, so just to be clear, what is the total length of statements that are on this recording from this witness?
I'm sorry.
Just the length of time this witness is talking on this recorded video.
2 seconds.
Okay, and so I understand that right now, all you've asked is to refresh his recollection. And I think the process is he can do that by looking at it right now. We're now outside of the presence of the jury. Then we can address plaintiff's position that somehow other portions can be played and et cetera. So why don't we just start there?
Why don't we show it to the witness now? If it refreshes his recollection, I have no need to show it to the jury.
Right. And that's what I'm saying. So we can take this in sequence. So you can go ahead and show him whatever you need to refresh his recollection. We'll go from there. And I think we need an exhibit number to identify this as well.
What exhibit number? This is plaintiff's 229, Your Honor. Okay, let's see if this works and we can hear it.
Caused it. She hired an engineer who told her the hole itself is safe, but he says he wouldn't continue.
That's it.
Okay.
Do that again,
Right.
please.
I think that there's then,
Caused it.
he
She hired an
summarizes
engineer
something
who
else that
told
he
her
said.
the hole itself is safe, but he says
The
he
reporter.
wouldn't
The reporter is then summarizing something else that he says off camera.
I'm not sure.
I mean, but he says, and then we stop. So why don't we just play
The hole
the
itself is safe, but he says he
what follows after, but he also says.
I'm not following.
The reporter is saying a quote and then doing a voiceover
the hole
of
itself
what
is
else he
safe,
said.
but
What's the?
But continue.
Right. Just don't pause it. Just continue playing it for a bit.
But Drolette says the landlord, the Piedmont Park Conservancy, hasn't said what
Oh, they cut
caused
it off.
She hired an engineer who told her the hole itself is safe, but he says he wouldn't continue to work on the restaurant until they know exactly what caused the sinkhole.
We don't know it's safe.
All right. Unless there's any other references to what he said to this reporter or that he's on film, I think that's the relevant portion to refresh his recollection as to this prior statement. So at this point, you're then asking him a follow-up on that. And sir, your memory has been refreshed. You don't need to be looking at that again or repeatedly.
I'm good.
All right. And then is there anything left on the plaintiff's side that they anticipate regarding this video? That
There was not, Your Honor.
okay. All right. You can let the jury know we're ready when they are. Right. Yeah, you can let them know. That's fine. But instead of it being a whole powwow for strategy, I'm just saying only the folks who need to use the restroom can step out in there to come right back. All right. No, I'm good.
Yeah, that's it. I don't, he's not gonna, I mean, he doesn't remember what the place looks like. Actually, yeah, let's use that, Alex, quickly and just say, if it is, could you fit your rig? Alex, what exhibit is
Yeah.
that? Okay.
That's the pin sites.
Okay. And I don't think I'm going to admit it with him. I just want him to see the picture.
Okay.
Hooray. Well, yeah, hooray.
Back to Jared.
Excuse me.
Thank you, Deputy Scott. Vince, may I ask the next question?
Just a few more, Ballard. You testified today that you're not offering any opinion, and you have no opinion on safety of the community center. It is true, however, that you went on camera back in 2018 and you said the hole itself is safe, correct?
Correct.
And Mr. Ballard, just one more thing that before we let you go. We've talked a lot about things that could have been done, testing, GPR, electroresistivity, after the hole was filled. Could you have done any testing before the hole was filled in that would have helped you to identify the cause of the sinkhole and confirm it was fixed?
Yes.
What would you want to do?
Inspect the top of the sewer right below the sinkhole.
And no one from Be Our Guest ever called you to get you or one of your people out to the site during the city of Atlanta?
No.
Okay, thank you. That's all the questions.
All right, redirect on those points.
Well, again, Mr. Ballard, so I have a few questions to follow up to the questions that Mr. McCleary just asked you. There was some number of questions he directed to you regarding the April 19, 2019 proposal. Do you recall that?
Yes.
And the emails surrounding that proposal.
Yes.
So this is, make sure we're level set on the time frame. April of 2019, not 18, but 19, long into this process, correct?
Correct.
And that proposal, was that based on understanding that as of that time, the sewer had still not been investigated and a cause determined of the sinkhole?
To the best of my knowledge.
And counsel specifically asked you in that regard. Well, actually, let me take a step back. The proposal talked about, as you noted, incremental steps that possibly could be taken at this point in time, given that the hole had been backfilled. Is that correct?
Correct.
And those steps range from less invasive to more invasive. Is that fair to say?
It would be an incremental process.
And like some of that might entail at some point drilling holes in the ground.
Correct.
You thought even about having to get some.
Correct.
Are you aware, do you know who was actually the owner of this property?
I do not know.
In your experience working on these types of cases, would that be something more in the realm of the owner or the landlord to be addressing something that invasive?
Outside of my area of expertise.
So, well, all right, it's fine. I'll deem that withdrawn. You may continue.
You have reason to know from what you discern through this case, talking to our client, talking to the servicing, talking to anybody who was in control of the site in the investigation at that point in time.
I do not know.
Now, you had indicated in response to cross-examination, that you have investigated some number, I don't know precisely, some number of sinkholes as part of your job before this. Is that correct?
Correct.
Was your job in those cases similar to investigate and find the cause of the sinkhole?
Yes.
Were you able to do that in those other cases?
Yes.
It was somewhat unusual not to be able to have that understanding to move forward in the project. Is that a fair statement based on your experience?
Based on my experience.
Now, you indicated, irrespective of dye testing, let's just leave that to the side for a moment. Irrespective of the Atlanta City report, it remains your view that the sewer was in some way, some form, some shape, part of the problem here.
Highly likely.
And on that front, did you have awareness that the sewer traversed the community center?
Yes.
And you're aware that the sewer traversed not just the lease spaces by our client, but other spaces outside of the leasehold that our client has?
I don't know that I know.
Were you aware at any point in time, if I showed you a diagram of the sewer line, like, would that refresh your recollection?
I don't necessarily know exactly how to define my client space versus other spaces in the building. I know it crossed through a significant part of the entire building.
And was part of your concern that there might be sinkholes then would open up along the sewer line beyond the hole that you were looking at?
Yes.
Speaking of, I guess, the sewer, so to the extent you hold the opinion, you described that the sewer might be the problem, wouldn't the grout that was dumped in have fixed that problem?
Not necessarily. The grout mostly just filled in a hole.
In fact, your report that you issued on November 7th, that was after you had been privy to the fact that the hole had been backfilled.
Correct.
And even at that point in time, you still remain concerned about the loss of ground and the future performance of the building or its safety.
Correct.
Did that position ever change?
No.
Mr. Not to make too fine a point on it, Mr. McCleary asked you a number of times. You couldn't say that it was unsafe. Were you ever able to say the building was safe?
No.
Mr. McCleary showed you a email chain in which from February, I think 14th, in which a Palmer Engineering report dated November 15th had been forwarded to you. Do you recall that?
Yes,
And you looked over that report.
yes.
Do you have that report in front of you, sir?
Which date?
November 15th.
I have the version that I have not marked up.
Okay, well, that's all right.
Okay.
Is that the version that was transmitted by way of email?
I don't think so. I think there's another version that has other things in it.
Nathan will put the version that was in the email back up on the screen. Can you all remind me, Lisa, number, please? I think you always put a news at number on it. So we're going to show you 150 was been admitted already to evidence and the council asked you.
Okay, so ask me about the specific one you're talking about, so I've kind of lost track here.
Put this on the screen so we're all talking about this.
Okay.
It is 150. I think it's 150, yes. Sorry.
No.
So we're gonna put I think it's 144, which has already been admitted evidence. This regard to recollection is to the report that you reviewed.
Yes.
Is that as far as the report goes, or is it good to the end? We can go. Down, please. Okay, look, right there, look. Anyway, this is one of the reports you remember, you said you actually relied upon because you marked it up with notes, right?
Correct.
All right, and you see a signature here?
Maybe, Council, I think we covered 144 in the direct. Can we get to the substantive distinction you're trying to add now to recross? All right.
So you testified in response to cross that there's a significance to applying a stamp or a seal to a report. Is that correct?
I don't recall that.
Okay. Well, what is the significance of a seal?
It's a designation that you're a professional engineer.
And if we go back to the top of this report, please. And what's the date of this report?
November 15, 2018.
Were you ever provided another report of the same date from this engineer with the same seal with different contents?
I think so, yes.
Do you recollect that?
Yes.
Of the same date from, let me be clear, during the real time, not during the litigation.
And we covered that distinction. We've already talked about the two reports in his direct, as I remember, and the timing of when and when he did not review it. I think we're covering the same ground. Is there something new?
There's a difference here. I understand that he testified to receiving this November 15th report. There's the second one that we've been calling Hagberg 1. And I don't think we probably discovered whether he actually had access and reviewed Hagberg 1. That's the distinction I'm trying to draw. Yeah, because remember, Your Honor, there's a September report and then 2
I know.
November
All right.
reports. So I'm not talking about the September, I'm gonna try to make this clear. Not a September report, we talked about that. This is November 15 report. Did you receive another November 15th report from Hagberg with a seal that had different contents
Yes.
during the litigation or during real time?
I don't recall. I know I got it during litigation. I don't know when I got it.
You recall those having different contents, those 2 reports.
Yes.
Did that matter to you in in your review of this case?
That was plaintiff's 133. It does not change his opinion. That was already brought out on direct. Next question.
You were asked on cross, whether you would have expected the city of Atlanta to provide a report that indicated the building was unqualifiedly safe, an unqualified report that the building was safe. Do you remember being asked that on cross?
Yes.
Do you have that exhibit in front of you?
No.
Using it as that. Whether you're asked it or not, you have about October and wrote down, it may not be precise, but would you expect the Atlanta to give an unqualified opinion that the building was safe?
No.
Do you remember that report giving any opinion about the safety of the building?
No.
No further questions, Your Honor.
Recross on those points.
Just one point. Mr. Ballard, Mr. Halsey just asked you on redirect about your knowledge or concern that there might be other sinkholes opening up on top of other parts of the sewer that may run underneath this building. You recall that?
Yes.
And you said that you would.
Yes.
And are you aware that there are hundreds of feet of this same sewer that are running in this property that are not underneath this building?
Yes.
And there's no greater probability that those would cause a sinkhole under the building than just out in the park or out in the yard towards Piedmont Road.
Correct.
Okay. And you don't know if there have been any additional sinkholes formed in any of those locations that we can see with our eyes because you haven't been to the site since 2019, right?
I have not been to the site since
You would
2019.
expect your client would have told you if another sinkhole had opened up over top of this.
Objection. The last couple of questions are outside the scope of.
Well, this last one, perhaps.
Well, the testimony, Your Honor, is there's a concern about sinkholes opening up underneath the city of Atlanta sewer. We've established the city of Atlanta's all the sewers are throughout the city.
All right. Well, the expectation, I guess I'll say this, the expectation of what his client will tell him. He's testifying to his opinion. All right.
No further questions.
All right. Can this witness be excused? All right. Thank you, sir. You can step down. Plaintiff may call the next witness.
You may switch with it.
Cells.
The plaintiff's called Chris Settles.
Yes, sir. Christopher Settles.
Good morning, Mr. Settles.
Good morning.
Please introduce yourself to the jury.
Chris Settles, Grounded Engineering.
Mr. Settles, how old are you?
52.
All right. What is your job title?
I'm the principal and owner of Grounded Engineering, geotechnical engineer.
Okay. Grounded engineering, when you say you're the principal, what does that mean exactly?
I'm the owner and primary engineer.
Okay. When was Grounded Engineering founded?
2012.
And where are you located at Grounded?
Flowery Branch, Northeast Hall.
Okay. So you probably prefer not to come into the city if you don't have to.
Unless we have to.
Okay. What does Grounded do at a high level? Describe some of the services you provide.
We do mostly land development assistance, either geotechnical engineering work in pre-development or construction materials testing during development.
Okay. Are there particular industries that you work in?
Residential, generally mass grade, commercial, industrial, retail, a little bit of all.
A little bit of everything. Okay. And when you talk about geotechnical issues, help us understand sort of the types of geotechnical issues that you work with clients on.
Generally foundations, building support, foundation support, soil suitability, site suitability, whether we can dig where we need to dig and whether we can fill on top of what we need to fill on top of.
Okay. Let's back up for a second. Tell us where you went to college.
University of Alabama.
All right. And what degree did you get?
I have a Bachelor of Science in Civil Engineering.
And what year did you graduate?
1996.
Do you have any licenses or certifications?
I'm a registered engineer in the state of Georgia, along with several others. I am licensed as a level 2 certified design professional by the Georgia State Water GSWCCC. Also a level 1B inspector, and that typically is erosion control, either erosion control plans or erosion control inspection. And then I'm also licensed by the International Code Council as a residential and building inspector.
Okay. Tell us, or tell the jury rather, the types of steps you had to take to obtain the certifications you just described.
Obviously graduating, for the licensed engineer, you take an initial test, either during school or right after graduation. And then you have to work for a professional engineer for at least 4 years, and then you have to pass the professional engineer's exam. And then with the other stuff, you, various seminars, various classes, and you have to pass the exams.
Okay. How long have you worked in the field of geotechnical engineering?
Since graduation, for the most part.
So 20 plus years.
Yes, sir.
Okay. And when we talk about the term geotechnical engineering, can you just explain to the jury what that means?
I mean,
I think we've covered that.
Okay, fair enough. Can you tell the jury what's different between a geotechnical engineer and a geologist, if you will?
geologists, pardon me, are scientists. They are focused on collection of data, analyzation of data. Engineers are typically more focused on utilization of that data to design solutions. It's a little more, from our training, would be stress strain related or building related, building interaction with the material related, where theirs is going to be more soil and rock and the interactions of soil and rock and water and those kind of things.
In your experience, would it be typical for a geologist to recommend a repair?
It's unusual typically. In our experience, geologists will collect the data. We have geologists at Grounded that work for us that work on drill rigs, collecting data, collecting samples, and then help us interpret that data. And then the engineers are typically the ones that do the recommendations and design the solutions.
Okay. You said you started Grounded in 2012. What companies did you work for between, let's say, college up to Grounded?
We've worked for several.
Okay. Can you just give a couple of names?
Professional service industries, I think they're now Atwell. Alberg Engineering, Riverdale Paving for a couple of years as a paving contractor, and then basically started Grounded in 2012.
Okay. I'd like to show the jury a copy of your CV if I can. It's Plaintiff's Exhibit 218. Well, actually, let me back up. Let's start by giving you a copy of that.
Is there any objection to the admission of 218?
There is, Your Honor. He's free to ask the witness about his qualifications, otherwise it's hearsay.
I tend to agree unless you can think of an exception. So you can walk them through the pertinent parts if you need to.
Fair enough.
All right, so that's granted, or sustained rather.
Approximately ballpark, how many different geotechnical projects have you worked on over the years for Grounded?
Several thousand.
Several thousand, okay. And then how many of those would involve either foundational issues or sinkholes or voids similar to what we're talking about here?
Sinkholes are rare.
I'm sorry.
Objection, question.
I think it's,
I mean, compound question, Your Honor. He's asking, if you want to ask it separate, I have no objection.
all right. You can rephrase.
How many cases or projects have you worked on involving voids or sinkholes?
We've worked on quite a few.
Okay, can you just give some examples of the types of projects?
Generally speaking, you've got, in this geology in particular, the Atlanta area, we're in the Piedmont geology, and naturally occurring sinkholes don't exist, like you would see in Florida, or you would see in Birmingham, or you would see in other geologies, Nashville, Valley and Ridge. In this case, generally, when there is a sinkhole, or what we would term a sinkhole, the subsidence is caused by some sort of a pipe failure or some sort of a water situation where we are losing material, losing dirt through the water, from the water.
And we'll get to this in a moment, but was that your analysis of what you dealt with in this case?
Yes, sir.
Okay. You're obviously here testifying as an expert witness or proposed expert witness. Is that something you do? Are you like a hired professional expert witness?
Very rarely.
Okay. What percentage of time would you say you split between what you're doing right now and your day job running Grounded?
Very little, 1 to 2, 3% maybe at
Okay.
most.
You probably prefer to be doing the Grounded work, right?
Always, yes, sir.
Okay. Have you been qualified or have you testified before as an expert in a lawsuit?
Not in front of a jury, no, sir.
I'm sorry?
Not in a courtroom, no, sir.
Not in a courtroom, but have you ever testified as an expert in a case?
Yes.
Okay. Approximately how many times?
10, 12, something like that.
I would move to admit Mr. Settles as an expert in the field of geotechnical engineering based upon his expertise.
All right. Other than the objections previously preserved for the record, is there anything additional from the defense?
Nothing additional.
All right. You may proceed.
Great. Thanks. Mr. Settles, when were you first approached about the case that we're talking about here today?
Roughly mid-2019.
Okay. And who approached you?
J.M. Williams, contractors.
Do you remember if there was a point of contact you were dealing with at J.M. Williams?
I believe it was John Norton,
John Norton. Okay. And who was John Norton, if you knew?
project manager to my recollection.
And when Mr. Norton reached out to you, what was the gist of that outreach, if you will?
They were working on renovating a space.
Overruled to explain the subsequent actions. You may proceed.
They were renovating a space at Piedmont Park for a new restaurant. They had encountered a quote unquote sinkhole or area of subsidence, and I had been requested to take a look at it and see if we could help provide some recommendations for the continuation of construction.
Okay. Do you have any understanding of how that sinkhole was discovered?
I beg your pardon?
Did you have any understanding of how the sinkhole had been uncovered to begin with?
My understanding was, and from what I saw when I visited the site in 2019, it was directly under the building as a large cavern.
Okay. At the time that you were contacted by Mr. Norton in 2019, what was the status of the construction?
It was on hold.
Okay, so no work was being done.
No, sir.
Okay. Did you speak with Mr. Ouellette, who's sitting at the table here, as part of that initial outreach?
I did, yes, sir, at that time during our visit.
Tell me, what was the purpose of that conversation?
Just same purpose of the visit, just to see if we couldn't provide some recommendations on how we could help get construction moving.
Okay. Did you come into it with any sort of preconceived notions of what you were going to decide, recommend?
No, sir.
Okay. At the time you were engaged, were you thinking about you'd end up in a lawsuit years later talking about this?
No, sir.
Okay. What was your understanding from the conversations with Mr. Norton about why you were being asked to provide this analysis?
I don't know if we need that. Maybe we can just kind of get to the
Sure.
heart of what he has to say for us.
Sure. Tell me about the work you did to come up with this analysis you were asked to perform.
As I stated, we visited the site. We reviewed several reports from several different engineers or geologists or otherwise. We summarized that information and we made a recommendation as to shoring up the structure for continuation.
Okay. Do you remember off the top of your head all the different documents you reviewed to get ready for this?
Not off the top of my head, no,
Would it be
sir.
helpful to refresh your memory just to show you a list of the
Sure.
documents you looked at?
Sure.
All right. May I approach?
You may.
Sure.
Handed you, you recognize the document you're looking at there?
Yes, sir.
And does that appear to be a list of the documents that you reviewed to prepare for your analysis that you're talking about today?
Yes, sir.
Okay. Would it be helpful to explain to the jury what you looked at to be able to share with them that document?
Sure.
I'd move to admit the document into evidence. It's Plaintiff's Exhibit 149. Yep. Copy of that. No. Give me a minute.
Yeah, we're going to object to the admission of this exhibit. Hearsay.
That's, well, I mean, yeah, at this point, I don't know who's compiled this list or who's written it. And so I would sustain there unless you want to lay the foundation or just let him cover it verbally, what
Sure.
went into his opinion.
We have a demonstrative, I believe, with the summary of the documents you looked at. Would that be better?
Demonstrative would probably work.
Let's put that up on the screen.
All right, so 149, plaintiff's 149 is being admitted for demonstrative purposes only.
I think it's a different.
It's a different
Oh, this
exhibit.
is a
Your Honor.
different
Yes,
one.
it's a-
Okay.
It's just a demonstrative. Give us 1 sec while we bring that up. Okay. Are you able to look at the screen and
Yes, sir.
see the list of documents that you reviewed in preparing your report?
Yes, sir.
Okay. And does this appear to be a complete and accurate list of the different materials that you reviewed prior to going on site to look at the sinkhole that we're talking about here?
I reviewed everything after I was on site.
Okay, so you went on site and then reviewed these materials?
Correct.
And did these materials factor into the analysis you ultimately provide?
Correct.
Okay. Is that something you typically do when you're doing work for clients? If you've got background documents or other reports, will you typically do that work?
Yes.
Okay. And after looking through the documents, did you have any initial reactions in terms of, takeaways or things that you had questions about?
Biggest takeaway was that we didn't seem to have a cause for the subsidence.
Okay. Now, we'll get to this a little bit later, but obviously one of the documents on this screen that we're looking at is the City of Atlanta memorandum from October 10, 2018. Do you see that?
Yes, sir.
And you just testified that you didn't see a cause for this occurrence. Does that change based upon having reviewed the City of Atlanta memorandum?
No, sir.
Why not?
They didn't isolate a cause.
Okay. Okay. When did you actually go on site and visit the property?
Somewhere in the neighborhood of March, April 2019.
Okay. Was it just you or did you have other people with you?
Just me.
And based upon your site inspection, review of the documents, et cetera, what initial conclusions did you draw?
That there was an area of subsidence. I believe at that point it had been filled in with concrete. And again, we could find no isolated cause or no highlighted cause for the initial subsidence.
And you talked about how in this particular geology in Georgia, it's rare to have a naturally occurring sinkhole. Having visited the site and seen this one, did you have any initial determinations about whether this was naturally occurring versus man-made?
I would have, it was not not naturally occurring.
Okay, and why do you say that?
There's a pipe that runs under the building. There's significant piping in the area. And again, in our geology, it's just a very, 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 very unknown, very unlikely phenomenon.
Okay. Based upon your review of the site, review of the documents, did you have any opinion about whether there could be additional voids or subsidence in the area?
Until we have isolated a cause, that would always be a potential, yes.
And why is that always a potential?
Because we don't know what caused it initially, and therefore we don't know if filling the void solved the problem or not.
If you were able to isolate the cause, would that give you better assurances in terms of being able to determine whether additional voids are existing?
It would certainly give us a better determination as to how to make sure that they didn't exist, yes.
Okay, but you didn't have that, right?
No, sir.
And so in this case, what was your recommendation?
Our recommendation was to utilize grout injections to shore up the foundation to prevent effect from future voids should they occur.
Okay, let's talk a little bit about that. When you talk about grout injections, you were aware that there had already been grout that had been put into this hole by the city of Atlanta, right?
Yes.
So is that what you're talking about? Just more of the same?
No, sir.
Well, why not?
Because again, we don't know what the cause of the sinkhole is, and just filling the hole isn't going to solve the problem necessarily.
Why wouldn't filling in the hole solve the problem?
We don't know where the problem's coming from. Therefore, we don't know whether we're continuing to lose material from below where they filled the hole.
When you talk about grout injections, if it's not the type that the city did of just dumping it into the hole,
No, sir.
what are you talking about? Explain it to the jury if you can.
This is, they utilize 1.5 inch diameter sort of steel water pipe. They drive that into the material with a plugged end. And we would be able to drive that below the existing piping and below the existing material into what we would consider to be natural ground or residual materials. And in those residual materials, we would come back up, creating a matrix between the grout and the soil to fill any voids, stiffen the material, and create a more substantive foundation situation for the building.
Would this be done only in the area where the sinkhole was, or would it be done in other places?
Our recommendation was for the entire structure.
The entire structure?
Yes, sir.
So not just the section we're in, but the entire building?
Yes, sir.
And why did you make that recommendation?
So that should future subsidence occur, the building would be generally unaffected and protected.
Okay. Did you have any concern that there could be subsidence in other parts of the building beyond the one that you were looking at?
With no known cause, that's always going to be a possibility.
Okay. And when you talk about these hollow pipes, explain, if you can, in layman's terms, like how does that work done? What does that look like?
I'm not sure I understand the question.
Pipes are placed in different places along the structure, and then each one gets an injection of grout. Is that right?
Well, they're driven to a terminus depth, and then we raise them at 1 foot intervals, and then you inject grout on 1 foot intervals and allow the grout at very low pressures to combine with and become a matrix with the soil.
Okay.
As you come up, and then you come all the way back up to just under the slab.
And how did you make any recommendation about having somebody present from the city to observe that work?
Yes. As with any situation, we feel like if there is a hole or a leak in the pipe, we don't want to fill that pipe with the grout that we're using to inject into the material.
Did you view that as a possibility here?
I did.
Okay. Well, let me ask this question. Was that work that you recommended, these additional grout injections, was that ever done to your knowledge?
No, sir.
You know why?
No, sir.
Okay. Had that work been done, do you think that you would have been able to determine whether there were additional voids either in that immediate area or within the structure?
I think we would have been able to look at the grout takes and determine whether or not there may have been additional voids, but we also would have the assurance that the foundations were stable and secure should future voids occur.
Okay. Without the work that you were recommending, did you have any opinion about whether you could say the foundation was stable and secure?
Long-term, no.
Why is that?
Because again, we don't have a cause, and therefore we don't know if we've solved the cause.
Okay. Did you think if you had done this additional injection work, it was possible or likely that you would find additional voids based on the geology you've been describing?
It wouldn't surprise me.
Okay. Did you summarize these opinions and this analysis in any sort of report?
The April 4th letter, yes, sir.
Okay, and you provided that to be our guest?
Yes, sir.
Okay. Did you have any opinion about whether this particular sinkhole was a localized situation? In other words, it was just the one?
Generally speaking, if there were a pipe leak, you would have an isolated area.
Okay.
But again, we don't know.
We don't know whether it was a pipe leak or something else.
We don't know.
Okay. I mean, in your experience, having done this for as many projects as you've worked on, what could be some other causes of this particular subsidence, if not the sewer?
We have seen areas where rock has been intermixed in fill and water has gotten into that, washed the soil material out of the rock, and then caused areas of subsidence in the voids that were left. But again, this was seemingly a little bit deeper and not likely the cause here.
Okay. You obviously stated a minute ago that the work that you recommended wasn't performed. Do you have any concerns that that work was never done and that there's no cause that's been identified to date?
Until we have a cause identified, I don't know that you can guarantee that everything's going to be okay forever and ever.
Okay. Well, let me ask you this. This case obviously has been going on a long time. You made your visit in 2019. What about the fact that no further voids or sinkholes have opened up in the last 5 or 6 years? Does that change your opinion?
No, I would just say it hadn't happened yet.
Okay. How long in your experience could it take? I mean, what are we talking about?
Could be years, could be decades. Don't know.
Have you seen examples of that in your experience?
Yes.
Okay.
I mean, there's no telling how long this was forming before it came to the surface and showed.
Okay. Did you have any further communication with Mr. Ouellette after you did this analysis in April of 2019, where you were provided additional information about the status of the property?
I was sent some pictures in 2023 that looked like they were starting to see some areas of subsidence in curb and gutter and pavement areas.
Okay.
Your Honor, there's been no disclosure of any opinions concerning anything after 2019 by this witness.
Your Honor, he provided an affidavit in the case with the exhibits attached to the affidavit. That's simply what I'm referring to.
It's not referenced as a disclosure of an expert opinion.
All right.
It was a court filing.
You can, I mean, I don't have the docket in front of me that you're referring to. Why don't, if you need to create your record to speak more extensively, let's approach, put it on the record, and we'll see where we are.
Based on the information that he received, did he have any further, analysis?
His answer was, is there anything else?
I think, I don't know exactly what he'll say, but I think he'll say he continued to have his concern. It's pretty vague. He said he looked at some additional photos and what was it? I'm gonna ask him.
That's what you're saying you're referring to.
Yes, sir.
Which has caused him concern.
I think I don't think he's gonna say.
That's it, it's only good. Yes, he still is.
Anything that past 2019. Running chair.
Okay. All right, plaintiff may re-ask a question.
Will you approach one more time?
Okay.
Based upon the additional information that you received in 2023 that you just described, did any of your opinions change that you've already testified to today about your opinions of this void?
No, sir.
Okay. Are you aware of the fact that the building that we're talking about here is currently in use by patrons?
Yes, sir.
All right. Does that change your analysis?
No, sir.
Why not?
We still don't have a cause.
Okay. And your testimony about the fact that there still could be sinkholes that could open up in the future, does that stay the same?
It does.
Okay. I have nothing further for this witness.
Well, and with the reservation,
Sorry, give me-
yeah, and then refer to, if you could just show that to opposing counsel, and we'll see where we go from there.
One more question, if you would, Mr. Settles. If the issue that we've been talking about were below the ground, what would you expect to see in your experience?
It will start as smaller areas of depression and then it will grow.
Okay. And how would it grow? How would that manifest in terms of what you're looking?
It depends on the cause. I mean, it could grow linearly, it could grow circularly, just depends on where the material's going to and how we're losing the material.
Thank you.
Judge, we're gonna, with apologies, we're gonna need 1 or 2 minutes. We didn't realize this is gonna be an issue. We're trying to put our hands on it.
All right, well, why don't we just, I'll let you reserve that for redirects, and we'll go from there.
Still morning. Good morning, sir. How are you?
Good, thanks. How are you?
I'm doing well. Thanks for asking. Mr. Settles, you're being paid for your time today to come and testify, correct?
Yes,
And what's your hourly rate?
$450.
Okay. And you've been billing that hourly rate to be our guest for all of your preparation for this trial,
Yes, sir.
all of your time to propose your recommendations for the site?
Yes, sir.
Okay. Let's talk about those recommendations, or I think you call it a proposal. I want to understand because I think what you're suggesting is you're going to look for additional voids by putting grout in the ground. And I understand you're doing that by monitoring the pressure of the grout.
Yes, sir.
Explain to the jury how that works.
The softer the material, the lower the pressure. The tighter the material, the more dense the material, the higher the pressures.
So you could rule out the existence of voids by putting your probe in the ground, and if there's very high pressure, obviously there's hard soil, there's not a void, exactly.
Well, it's not a probe, it's a pipe with a pump and grout, and the grout is creating the pressure.
Okay. And if there is very high pressure, that would confirm to you that there isn't a void that's accepting the grout.
Correct. There would also be very little, if any, grout take at that location.
Sure. If there's high pressure.
Yep.
It's not enough to go in.
Yep.
Okay. And so your proposal back in 2019.
My recommendation.
Recommendation. Is there a distinction between the two?
Well, we don't do the work.
Okay, this would have been done by a contractor.
Correct.
Your recommendation was to put a hole in the community center every 5 to 7 feet square and insert the pipe and perform this injection.
That's correct.
Okay. And I'm not sure I'm fully understanding, but are you telling me that your recommendation is what to do when you don't know the cause?
My recommendation was to shore up the foundation so that we could continue construction in a relatively safe manner, protecting the investments that were being made.
And so you can get comfortable to move forward with construction without knowing the cause of the signal?
If you do substantive remediation, yes.
And that substantive remediation is what you're recommending?
One of the ways, yes.
Okay. And so explain that to me, because what I've been hearing this whole trial is without knowing what the cause is, you can't possibly fix the sinkhole. Can you help me understand that? I'm unclear.
Well, what I've said is that without knowing the cause of the sinkhole, we can't determine whether the fix that was provided solved the problem.
Okay. You can't certify that it solved the problem. You can't say it didn't solve it.
I certainly can't, no.
And so this grout injected with pipe, you can use that to identify the void. That's one thing, right?
You can, it will show the areas where there are voids or whether there are softer materials in particular because of the pressures that we would be monitoring and the grout takes that we would be monitoring. Yes.
So that's one purpose, to identify, right?
Well, the purpose is to shore up the foundation and ensure that the community center is going to stay there like it's supposed to. We can also use that information as we're collecting it to determine whether we have encountered additional voids. And if we have, we could offset that material or offset those injection points to ensure that we've created a safe situation.
I think we're getting to the same point, but I was going to go step by step. If there is a void identified because there is low pressure and the ground is accepting grout, once it stops accepting that grout, you believe you've solved the problem?
Generally speaking, we believe that we have filled the void, yes.
Okay.
And again, you'll see as you're filling the material, you'll see the pressures go from very low to as we're getting pushed back from the grout itself, because we filled the void, the pressures begin to rise.
And so the situation in that location from your engineering perspective has been addressed once you start to see that high pressure and the grout is no longer being accepted.
In theory, yes.
Okay. And that's whether or not you know what caused the hole or not, right?
If we do it correctly, yes.
There was some mention in your testimony. I just want to clear it up because it came up with another witness. You said when you went to the site, you've been to the site one time, right?
That's correct.
6 years ago.
That would be correct.
And when you went to the site, you said the hole had been filled with concrete.
I believe so, yes.
Okay. Did you do any further study to understand whether it was concrete or maybe something else that the hole had been filled with?
I did not.
You didn't think that was important?
No.
That wouldn't have been important to you if it's the same kind of grout you're recommending today?
It wouldn't be the same kind of grout that we're recommending today.
How do you know?
Because the grout that we're recommending is neat and it gets injected as a matrix with the soil. It's not for filling holes.
Oh, I'm talking about the material itself,
Well, the material itself would not have large aggregate in it.
but you don't know what material.
From what I've understood, it's a cellular grout.
Okay. And that's different than concrete. That's all I'm trying.
No, concrete is concrete. Concrete's made of Portland cement or some sort of cementitious material and some sort of aggregate. The aggregate in this case is cellular.
So what's in the hole?
Concrete.
You believe it's concrete?
It is concrete.
Okay. One of the materials that you reviewed that was on the demonstrative was the Palmer Engineering September 2018 report. You recall that, sir?
Vaguely.
You recall that report vaguely, or you recall that it was one of the materials that?
It was one of the materials that was reviewed that hasn't been reviewed in a couple of years.
Exhibit number is that? Palmer's. I've got it. This is plaintiff's 97, which has been admitted. Do you have a copy of it?
Not that
I'm not gonna make it sort.
I don't have any idea, to be honest with you.
Before we get into this, Mr. Settles, you understand that engineers often have to reach conclusions based upon their professional judgment and experience, right?
Correct.
And in your professional judgment and experience, it's the city of Atlanta's 100-year-old sewer that caused the void and loss of soil in question in this case. Right?
In my opinion, there has not been a definitive cause identified.
There has not been a definitive cause. That's not my question, sir. My question is, in your engineering opinion, what caused this void?
In my opinion, it is not a naturally occurring sinkhole, and no demonstrative cause has been presented.
Okay, and it sits immediately on top of a 100-year-old.
That it does.
And it is your conclusion that more likely than not, that 100-year-old sewer.
I would not be surprised if the sewer were the problem.
When you told me at your deposition, you recall giving a deposition recently.
Yes.
Okay, and you were under oath there.
Yes.
Okay. Do you recall telling me at your deposition that it remained your opinion that the void was caused by the city of Atlanta?
I would absolutely believe that it was. Yes.
Okay. And your concerns that you were expressing at your deposition were really limited to the city of Atlanta's sewer assets that I think you told me your concern was another sinkhole could have formed because I think you used the term, these sewer assets were at the end of their useful life.
Yes.
Okay. And there are sewer assets all over this city that are at the end of their useful life. Isn't that correct?
Yes.
Running underneath hundreds, probably thousands of buildings in this city. Right?
Could be. Yes.
Okay. Are you suggesting that all of those buildings should be evacuated or abandoned?
No, sir.
Okay. Let's go back to the Palmer September 18, 2018 report. And is this a document that you reviewed as part of your work in this case, Mr.
Yes,
Settles? Okay. If you look on page 2, there's some discussion of what the city of Atlanta had done back in July of 2018, and there's discussion of a dye test. Do you recall reviewing that?
I do.
Okay. Did you consider that there was information or evidence indicating there was a positive dye test performed by the city of Atlanta in reaching your conclusions you're offering today?
I reviewed this letter. Yes.
Okay. And did you just discount that? I mean, a positive dye test would tell us if it's the sewer that caused this, right?
It would.
Okay. And so why do you still have all these questions?
I don't believe that there was a positive dye test, was there?
You reviewed information that said there was.
That's been a long time ago.
The recommendations that you've called them to insert the pipe through the ground, is there a way I can refer to that without talking about the whole, what do you call that?
Grout injection.
Grout injection, okay. Was the grout injection, I think you testified that recommendation was provided to be our guest.
Correct.
And you said it wasn't done to your knowledge.
That's correct.
You know why not?
I don't.
Okay. You know if Be Our Guest ever asked to do it?
I don't.
Mr. Settles, I think I may have covered this, so apologies. You don't have an opinion whether the repair performed by the city's contractor was proper or not.
They filled the hole. And did they solve the problem? I don't know that we know.
Do you have an opinion that what they did was proper or improper?
I don't have a problem with what they did. I just don't think that we have a definitive cause, and therefore we don't know if it was a solution or a fill.
Okay. And so I think what you're telling us, if I understand you, is there are things we don't know.
That's correct.
You're not telling the jury that there are other sinkholes. You're telling the jury there could be other sinkholes.
That is correct.
And there's no reason those other sinkholes, the only reason you believe that, again, is because of the existence of the old city sewer, right?
That's correct.
Okay. And there's no reason that a sinkhole would be more likely to open up because of that old sewer asset under the building as outside the building, in the park, anywhere else above.
That's correct.
Okay. You could have done, and you would have wanted to have done some of this grout injection in areas outside of the slab, correct?
It would have gone just outside the slab, yes.
Are you aware there was an atrium area of the walker space that was being added as an addition to the community center?
I don't recall that.
To the extent there was a lot of exposed soil, that would have been a good place to start.
Well, the purpose of the grout injection was to shore up the actual structure.
And if there was going to be a structure built on top of exposed earth, that'd be a good
It would have been part of our recommendation, yes.
You testified, Mr. Settles, that you don't think there was a positive dye test because that's what the city's report said, right?
I don't recall. My understanding from review and my recollection is that they did not indicate the sewer was the cause.
And you don't believe or have a lot of trustworthiness of anything that the City of Atlanta Department of Watershed Management says, do you?
Not generally speaking, no.
You view them as untrustworthy.
Not generally speaking, they're not trustworthy, no.
I have nothing further.
All right, redirect.
Briefly, Your Honor.
Do you need to revisit the other issue we flagged, or are we moving on to other things?
I think we're moving on to other things, Your Honor.
All right, understood.
Mr. Settles, you were asked a moment ago about a dye test and whether there was a positive dye test, and there was a reference to it in a report by Mr. Hagberg. Do you remember that?
Yes.
And you said you didn't think there was a positive dye test. Is that right?
I don't recall.
All right. Let me put up on the screen, if I can, already admitted as Plaintiff's Exhibit 109, we can. Take a minute. It'll come up on the screen.
And while that's coming up, I'll just, direction for all counsel. Let's try to avoid just reading things that have already been read to the jury and get right to the question, especially with documents that have already been.
Yes, Your Honor. Just briefly, Mr. Settles, you recognize this as a copy of the City of Atlanta memorandum, and it's got a date on it of October 10, 2018.
Yes.
Is this the City of Atlanta memorandum that you reviewed in preparing your analysis?
Yes.
All right, let me ask you to look at the last paragraph on the first page here. We'll scroll down just a little bit.
Your Honor, this is obviously cumulative.
Well, he can refer to it, read it himself, because we don't have to read it aloud. And then if there's a new question to be asked here or some other area that hasn't been covered, I'll see where the question's going.
Mr. Settles, if you go down to the third to last sentence in that big paragraph, you see the sentence starts similarly. You
Yes.
see that? Would you mind reading that to yourself briefly?
Mhm.
Thank you. You got a chance to read it?
Yes.
Does this refresh your memory about whether you saw a positive dye test or a negative dye test in the City of Atlanta results?
Yes.
What's your recollection?
Their result was negative.
Okay. Do you know where Mr. Hagberg got the information where he said there was a positive test?
I do not.
Okay. Do you know if there are other versions of reports Mr. Hagberg prepared other than the one that you were showed earlier today?
Objection. The one he was shown today is not the one in question.
I'm just asking if he knows if there.
Other than the one you said that he had based his opinion. Maybe rephrase the question.
Sure.
To narrow that down.
You were shown a copy of a Hagberg report from September of 2018. It was put up on the screen a minute ago. And obviously that's one that you looked at in preparing your opinions.
Yes,
I'm just asking if you know if there are any other reports that were prepared by Mr. Hagberg.
yes,
You're aware that there are some.
yes,
You don't recall the contents.
yes.
Mr. Settle, just one more question. If the sinkhole were occurring underneath the foundation of the building, what types of impact would you expect to see on the structure in your experience?
Ultimately, if the foundation system or the slab became undermined, you would see cracking. You would eventually see rotation, and then you would eventually see more severe cracking.
Okay, cracking in the floor?
Cracked floor, walls, foundations themselves, footings.
Nothing further.
Good cross.
Mr. Settles, if we could leave this up, those things you would expect to see over time, cracking, you said rotation, that's something that obviously someone could monitor.
That's correct.
And with respect to this City of Atlanta memorandum that we've talked about ad nauseum now, you see, you were asked if this confirmed your recollection that there was not a positive dye test. That paragraph, Mr. Moy asked you to look at, it starts with the DWM, I think that's Department of Watershed Management, enlisted a third-party contractor to assist with completing the investigation. You see that?
I do.
And do you know, as you sit here today, that that third-party contractor is a company called Ruby Collins?
I don't recall.
Okay. Do you know if the city, not through their contractor, but through their own staff, had performed dye testing prior to the work that the city's contractor did?
I do not.
All right. Can this witness be excused?
Yes, Your Honor.
Thank you, sir. All right, members of the jury, I think counsel timed that perfectly for you. So let's take our afternoon lunch. And I propose we try to, I know traffic got the best of some of us this morning again. I propose we try to gain back some of that time and come back at 12:45 unless there are any strong feelings. We'll see you back at 12:45. Please don't discuss the case with anyone or do any research.
Sure.
All right, starting with the plaintiff, anything to take up before we go into recess?
No, Your Honor.
Anything from the defense? One thing I want to flag, just trying to anticipate here, as it was kind of reserved in the motions in limine. I know there's another plaintiff expert, potentially Mr. Erickson, I believe.
Yes, Your Honor.
And the thing we were flagging was just, it was essentially the 403 cumulative. And so I would check in if they still intending to be called, you know, what new is he bringing to the table at this point now that we've heard from Mr. Settles and we've heard from Mr. Ballard?
Sure.
I mean, that's kind of more of a question.
Well, Mr. Erickson is the structural engineer who came on site, did his analysis, so he's going to limit it to that, focusing on his analysis of the structural recommendations for further shoring.
All right, and that's new ground. That's a different opinion than what Mr. Settles just gave us? Correct,
Your Honor. Mr. Settles was describing grout injections into the soil.
All right, fair enough.
Your Honor, we would like to be heard on that point. We disagree that Mr. Erickson, who we've deposed, is going to offer anything new here. Mr. Erickson is a structural engineer. His report is really about what shoring needs to be done so that the excavation to look is safe. And so I don't see what he adds to the case. I mean,
The shoring that Mr. Settles just described?
No, Your Honor.
shoring that would need to be done. Essentially, he's going to testify that he recommended an alternative
Okay.
to the city of Atlanta, that round thing you've seen. That's shoring, and I just don't see how that matters.
Well, it's an alternative, I suppose, that the jury is determining as a question of fact of what remediation should have been made and which party should have made them. So if he's saying a different alternative and talking about the particulars of that, I think I see that as fair
I
game.
would say it's an additional alternative, Your Honor.
Right. All right. Fair enough. Any other? But I think you can get a sense of, and I thought that last witness was, I think both sides did an excellent job, kind of remained focused on the core issues there.
Great.
So with that, not hearing anything else, we'll see you at did I say one? Sorry, 12:45.
Great. Thank you, Your Honor.
All right, we're in recess.
John is Eric's here, so I think it's appreciated.
Based on what we just heard.
I was in there a lot.
everybody. If we're back on the record, is there anything we need to take up before we bring back the jury from the plaintiff?
No, Your Honor.
From the defense?
No, Your Honor.
We can go ahead and just bring in your next witness as we're bringing in the jury. Good to go. And we could have someone collect all the exhibits, put those back with the stack. Just someone in front of the court reporter in the back.
I just want to introduce myself before the jury comes in. We briefly met at the pretrial
Sure.
conference. My name is Frederick King. I'm
Welcome.
associate with the Trump Pepper.
All right. And I can get another table, like I said, if y'all have expanded, if you need to. Okay. All right.
Mr. Boyd's witness, may I step out for 2 minutes while Mr. Boyd is still here? Is that okay?
So I just speak up a little bit.
Mr. Boyd's witness, is it okay if I step out for about 2 minutes?
Well, I mean, look, my position is if you've got multiple counsel, y'all can be coming and going. I just need one person in the chair, right? So have at it.
I'm here.
Just a body, basically.
Body and a bar card.
I got my bar card. I have that.
Sir, you can just go ahead and come on up here.
Yep.
Thank you, Deputy Scott. Please be seated, everyone. Welcome back. Plaintiff may call the next witness.
Yes, Your Honor. Plaintiffs call Nils Erickson to the stand.
Well, from the testimony, you get a what the truth is what you brought.
I do.
Please state and supposed to have a report.
Sure. Nils Erickson.
Good afternoon, Mr. Erickson.
Good afternoon.
Thanks for being here.
Sure.
Mr. Erickson, what is your job title?
I'm a structural engineer.
And where do you work?
I work at M2 Structural.
How old are you?
I'm sorry.
How old are you?
48 years old.
All right. How long have you been with M2 Structural?
I've been with M2 since 2013.
13. And where is M2 Structural located?
On the west side of Midtown Atlanta.
And tell the jury, if you can, what M2 Structural is, what it does, the types of services it provides.
Sure. We're a consulting structural engineering firm. So essentially we design buildings. We're generally hired by architects. They're our typical clients. An architect will design the aesthetics and the layout and the use of a building. We'll design the elements that support the building against the weight of the building itself, the weight of its occupants, external loads like wind loads, earthquake loads, snow loads, rain loads, things like that.
And how do you go about doing that work that you're describing to make sure the building will support different loads?
So we consult building codes. We use experience to run analysis on the different members that make up a building, vertical members, horizontal members, bracing members, and using material standards, design them to meet or exceed code and perform adequately for their intended use.
Okay. And are you typically engaged by an architect?
That's the typical arrangement, yes.
Okay. Where did you work before you joined M2?
Before M2, I worked for about 9 years up in Connecticut at the DeSalvo Erickson Group. Prior to that, I worked for about 4 years at Pruitt Eberly Stone here in Atlanta, and prior to that, about 3 years at Preston Phillips, also here in Atlanta.
Okay. So how long have you been in this line of work total?
A little over 25 years.
Okay. And where did you get your undergraduate degree?
Georgia Tech.
Georgia Tech. And do you have a master's degree as well?
Yes, I do.
And where is that from?
Also from Georgia Tech.
What is your master's in?
It's a Master's of Science in Civil Engineering.
When did you get that master's?
In 1999.
Do you have any licenses or certifications?
I'm a licensed professional engineer in the state of Georgia, as well as about 20 other states around the country.
Okay. Any other certifications or licenses?
I'm a lead accredited professional. I think that's the only other certification.
Okay. Let's start with the licensing, being a licensed engineer. Can you just explain to the jury the steps you had to go through to obtain that license?
Sure. It starts with education with university. You need at least an undergraduate degree from an accredited engineering university. Then, depending on the degree you get, 3 to 4 years of experience in the field, followed by a written exam.
Okay. And then what about the lead accredited certification?
That was a lot of self-study followed by also an exam, a written exam.
Okay. You said that you're a structural engineer. Within the field of structural engineering, are there different sort of denominations or branches?
Yes, there are.
Explain those to the jury if you can.
Sure. A lot of in the business, we refer to civil engineers along horizontal lines and vertical lines. So vertical lines would be the type of work that I do, designing buildings and those types of structures. The horizontal side of the field designs roadways, bridges, underground utilities. There are also some specialties for subsurface, for soil engineering. It's a pretty broad field.
Okay. And so for purposes of today, you're in the vertical branch.
That's correct.
Okay. Tell us a little bit about the types of projects you've been involved in, just at a high level.
Sure.
Understand.
Our most typical projects are multifamily residential apartment buildings, basically. A lot of wood framing, sometimes concrete and steel framing, supported on various different foundation systems, usually concrete or piles. That would be our most typical project. We also do a lot of steel framed work as well, shopping centers and those types of things.
Okay. Have you worked on restaurant spaces before?
Yes, I have.
Approximately how many?
Oh, roughly 20 to 30 buildings that eventually maybe had a restaurant use.
Okay. Have you served as an expert before?
I have not.
Okay. Is it not something you typically do?
No, it is not.
Okay. Your Honor, subject to the previous ruling, we'd move to admit Mr. Erickson as an expert in the field of structural engineering based upon his background, qualifications, and experience.
All right. And so are there any other objections or issues other than those already reserved for the record?
Nothing additional, Your Honor.
All right. You may proceed.
All right. Let's talk a little bit about the case that we're here for. Do you know the plaintiff in this case, Mr. Ouellette?
Yes, I do.
Be our guest. How do you know Be Our Guest?
So for this project, we were, as is our typical arrangement, we were engaged by an architect, AI3, who was hired by Mr. Ouellette.
Okay. Had you worked with AI3 before?
Yes.
Okay. Approximately how often?
Oh, approximately 20 projects or so prior to this one.
Okay. And what was the scope of the work that you were being engaged for on this project?
So it was a renovation and fit up project. There were two components to it, two restaurant spaces that were being built out in the existing building.
Do you remember the names of the two restaurants? It's okay if you.
Walker's was the name of one of them and Soulshine was the other.
Okay. And if you remember, tell the jury a little bit about what each space sort of required in terms of the work that was going to be done.
Sure. The Walker's space faced Piedmont Road. And there was more work in that space, more structural work in that space. It involved some changes to the building facade, the exterior wall of the building, opening that up to create sort of an inside-outside component. There was a lot of exterior work, some new dining areas outside, a little bit of work having to do with the mechanical systems that were being upgraded. That was the Walker space. The Soulshine space, our scope is much more limited. Again, there was a little bit of work to the exterior facade to make it more open to the park, but fairly limited scope in that space.
Okay. How did you become aware of the sinkhole at issue in this case?
So I got a call or an email from one of the architects at AI3 that said that the contractor had
Runner here, sir.
Is there anything material he's about to disclose? It's just to explain a subsequent action denied, overruled rather.
So the architect received a phone call from the contractor who was working in the space, saw cutting out some portions of the slab, the concrete slab, and those pieces of the slab fell into a hole in the space. And the architect requested that we go out to the site to take a look at it and see what recommendations we have for moving forward with the work in that space.
Okay. Do you remember ballpark when that was?
I believe it was July. I don't remember the date, but July 2018.
Okay. And then what was the architect asking you to do in terms of coming out to the space, and what was your work?
Essentially to recommend next steps. It's not common for the cutting out of a slab to result in those pieces of slab falling into a hole. They were concerned about the stability of the building with the presence of this hole under the slab.
Okay. And what types of recommendations would typically go into addressing that issue if there's concerns about stability of a building?
Well, first off, it would be ensuring the stability, which would typically be achieved with shoring, with additional supports inside the space, if they were necessary, and then the investigation and repair of the issue at hand.
Okay. Did you went on site and visited it? Was that in July of 2018?
Yeah, I believe that was in July. I did visit the site. Yes.
Just briefly describe for the jury what you saw when you got there.
Yeah, so the contractor stopped work when the pieces of slab fell into the hole. So the site, as best I could tell, was the same as when he had stopped work. So there were pieces of concrete slab laying on a hole in the middle of the space.
Could you see down into the hole at that time?
I could not see very much because the pieces of concrete were covering up most of the hole.
Okay. Did you, based on that initial site visit, and we'll get to the actual recommendation you made, but based on that initial site visit, did you have any initial reactions in terms of, the structure and its stability?
At the time I was at the site, I didn't have a lot of background about the building. Like I said before, it's not usual for a fairly simple operation like that to result in concrete falling into a hole. So it was certainly concerning, but I didn't have any information on me at the time to render an opinion.
Okay. Did you end up getting additional information about the building itself?
I did, yes.
What'd you determine?
So we received contract documents, drawings for the original construction of the building, and we were able to see where the structural elements were located: columns, beams, roof framing, and foundations.
And what did those drawings tell you, if anything?
There were two building columns supporting the roof of the building, and their associated foundations that were fairly close to the location of the hole.
Okay. Did you end up summarizing or providing some sort of recommendation of what you thought needed to happen from there?
I did, yes. I wrote a letter report.
Okay. Who were you contracting with to provide that analysis?
I contracted with the contractor.
Who was that?
Norton. I'm sorry, I can't remember the first. Norton.
K.M. Williams, John Norton?
Yeah, John Norton at K.M. Williams, yes.
Did you review any documents in addition to the drawings you mentioned, any other documents that you looked at to try to prepare your recommendation?
A geotechnical engineer had also visited the site a couple of days before I did. I reviewed their report, and that was the basis of my letter report.
Okay. And tell the jury, if you can, at a high level, what recommendations you made based on this work.
Sure. There were basically three recommendations. One was to temporarily shore those two building columns that were closest to the hole to ensure that the space was safe for the next level of investigations that need to happen. And then my second recommendation was a a concurrence with the geotechnical engineer's recommendations, which was to remove the pieces of slab and investigate the soils below, investigate the void, and try and make a determination as to why it happened. And then thirdly, remedy the void, repair whatever it was determined caused the void, and then move forward.
When you talk about shoring, can you just, in layman's terms, what does that mean? Temporary shoring?
Essentially just additional supports. In this case, we had two columns that we wanted to, two vertical columns that we wanted to shore. So it would be bringing in additional columns that would be spread out away from the area where the void was discovered that could support the roof framing that the two columns in question were supporting.
Okay. I'd like to show you what's already been admitted as Exhibit 41, Plaintiff's Exhibit 41. Put it up on the screen for you. Do you recognize this document?
Yes, that's the letter report.
Okay, it is dated, and this is something you prepared, is that right?
Yes,
Dated July 25th, 2018, is that right?
that's correct.
So that's approximately when in relation to when the sinkhole was first discovered?
Maybe about a week later.
Okay. Let me ask you to scroll down if you can. We'll go down to the third paragraph there. It starts with, "It is our recommendation." Take a moment and read that if you can.
There's a box up on the screen. Is it
Oh,
possible?
sorry.
If you just press the button, stay muted.
Okay, got it.
You had a chance to read that?
Yes.
Does that summarize your recommendation about providing additional shoring of the two existing steel columns within Suite A?
Yes.
Okay. And let me ask you to look if we can. We'll go to the sketch you mentioned in that sentence as shown on the attached sketches. I just want to point out the sketches. And I'm going down to what's attached to this report. And it's got a Bates number on it of 3571. Yes. And then it'll need to be tilted. Couple pages down here. There we go. If you can just scroll up a little bit there, Ms. Wilkerson. Thank you. Are you able to see what's on your screen there, Mr. Erickson?
Yes.
Okay. What does that reflect? What are we looking at here?
So this is a sketch of taken from the original drawings for the building. These are the original foundation plans for the building. And I've drawn in the approximate location of the void, of the hole in the space, as well as the two columns I just referred to, the two building columns that are supporting the building roof framing.
Okay. You mind if we blow that up just one more time? Thank you. So it looks like the box that says existing steel columns to be temporarily shored. Do you see that?
Yes,
Those are the columns that were already in the space. Is that
that's
right?
correct.
Okay. And then explain the temporary shoring posts and what they're what they're intended to accomplish?
So the shoring posts, we've proposed locating the shoring posts far enough away from the void location so that they wouldn't put any load on the immediate area of that void in case there were any other loose soils, or if the void was larger than what was presenting itself at the time. So we're locating those shoring posts away from the area of the void, but still within reason to temporarily support the existing building columns.
Okay. Let's go back up to the first page if we can, Ms. Wilkerson. In the first paragraph under the bullet points there that we were just looking at, in the second sentence, you say further and as recommended in the geotechnical field report referenced above. Please scroll down. It says further and as recommended in the geotechnical field report referenced above, additional investigation shall be performed to identify the cause and full extents of the underslab void. What are you recommending there?
Further investigation to determine first how far the void may extend, and then secondly what may have caused it.
Did you have any initial impressions of that issue?
Not initially when I was at the site.
Okay. Let me ask you to look at the last paragraph there on the first page. Given the potential presence of an old sewer line in the building, it's possible that voids exist under other portions of the building slab with the potential to impact other portions of the building, structural, architectural, mechanical, electrical, plumbing, and fire protection systems. Do you see that?
Yes.
What are you saying there?
So in our review of documents that were provided to us after I visited the site, we were given site drawings that showed the building on the land that it's on, as well as utilities on that land. And included in that was a sewer line that ran directly underneath the building.
Okay. And is that the reference to voids exist under other portions of the building slab? Is that due to the sewer line?
Well, no, not necessarily. I mean, it could be the sewer. It could just be from whatever was causing this void. But the fact that there was a void that presented itself means that there is the possibility that it could be present in other areas. The fact that there was a sewer line running directly under the building and directly in the area of this void made that a possible culprit.
And when you say other areas, are you talking about not just in Suite A, which is where the sinkhole was, but in other parts of that building?
Possibly.
Okay. Was that a concern for you?
Well, I recommended it be investigated. So yes, it was a concern.
And who did you provide this memorandum to that we're looking at in Plaintiff's Exhibit 41?
This was provided to the contractor and the architect.
Okay. After this report was provided, do you know what happened next?
I received a report by another engineer a few months later.
And who was that?
That was PEC was the Palmer was the company.
Okay. And did that change any of your recommendations with respect to what we're looking at here in Exhibit 41?
No, it did not.
Why not?
Their recommendations were very similar to the recommendations in my report.
Did you go to the site again after this initial visit in July of 2018?
I visited the site one more time for some work going on in the other space, in the Walker's space.
Okay.
I walked that space with the contractor. I asked him if anything had changed in the Soulshine space, and nothing had changed in that. Nothing had been done in that space at that time.
Do you understand why nothing had been done?
I do not know.
Okay. Was M2 ever engaged to do this temporary shoring work that you recommended in your memo of July 23rd?
As part of our services for this report, we reviewed a shoring submittal that was put together by the contractor.
Okay. Was that work actually done?
Not to my knowledge.
Okay. Okay. Are you aware of the fact that the city of Atlanta came out and did some work and then summarized that effort in a memorandum came out a couple months after this report we're looking at?
Yes,
Did you have a chance to look at the city of Atlanta memorandum?
yes, I did.
And what was your impression or takeaways from that?
The memorandum was an investigation of the existing sewer line, the sewer line that ran under the building.
Okay.
My recommendation was that, again, going back to the vertical construction versus horizontal, I'm not an expert in horizontal construction or subsurface construction. So my recommendation was that that memo be reviewed by an engineer with a lot more experience in that field.
Okay. Were you asked to provide impressions or analysis of City of Atlanta memorandum to Mr. Alette to be our guest?
Yes, we had a conference call.
And when was that conference call?
Oh, gosh.
Ballpark.
October, November of this same year.
After the memorandum?
Yeah.
Okay. And in the wake of that call, did you summarize your impressions or takeaways from the city memorandum?
I did. I wrote an email follow-up after that call.
Would it refresh your recollection if we were able to put that up and show you a copy of that?
Sure.
Okay. I'd like to provide you a copy of Plaintiff's Exhibit 125.
Your Honor, I just want to make clear that it's not being put on the screen.
It's not? I've just got a copy here. You recognize what you're looking at there in Plaintiff's 125?
Yes, I do.
And is this an email you wrote on or around November 5th of 2018?
Yes, it is.
To Mr. Alette in addition to Don Moss and Chris Carfora?
Yes.
Okay. And is this the email you were just describing that sort of summarized your impressions of the City of Atlanta memorandum?
Yes, it is.
Does this refresh your memory of what you were describing?
Yes.
Okay. I'd move to propound Plaintiff's Exhibit 125.
To tender?
Tender.
Okay. All right.
Your Honor, it's still hearsay.
If it's being tendered for the truth of the matter,
It's not, Your Honor. We're actually propounding it just to get his reactions to it.
Your Honor, may we approach?
yeah.
Yeah. Since the reaction being because it's a real time. Well, pressure.
Mr. Erickson, does the document I presented in front of you refresh your recollection of your impressions or takeaways from the City of Atlanta memorandum?
Yes, it does.
And at a high level, walk us through what those impressions were.
Impressions were that the memo did not provide any indication as to whether or not the temporary shoring we've recommended was installed.
Okay. So to your knowledge, based on the memorandum, there's no indication it had been, right?
There was no indication that it had been.
Okay.
That's correct. The memo described some testing that was done of the sewer line itself, and then it described material, that flowable fill, concrete material was placed in the hole to fill in the void.
Okay. Did it say anything about the type of, in terms of where the grout was placed, the fill that you're describing?
Not specifically, no.
Okay. Do you recall if the memorandum had any indication of what the cause of the void was?
It did not, as I recall.
Okay. Do you know whether a cause of this void or sinkhole was ever discovered or identified?
Not to my knowledge.
Do you know if the sinkhole was repaired?
The memo described grout, a flowable fill grout being poured into the hole.
Okay. And that was the extent of what you knew had been done, is that right?
That's the extent of what I'm aware of, yes.
Okay. You'd mentioned that you had gotten a report. Well, I think you'd been engaged with J.M. Norton, and were you familiar with a company named Piedmont Geotechnical?
Yes.
And what do they do?
They're a geotechnical engineer.
Okay. Did you read any recommendations or that they made in terms of what needed to be done with this issue?
They visited the site and prepared a memorandum just before I visited the site, and their recommendations were very similar to mine. In fact, I referenced their recommendations in my report to further the investigation of the soils in the void area.
Further the investigation of the soils and?
In the void area.
In the void area. Did you provide your recommendations that we've been talking about today for temporary shoring to my client, Mr. Allett?
I provided them to my client, AI3.
Okay. And do you know if they were passed along to Mr. Allett?
I don't know.
Okay. Do you know if they were passed along to the Piedmont Park Conservancy?
I do not know.
Okay. Was this build out ever completed?
No, I don't believe so.
Okay. And so your firm didn't do any further work on the structural engagement that you'd started on, is that?
No, we did no further work after this.
Do you know why that was?
I know that the contractor left the project not too long after this time frame.
Do you know why?
I do not know.
Objection, Your Honor. Speculation, move to strike.
He just said he doesn't know.
David, no.
Moot. Overruled. All right.
Nothing further this time.
All right. Cross-examination.
Good afternoon, Mr. Erickson. Good afternoon, ladies and gentlemen of the jury. My name is Frederick King. I'm a lawyer with Piedmont Park Conservancy. Mr. Erickson, thank you for being here today.
Sure.
I'm going to be asking you some questions. Are you ready to proceed?
Yes.
All right, Your Honor, may I proceed?
You may.
Thanks. Mr. Erickson, I want to make sure we're very clear about the opinions you are not here to give the jury. So let's start there. First, you don't have any opinions regarding the safety of the community center as it stands today, correct?
I have opinions regarding the safety of the community center.
So your testimony today is you do have opinions about the safety of the community center as it stands today.
I'm sorry, could you ask that question again?
Sure. I just wanted to know, do you have opinions today about the safety of the community center as it stands today?
Yes.
Okay. You're aware you were deposed late last year by us?
Yes.
Okay. I'm going to hand you a copy of your deposition transcript. And counsel, do you have a copy?
I'd like it.
What we can do is, this is a copy of your deposition transcript. Do you recognize this?
Yes.
Okay. You can follow along with me as I read on page 62, line 6. Let me know once you're there.
Yes, I'm there.
Okay. I read, all right, so you are not going to be providing any opinion regarding the safety of the community center as it stands today. after the repair that's been performed by the City of Atlanta, Ruby Collins. Answer, that is a correct statement. Did I read that correctly?
You read that correctly.
Okay, thank you. You can just set that aside for now. And to clarify, you're not telling the jury that the building is not safe.
I am not telling the jury that the building is not safe. That's correct.
Okay. And you do not have an opinion about the adequacy of the repair of the void or sinkhole, however it's been termed, correct?
I do not have an opinion on the adequacy of the repair of the sinkhole.
Okay. Mr. Erickson, I think we talked about this, or this was brought up on direct, but you're a structural engineer?
Yes,
Okay. You haven't done any research into naturally forming sinkholes, right?
I have not.
Okay. Or of non-naturally forming voids? I know some people dispute between the difference.
Research on that matter?
Yeah, have you done any research into non-naturally forming voids or man-made involved voids?
No, I have not performed research on that.
And you don't have any specialized training or certifications into voids or sinkholes?
No, I do not.
Okay. Now, this was mentioned on direct. You wrote a report in this case in July 2018, right?
That's correct.
Okay. You talked a bit to the jury about that, so let's bring that up. And Alex, could you bring up Plaintiff's Exhibit 41? Oh, sorry. Looks like we're not connected to the Zoom or allowed to share right now.
All right, we just need a host name.
Alex Martinez.
All right, if we get Mr. Martinez added back to as a co-host.
Like Ms. Sue has stepped out for a second.
She
Sorry.
hears us.
Oh, okay.
Okay.
All right, looks like you're.
You want to stay home?
Okay.
Okay. Thank you then. Okay, so we got Plaintiff's Exhibit 41. This is your report you wrote in July 2018.
Yes, that's correct.
Okay. And Alex, let's move over to page 3. All right. Mr. Erickson, this is a map at the community center, right?
Yes, a site plan. Mhm.
And these red shapes and lines on the map, those are your additions to it, right?
Yes,
Okay. I see in the middle of the page, it looks kind of like a cloud. Do you see that?
yes,
Okay, and that's right around the old rock sewer as shown on city records. You see that?
yes,
Okay, that's your notes on top of this map.
yes. The
Okay.
red notes are my notes. Mhm.
Now, you didn't know if it was the most likely cause or definitely the cause, but you did think the sewer was a possible cause.
That's correct.
Okay. And at the time that you authored this report back in July 2018, you had no reason to suspect any other causes other than the City of Atlanta sewer, right?
I wouldn't say that's necessarily true.
Okay. Well, your testimony today is you had reason to suspect there were other possible causes.
I had reason to suspect that the sewer could be a cause or there could be other causes.
Okay. I've got your other deposition in this case. You're aware you were deposed back in 2022?
Yes,
Okay. Counsel, same thing. There you go. Mr. Erickson, I'll hand you your other deposition from 2022. Do you recognize that?
yes, I do.
You can follow along with me again as I read. We're going to page 50, so let me know when you're there.
Okay.
All right. And starting at the very bottom of page 50, question, at the time that you authored this report, did you suspect anything else as a potential cause of the void? Answer, I had no reason to suspect any other causes. Did I read that correctly?
You read that correctly, yes.
Okay. And you can set that aside for now too. Thanks. And just so we're clear on this map, you didn't note any other possible causes.
On the drawing that's on the screen right now? I did not on the drawing that's on the screen right
Yep.
now. Yeah.
And you mentioned 2 columns supporting the roof framing on direct. You remember that?
Yes,
Okay. I just want to confirm that roof framing was mansard roof framing, correct?
it was a mansard roof. That's correct.
Thanks. And I don't think we really need to talk about this much. Just want to clarify that you mentioned on direct something about additional voids. I just want to be clear, when you inspected the community center back in July 2018, You were not aware of any evidence of additional voids under the community center, correct?
That's correct.
Okay. You didn't do any testing or inspections to see if it was anything more than just possible?
We did not perform any testing or inspections.
You didn't have any information whatsoever that there are currently voids or sinkholes underneath the community center, correct?
I do not.
Okay. And you mentioned something about sewer lines. I just want to be clear that there are sewer lines all over the city of Atlanta, correct?
Yes, there are.
Okay. And your testimony was that these possible voids were related to the sewer lines. Throughout the entire city of Atlanta, possible voids could exist because of the old sewer system?
Objection mischaracterized.
Overall,
I can ask
answer the question if you remember.
The, I'm sorry. Yeah, could you
Yeah,
ask
I
the
can ask
question?
you again, no problem. So throughout the entire city of Atlanta, it's possible that there are voids all over the city related to the old sewer system?
Yes, that's possible.
Okay. And Mr. Erickson, just to be clear, you would absolutely agree that it is also possible that there are no other voids underneath the community center, correct?
That is possible.
Okay. And there are things you could observe that might clue you in onto whether those voids exist?
Yes.
Okay. For example, you could see a settled slab or a crack in the wall, right?
Those would be signs that there's been movement in the building.
Okay. And when you went out to the site in July and August 2018, you didn't see any signs like that of any other voids existing, right?
We were really only, we only inspected the soul shine space,
Okay.
the space where the void was, that presented itself was located.
And you went out to the Walker space as well in August 2018, correct?
Yes.
Okay. You didn't see any other signs of voids existing in the Walker space?
Well, in the Walker space, a large portion of the slab had been removed for work that was going on. So that there wasn't really much to look at as that would show any signs of movement.
Sure. I just want to clarify, you didn't see any evidence like that?
They wouldn't have presented themselves, but no, nothing was observed in that space.
Okay. And you've been dealing with an underslab void in another case, in a new construction up in North Carolina recently, right?
Yes, that's correct.
Okay. And the repair investigation is still underway?
It is still underway.
When considering the repairs to this underslab void up in North Carolina, one of the possible repairs was to monitor for settlement, right?
That was one of the strategies, correct?
Right.
Yes.
Installing strain gauges and settlement monitors to see if there's any further movement in the future, right?
They were installed in this case on this other project. Yes.
Okay. And that settlement monitoring is okay because some signs of soil erosion are able to be seen with settlement monitoring, right?
I'm sorry, could you say that again?
Sure. The reason that settlement monitoring was one possible repair is because signs of soil erosion are able to be monitored with settlement monitoring.
Well, the monitoring wouldn't be a repair. It would be an ongoing part of the investigation.
Right.
It would be a
After
data point to use to determine the cause.
Sure. So after the void is filled, you monitor for settlement.
That could be a strategy to monitor movement of a building.
Okay. Now, the jury may have heard when you came out to the site in July and August of 2018, something about safety. I just want to be clear, you didn't have an opinion back then as to whether it was safe to continue construction at the community center, right?
Our recommendation was to install shoring to preserve the safety of the building and then conduct an investigation.
But you weren't engaged to opine on whether it was safe to continue construction?
No, I was not.
Okay. The scope of your services wasn't involving, whether it's safe to continue construction.
I didn't quite hear the grounds.
Cumulative.
Okay. All right. You can answer this question as you understand it, and then let's get to the actual question that matters.
Yes.
I can re-ask if you didn't remember.
Yeah, could you
Sure. The scope of your services wasn't really to determine the safety of the construction work?
Same objection.
All right.
Asked and answered.
If you've got a follow-up, then you can do it, but I think he's already covered a lot of this.
Sure. And in 2018, I just want to clarify, you never told Be Our Guest or Ms. Drolet that it was not safe to continue construction work.
Not specifically, not in those words, no.
Okay. And you mentioned about the temporary shoring. That was just for while an investigation and repair was conducted, correct?
That's correct.
Okay. Let's move on. Mr. Erickson, I just want to clarify, there's been some discussion about structural versus geotechnical engineers. You agree that sometimes the roles of geotechnical and structural engineers can overlap, right?
They're very intertwined, yes.
Okay. And you would agree that there's times when determining the proper repair for a sinkhole can fall upon the role of a structural engineer?
Yes, portions of that, and yes.
Okay. And assuming an engineer has the appropriate qualifications and expertise, they can act outside of their designated specialty, right?
If they have the experience and qualifications.
Sure.
Correct, yes.
And I just want to be clear, you don't have any opinions about the Conservancy's structural engineer, Mr. Hagberg, right?
No, I do not.
Okay. Mr. Erickson, your primary opinion in this case is essentially about installing temporary shoring back in July 2018. Is that right?
Again, there were multiple parts to our recommendation, and one was to install the temporary shoring. One was to conduct an investigation, and the third was to repair based on the findings of that investigation.
Sure. So the jury's heard about this temporary shoring. Just to be clear, you've made that recommendation before the city got out to investigate and repair the void, correct?
That's correct.
Okay. And you'd agree once that investigation and repair was complete, that temporary shoring that was unnecessary?
Yes, if the investigation was thorough and the repair was thorough, then yeah, the shoring would not be necessary anymore.
Okay. So if the void had been adequately repaired, the temporary shoring that you recommended, that would no longer be needed?
That's correct.
Okay. And Mr. Erickson, just so we're all clear here, you have no opinions whatsoever related to the community center as it stands today, correct?
That's correct.
Okay. Thank you, Your Honor. No further questions.
Redirect.
You were just asked whether you were engaged to opine whether the building is safe, right?
Yes.
You weren't engaged as an expert in this case, as an expert witness for this litigation, right?
No, I was not.
In fact, you were engaged as a structural engineer to provide recommendations about how to shore up the building from collapse, right?
Yes.
Okay, and that's what you did, right?
Your Honor, I'm not sure this is inside the scope of his opinions that he's been disclosed for.
All right, overruled. You can answer if you recall the question.
That's what you did, right?
I'm sorry, what was the question?
Provided a recommendation about temporary shoring of the building to prevent collapse.
Yes, I did.
Okay. You were asked a moment ago if the city of Atlanta work was sufficient that the temporary shoring was no longer needed, right?
Yes.
Do you recall having an opinion about that after you got the city of Atlanta memorandum back in November of 2018?
I did not have enough backup information to render an opinion based on strictly that report.
In fact, when you got that report, your advice to the client was?
Objection, Your Honor. He's just reading the hearsay into the record.
All right, and is there a non-hearsay purpose that the statement he conveyed to a client outside of court is admissible?
Well, I'm trying to redirect on the fact that he was asked whether he had any, he basically had, on cross-examination, counsel had tried to establish that once the city filled the hole, he didn't recommend further temporary shoring, and that's inaccurate. I'm trying to correct that.
Your Honor, I'm sorry.
Or he had an opinion after reading the memo, right?
Correct.
Okay,
The
then I
suggestion
think
on
let's
cross was to
focus
the
on what his opinion was after reading the memo.
After reading the city of Atlanta memorandum, did you have an opinion about whether temporary shoring was still needed?
I don't recall. In my response, I clarified that the repair had not been documented. The repair had not been, there was not enough backup information with the memorandum to determine whether or not the repair was thorough, and that the shoring had not been installed prior to this work being done.
And so did you still think it was an open question whether the shoring was needed?
It would still be an open question without that backup information.
Okay. You were asked during cross-examination if you saw any cracks in the building when you went there in 2018, right?
Yes,
Do you know if there are any cracks in the building as we sit here today?
I do not know.
If there were any, would that give you concern?
It would be indicative of potential building movement.
Okay. Nothing further.
Recross.
Yes, Your Honor. All right, so back on this October 2018 memo. Mr. Erickson, you reviewed the memo, but you did not review the documents related to the City of Atlanta's repair of the void, correct?
There were some documents attached to that memorandum.
Okay, but
I'm not sure exactly what you're referring to.
yeah, there are documents that support the repair. You did not review the documents of the repair, correct?
That's correct.
Okay. And you have no knowledge of what other professionals were involved in this City of Atlanta repair?
I have
correct?
no knowledge of the other professionals that were involved.
Okay. And you haven't investigated the community center after the void was filled, correct?
No, I have not.
Okay. Have you been out to the community center since the void was filled?
No, I have not.
Okay. Thank you, Your Honor. No further questions.
All right. Can this witness be excused? All right. Thank you, sir. You can step down.
Thank you.
All right. Plaintiff may call their next witness.
Yes, Your Honor.
Gina Miller.
Thanks.
Not on Mr. Abed or Mr. Peak.
Not at the present time.
Your Honor, can we just have a few minutes? We were told the order of witnesses and Ms. Miller was not supposed to be next. We just need a moment to just get ourselves organized here.
Yeah, you can take a minute and place here, and we'll begin testimony shortly. You can have Ms. Miller come on in.
Yes, Your Honor.
My name is Gina Miller, Ginamiller.
All right, we'll just hold in place for a minute,
Yes, Your Honor.
and then you can ask your first question in about a minute.
Sure.
All right, you can proceed, sir.
Good afternoon.
Good afternoon.
Just so we can all make sure we heard you the first time, please introduce yourself to the jury.
Hello, my name's Gina Miller.
Ms. Miller, please describe, where do you work?
I work at Bennett Thrasher, a full-service accounting firm.
Okay. And tell the jury a little bit about your educational background. Let's start with college. Where'd you go to college?
So my undergraduate degree is from Truman State University in Missouri. I graduated in 1989. From there, I also have an MBA from Southern Illinois University.
Okay. If you don't mind maybe pulling the microphone just a little bit closer. Can hear you. What certifications do you have, Ms. Miller?
I'm a CPA, a certified public accountant. I sat for and passed the exam in May of 1989. From there, I went to, well, in addition to my CPA, I also have designations in the business appraisal field, both in ASA and in ABV.
Okay. What is ABV and ASA?
So ASA is an accredited senior appraiser with the American Society of Appraisers, and the ABV is an accredited business valuation through the AICPA.
Any other certifications or licenses that you have?
I'm also certified in financial forensics, and I'm a certified exit planning advisor. I think that's it.
Okay, that's plenty. Tell us what you had to, the work that you had to undergo to complete a CPA.
So the CPA is quite challenging. I studied for a full semester just for the CPA exam, sat and passed it. It's a three-day exam. At the time, it was all given just at one time. Passed that, and then 2 years of experience to be licensed as a CPA.
Okay, and then what about to be licensed as an appraiser?
So to get those designations, specifically the ASA, I participated in 4 weekends, so 3-day classes, each of 4 on 4 weekends, and there was an exam to follow for each.
Okay, and then in addition to obviously the work you've described, do you have to complete additional continuing education to maintain those certifications?
I do. I have to have at least 80 credit hours every 2 years to maintain my CPA license. And for the ASA designation, I have to have 100 credit hours over 5 years. So continuously learning.
Okay. Do you also attend conferences, industry events, things like that?
I do. I like to stay abreast of what's going on and mix with my peers.
Have you ever presented at such conferences?
I have. Most of my presentations have been on business valuation and exit planning.
Okay. Tell us a little bit about your professional experience. How long have you been doing what you do?
So I started off as an auditor right out of school, and I achieved my 2 years of experience to finish out my CPA license. From there, I went into industry. I worked at a large retailer that was based in St. Louis, Missouri, and I worked in various departments there, financial reporting, treasury, capital planning, and executive compensation I was there a little over 6 years. I decided that it would be better for me to go back to client work. I really enjoyed those relationships and started business valuation back in 1997, so almost 30 years ago.
Okay. And when did you join Bennett Thrasher?
I joined Bennett Thrasher in 2014, so a little over 10 years ago.
Okay. What was your title when you joined?
I joined as a director, and then from there was promoted to partner, and that was in 2018.
Okay. And are you within a particular division at Bennett Thrasher?
Yes, I lead our business valuation group, which is part of our disputes, valuations, and forensics group. My team has 18 professionals on it.
Okay. And at a high level, tell the jury the type of work that you do.
Sure. So what I do is value businesses that are not publicly traded. So you don't necessarily know the value of the business. You can't look to the stock market. The reason I value businesses is because there may be a marital dispute or a partner dispute where they might want to buy each other out. Some of the work I do is for tax purposes.
Okay. What types of tax valuations would you do?
I'm sorry.
When would you need to be providing a tax valuation, for example?
Sure. So a lot of people are doing estate planning, and if they own a large business or a large interest in a business, then they might want to put that interest into a trust, or they might want to gift some to the next generation as they come into the business. So those would be some common reasons to have a business valuation for tax purposes.
And when we talk to the jury about valuing an interest, can you sort of explain that in a way that we can all understand?
Yes. So think of it as your house. Your house may be valued, we'll say $500,000, but you might also have a mortgage on your house for $300,000. I would be valuing, the equity. So the equity you have in your house is $200,000. Similarly for businesses, we value the company as a whole and then deduct the debt to determine what the equity interest is.
Okay. Now, in this case, and we'll talk about this today, you weren't really providing a valuation of these businesses. You were providing more of a projection of future losses. Is that right?
That's correct.
Okay. Is there any sort of common theme between those two?
There are a lot of similarities. So I have prepared quite a few lost profits analyses over the years that often comes hand in hand with a business valuation expert's work. The common part is one of the methods to value a business is what we call a discounted cash flow analysis. That's the same methodology I use in our lost profits. So it's what those cash flows might look like in the future and then discounted to a present value, depending upon the risk that's involved.
Explain when you mean discounted to a present value. How do you run that calculation?
Yes. So in a discounted cash flow analysis, we might have multiple years, typically multiple years of cash flows that we're looking at. This is really your revenue less your expenses and maybe some other cash flow items that to get down to kind of a net cash flow number. And we would have that for year over year over year. And we wouldn't want to just add those together because a dollar today is worth more than a dollar down the road. So we discount that to a present value. We say, today might be worth, that dollar's worth a dollar, but a dollar next year might only be worth 90 cents on the dollar, and a dollar the following year may only be worth 80 cents on the dollar. And so bringing it to present value would give you an idea of what that's worth today.
Okay, thank you. You mentioned that you do both business valuations and lost profits analyses. You've done lost profits analyses before, right?
That's correct.
What is the breakdown between the two in terms of your work?
By far, the bulk of my work is business valuation because we do that for a variety of purposes. But I have probably been an expert in about a dozen or so where we've used lost profits.
Okay. Have you ever done a analysis similar to what you've been asked to do here in this case?
Yes, this is very similar to the other cases that I've worked on.
Tell us a little bit about some of those examples.
So I've prepared a similar valuation, or I'm sorry, a similar lost profits analysis for a land developer that was recent, testified within the past year on that one, so it's top of mind. Have prepared lost profits in situations where there has been a trade secret stolen and somebody else profited off of a trade secret even though they didn't have the rights to it. So I've had a few cases like that. Those are a few examples.
Have you ever done a work, either business valuation or lost profits analysis in the restaurant industry?
Oh, yes. We typically, we do, our analyses are across a wide range of industries. I think I've hit most industries at this point in my career, but restaurants is something that we do a lot of business valuations because we have a really large hospitality group at our firm, and so we tend to get a lot of clients that way.
Why would a restaurant want to do a business valuation? Maybe give us an example of why that might be helpful to a restaurant or a business.
Well, one case stands out, and that is a partner dispute. They both owned restaurants in this, it was a restaurant group of about 10 restaurants, if I remember correctly. And the two partners, they just didn't see the path forward together. And so one was going to buy the other one out. And that was why they needed a business valuation.
Okay. How many times have you testified or, well, let me start. How many times have you served as an expert witness in a lawsuit?
I've served as an expert probably 12 to 15 times. I have testified in five different matters.
Okay. Is that your full-time job? Are you a hired expert and that's all you do?
Oh, no,
Okay.
no.
What would you consider to be your primary job?
Primary job is business valuation.
And is that why you were initially engaged in this case?
Yes, not to prepare a valuation, but because I had worked with Mr. Dooley previously.
Okay. We would move to admit Ms. Miller as an expert based upon her experience, education, and background. She's qualified to render a financial opinion here.
All right, other than any other objections previously preserved, is there anything else from the defense?
None in addition to what's already been preserved in the motion of limine, Your Honor.
All right, you may proceed.
Thank you, Your Honor. You mentioned that you were approached by Mr. Dooley. Who is Mr. Dooley?
Mr. Dooley is one of the owners of Be Our Guest.
Okay. And what did Mr. Dooley approach you about?
Mr. Dooley called me in late December of, I think it was 2021, to ask or to tell me just a little bit that he and his partner were in a disagreement. So they were both owners of Be Our Guest. They were hoping to open some restaurants, but there was a problem with opening the restaurants, and they were in a disagreement with their potential landlord.
Did he identify the partner you just described, either at that time, or have you come to know who that partner was?
Yes, Catherine Drillette.
Okay, is that who's sitting here at the table with me?
Yes.
Okay. And you said you'd done work for Mr. Dooley before?
Yes, it was years prior. There was a company that he needed a business valuation for.
Okay. You said that there was a dispute with the landlord. Did you come to learn who the landlord was in this case?
Yes, my understanding is that it's the Piedmont Park Conservancy.
Okay. And did Mr. Dooley tell you anything else about the case and what was going on at the time?
Objection, hearsay, Your Honor.
Maybe you can show if this is just to see where it went from there, or?
Sure.
Okay.
I can rephrase. Did you have any understanding in terms of the status of the construction work at the time that you were engaged?
I learned through the process of gathering information after we were engaged that I learned that, yes, that they were building out the restaurants and there was a sinkhole and they weren't able to continue building out the restaurants because there was, because of that sinkhole. And so their bank wouldn't lend them the money to continue the construction. And I think that just ensued into a squabble over the lease.
Okay. And when you were engaged to do this work, how did you decide that a lost profits analysis is what you were going to do?
So there are a few things that we consider in determining what type of analysis. A lost profits is appropriate when there's a finite period of time. I guess the other option could have been a business valuation, but that assumes that it's for an indefinite period of time, like a total loss. And this, because we had a contract, which is the lease, we had a finite period of time in order to determine what the lost profits were.
And just to state the obvious, lost profits is the profit that the business would have made had it not been shut down. Is that fair?
That's correct.
Okay. Give us an example that the jury can understand, if you will.
Of lost profits?
Just a hypothetical.
Sure. So say that you owned a business, say that that business, maybe it was a Chick-fil-A franchise, and I have no idea what the numbers are, but say that there were revenues every month of $150,000, and you had costs, the cost of the inventory or the cost of the paying your employees, and so your profits were maybe $50,000 a month. And so if for any reason that business was interrupted, there was some reason that it couldn't continue, we could look at that monthly profit going forward of $50,000 per month for the period of time. Maybe it's a 1-year lease or franchise agreements. And we could use that information then to determine the profits that were lost, the profits that you as a business owner missed out on.
Thank you. What types of methods would someone in your field use in trying to run a lost profits calculation?
Well, there are really two main methods of preparing a lost profits analysis. The first is called a before and after. So in the case of your Chick-fil-A franchise, we assumed that it was up and running for a few months, and then it stopped. And so we could use the before and after to calculate what had been going on, and then apply it to what the future what the expectations were. So your future expectations based on what your history was. And that's the before and after method. There's also a method called the yardstick. Some people refer to it as a benchmark, where you take another company that's very similar. Again, this is for a company that doesn't have a history, that just was brand new, that was starting up. We couldn't tell exactly what that company would do, but we have this other company that's very similar. It's our benchmark or our yardstick to say, well, this company, so say if we go back to the Chick-fil-A franchise, maybe you were a franchisee with 2 stores. One never opened, but you had success with the other one that you had been operating. If you because you didn't have a history with the one that shut down, you could use the one that was operating and say, oh, well, they were always earning $50,000 a month. Therefore, this Chick-fil-A franchise or this Chick-fil-A location is very similar to that. So it would probably have earned $50,000 a month. It's very simplistic, but that's what we call the yardstick method.
Okay. And which method did you end up using in this particular case?
In this one, we chose the yardstick method.
And why is that?
Because the 2 restaurants that were supposed to go into that space didn't have any operating history. But yet we had a very good benchmark to use. The Nook, which was also owned and operated by the same people, to take a look at that business. There were a lot of similarities between the 2 businesses, and to use that business as an indication of what kind of profits the new restaurants could have.
And what types of information would you need to look at in using the benchmark or the yardstick? What types of information would you need to make sure that you were being reasonable in projecting out for the new business?
So looking at the projections for the new business, there were a few things we did. When the projections were given to us, we had a conversation with Mr. Roulette about how these were prepared. When we are preparing an analysis, especially for litigation purposes, we prefer not to use projections that were developed for the litigation purpose. As you can understand, people may not have a lot of faith in those. So we asked for the ones that were prepared in what we call an ordinary course of business. In this case, the projections were prepared for their lender in order to borrow the money to build out the restaurants. And then also, we learned that the projections were shared with the potential landlord, with Piedmont Park Conservancy. So we know that because they were shared with these 2 parties, that each of them had to have vetted the projections as well.
Your Honor, this calls for speculation. Please move to strike.
All right, Mr. Moore.
Why was it, did you have any understanding about the projections that have been prepared for the lender in terms of whether the lender ultimately provided a loan based upon those projections?
I understand that the lender.
I renew my request to strike any testimony the witness has that these projections were somehow vetted by the Conservancy. That's speculation.
That wasn't my question.
Yeah, that's not how I heard it either.
I understand, Your Honor, but she had testified to that. That's why I objected and I asked for it to be stricken.
All right. To that extent, members of the jury, disregard the previous response. I charge you. Mr. Moore, if you could re-ask the question, we'll just make sure we're all on the same page of where we're
Sure. These projections that were given to you by Be Our Guest for this new business, was it your understanding those projections had also been provided to a lender, in this case, Atlantic Capital?
Yes, that's my understanding.
And do you know if the lender provided funding or a loan to Be Our Guest after receiving those projections?
Yes, my understanding is that Be Our Guest had alone with that bank.
And based upon your experience in the industry, did you draw any inferences about whether those projections were reasonable?
Objection, Your Honor, as to inferences drawn to the reasonableness of the projections as to the lenders.
All right, overruled. If you remember the question, you can respond.
Yes, when we work with banks, we understand that they do vet the projections. It's very important for a bank to understand that they can get paid back. And so they would definitely look at the projections.
It was your understanding that that happened here?
Yes,
Okay. And so the projections you said were not for litigation, but were prepared in the ordinary course of business, right?
that's correct.
Okay. In addition to looking at these projections, which we'll put up in a moment here, what other data points or documentation did you look at, for example, from the Nook?
We looked at the historical performance of, I think it was about 10 years historical performance with the Nook, understood what their revenue and expenses were, and analyzed that as part of our vetting process for the projections. We also looked at data, industry data information that was available. We, as a firm, subscribe to quite a few databases that have industry information.
And what types of industry information at a high level would you be looking at to vet these numbers?
There's a wide variety of information from, growth in the industry to earnings margins. In this particular case, we looked at some information that we didn't have from looking at the Nook's financials, and that is really some balance sheet items that we ended up using industry data for.
Okay. Did you look at income statements?
Yes.
What is an income statement?
So an income statement is a statement that historically shows the amount of revenue less the expenses. So in the Chick-fil-A example, it is the amount of revenue that is brought in from sales of chicken biscuits. It's the cost of the chicken biscuits, and then also the cost of renting the location, paying the employees, et cetera.
Okay. Your Honor, may we approach the bench?
Sure.
Sorry about that, Ms. Miller. Never a dull moment. So you mentioned income statements. In this case, did you look at income statements for the Nook?
Yes, we did.
Okay. And did you vet those income statements against the industry data and other metrics you've described?
Yes.
Okay. You've talked, we obviously, in your example you gave of the Chick-fil-A, that was an easy one because you had a Chick-fil-A franchise, or two Chick-fil-A franchises. So you could look at the other one as a sort of a yardstick for the one that didn't open, right?
Yes.
Here, you're using the Nook as a yardstick. how did you become comfortable with feeling like the Nook was a reasonable yardstick or benchmark for the new business?
So in my work, I'm often looking at comparable companies. It's something we do for business valuations as well. And sometimes it's really hard to get a comparable business. But in this case, because there was the Nook, owned by the same people, managed by Mr. Lett, similar size, similar location, similar enough menu where it is, food and alcohol. It's not like a pancake house. I think those were the key issues that we honed in on, as this is a very similar business.
Okay. And if we can, I'm going to draw your attention to to Defendant's Exhibit 28. Before we put it up on the screen, is there a way to show it just to her? Maybe not. Yeah, maybe. Any objection?
There's no objection.
Okay, we move to tender PPC Exhibit 28, Defendant's Exhibit 28.
Defense 28 is admitted.
Okay, can we put that up on the screen? Take a moment. Okay. Take a moment, Ms. Miller, if you would. Do you recognize what's been put up on your screen as Defendant's Exhibit 28?
I recognize that these appear to be the projections that we used for the Walker's restaurant.
Okay, and I'll represent to you that these actually had columns that reflected monthly projections.
Yes,
We've hidden those columns just to reflect the annual. So nothing's been altered. We just basically shrunk the spreadsheet in a way that you could see it. That makes sense?
I understand. Yes, thank
So
you.
what are we looking at here?
So for 2018, which was a partial period, 2019 and 2020, these are the projected sales, both food and alcohol. And then farther down, you see the same? Okay. And then farther down, there are the expenses, the cost of sales, which is, again, the food and the alcohol. And then various types of expenses that the restaurant would have to incur.
Okay, so we see the cost of sales for food and alcohol. We see the cost of insurance, marketing expenses, labor expenses. Keep going down. Professional fees, licenses, accounting, other operating costs, right?
Yes.
And then it gets down to a total number at the bottom there, right?
Yes, total expenses.
Okay. And then if we go back up to the top, you have similar data for 2019 and 2020, right?
Yes.
And explain why 2018 was partial.
If I recall, Walker's was set to open in the latter part of 2018.
Okay. There's a tab on this spreadsheet. We're looking at Walker's, which is projected out. Can you click on the Soul Shine tab, please, Ms. Wilkerson? And what are we looking at here on this tab?
So these are the projections for Soulshine, the other restaurants, smaller than Walker's. And you'll see the food and alcohol revenue at the top. Less the cost of that revenue, cost of sales for the food and the alcohol, and then the other common expenses that a restaurant would have.
Okay. And then let's go to the combined. Well, you'll see there's a net profit number there. But before we go there, Ms. Wilkerson, can we look at the net profit projections for Walker's, please? They're at the bottom. And so this is projecting out 2018, 2019, and 2020, right?
Yes.
Okay. And then what is the combined tab?
So I believe the combined tab is both Walker's and Soulshine together.
Okay, there we go. It's a lot more granular, as you can see. Are these the projections that were given to you that you relied upon in projecting out lost profits for the new businesses?
Yes,
Okay. And are these the same projections to your knowledge that were given to the lender in this case?
that's my understanding.
Okay. You talked earlier in your testimony about when you're providing a lost profits calculation, and I think even in your franchise example, you have a defined period. You talked about maybe in the franchise case, it's a 1-year franchise agreement. Is there a term for that when you're running it in a lost profits analysis?
So in lost profits analysis, there is one of the key factors is that time period because it'll matter, if we're talking about profits for 2 years or 10 years. And normally that you would be able to set it up, set that time period. So for instance, if there was a business interruption, but you recovered 3 years later and, we're back in action, then it might only be for a 3-year period. When you have a lease or other kind of a contract, then it's appropriate to set it to the term of the lease. And so in this case, there's a 10-year lease with 2 renewal options, 5 years each.
Okay. And so was that the loss period that you used in running your calculations?
Yes, I used all 3 loss periods. So I ran it if it was only 10 years. And then I also looked at it if it was 15 and then also 20.
Okay. So to be clear, when you ran your analysis, you didn't just project out a 20-year loss, did you?
No,
Okay. You provided a 10-year, a 15-year, and a 20.
that's correct.
Okay. And the lease term, the initial term was 10 years, right?
Yes, 10-year lease.
With 5-year extensions.
That's correct.
And so did that strike you as a reasonable loss period under this
Yes.
lease?
Yes.
Okay. We've talked about the yardstick method. What other data did you review from BR Gas related to the Nooks and its performance?
We looked at tax returns. That's how we were able to put together the historical financials straight from their tax returns.
Okay.
We looked in comparison to make sure that the menus seemed reasonable. We looked at the menus for Soulshine and Walker's as compared to the Nook. And I had quite a few discussions with Mr. Dooley and Mr. Lett.
Object to the substance of any hearsay conversations you have with Mr. Dooley and Mr. Lett.
All right. Counsel, unless you think that it satisfies
I can
the rules.
tailor that.
Okay.
Without telling us the substance of your conversations, what was the purpose of those conversations, if you will? I don't want to know what Mr. Lett and Mr. Dooley told you, but just generally, what was the purpose of those meetings or discussions?
So, and I would say with all of my clients, we always have an opportunity to talk to management to understand the business. It's so important, whether we're doing a business valuation or lost profits, to get a really good understanding of the business. Mr. Dooley and Mr. Lett they have all the knowledge about how, what they expected to go into these restaurants. And so we had full discussions about that.
Okay. And you mentioned the menus. Were the menus the same? In other words, were they just going to take the Nook menu and drop it into Walker's? And
No, the
Carbon
menus
copy?
were not the same. They were not identical, of course, because each of the new restaurants had their own concept. They were started, or they were going to be started with that Piedmont Park kind of frame of reference and really use that area. So they were not the same, but they are similar enough in that they both have food and alcohol.
okay. The projections we put up on the screen a moment ago, do you have any ballpark of when those would have been prepared?
I don't know exactly when they were prepared, but they were prepared at the same time that they were doing the construction, so fairly close to when they would have opened the restaurants.
Okay. Was that important to you?
Well, certainly you want to have the most, the best projections with the most information. So typically, as you go through time, you continue to accumulate more information and would have a better feel for the expenses that might have to offset the revenue, things of that nature.
Okay. Do you know whether the lease agreement that was the subject of this dispute had any framework whereby the conservancy's rent would be determined based upon the income of the business?
Yes, yes. I read through the lease agreement and we actually forecasted what the rent expense would be based on the lease agreement itself. The lease agreement had a certain amount that was a base rent, would have to be paid every month. And then there was another line that we had to add in that showed the amount of rent based on revenue. So it was a percentage of the revenue. So yes.
Is that something you see very often?
Yes, especially when it's a retail restaurant, things like that, because the landlord would like to have, a piece of the action. If this restaurant's going to do very well, they would like to have more income.
Did you draw any conclusions based upon the fact that in this case, the conservancy's rent was going to be derived from the income the restaurant was going to receive?
Objection, Your Honor, this is an undisclosed opinion for this witness. She's not been disclosed to give any conclusions as to the rent provision in the lease and what that meant to the landlord.
All right, so this was not noticed as a basis for her opinion? Was that the issue?
He's asking for the conclusion she drew from the lease provisions regarding rent payment. That's an undisclosed opinion. The only opinion we have disclosed for her is for her calculations on lost profits, not on whether the landlord expected anything from the lease provision.
I can ask her lay opinion.
Well, I don't think she can talk about, I'll sustain the objection on that unless this is forming the basis for the ultimate opinion that she offered today. It shouldn't be her opinion on what she expected of the landlord.
When you see that type of provision in your experience, why is that typically included?
Objection, Your Honor. Again, now she's going to give testimony as to why landlords includes provisions. Again, this is not disclosed to this witness.
And if you want to make it for the record, you can approach and do that, Mr. Moy, but I would sustain the objection.
Were you comfortable relying upon the projections that were given to you in forming your opinions on future lost profits in this case?
Yes, I was very comfortable with the projections
Why?
for a variety of reasons. One is that we were able to, we understood the similarities and the projections were prepared by people that had restaurant experience. That matters a lot. Somebody who knows what they're doing to put those projections together. Also, it was my understanding that the bank relied on these projections. And so that takes it to a pretty high level because you never want to give bank wrong information. You'd really get in trouble for that. And so understanding that the bank relied on these. And then also I understood that the landlord was relying on these as well.
Your Honor, this witness is speculating as to what the landlord was or was not relying upon.
All right, that's sustained. Jury will disregard that aspect. Next question.
The projections that we looked at had income projections, cost projections, and then a profitability number at the bottom, right? You remember that in the spreadsheet?
Yes.
Is your work just plugging those numbers in and taking it all the way out 10 years or 15 years or 20 years?
No.
Okay.
No.
What else goes into the calculation?
So there's a lot that goes into the calculation. So really just understanding what those expenses are, if they're appropriate. As I said, we recalculated the rent because it was based on, a portion of it was based on the revenue that the restaurants would earn, along with the term of the lease. And then just understanding the various aspects of those income statements.
Okay. And you alluded to this at the beginning of your testimony today, but you talked about having to apply a discount rate. Can you tell us a little bit about how that plays into your opinions here?
Sure, sure. So there are three really important things when you're doing a discounted cash flow analysis. It's the cash flows that you expect in the future, and we talked about those projections. It's the time period. So we talked about why it's 10, 15, or 20 years. And then the other part that's really important is the discount rate. So we talked about how, it's not just additive of all those cash flows year over year, because $1 today is worth more than in the future. So we discount that back. One way to think about a discount rate, some people call it a return on their investment. if you have a bank account, a savings account, and maybe you're getting a 1% return, a 1% interest on that money, you're probably okay with that because you know that that money is going to be there whenever you need it. So you can go in and grab the money and it's available. There's very little risk to what's in the bank account. When you invest in a business, there's significantly more risk. I mean, even if you were investing in a stock that was publicly traded, there would be more risk and you would want more of a return. So, say maybe that would be an 8 to 10% return. It would vary by business. When you invest in restaurants in particular, which can be more risky, a restaurant that hasn't opened yet, there's a little more risk. You would want a much bigger return on your money because you're putting your money out there in a risky position. So you want to get a big return. That's the same way we look at discount rates. So in this particular case, we used a fairly high discount rate of 22%, which may not have any meaning to you. But the industry, like the restaurant industry itself, the discount rates tend to be closer to, say, 12% at the time we did this analysis. It can change over time. So we applied a much higher discount rate. And what that does to the analysis is it reduces the value. So it reduces the present value of the cash flows, the higher your discount rate, because it's saying instead of that dollar that is only worth 90 cents next year, or next year's dollar is only worth 90 cents today, we used a rate where we pretty much said, yeah, next year's dollar is only worth 80 cents today. I mean, it's much lower. So in effect, with that higher discount rate, it lowered the lost profits conclusion.
And so the lower the discount rate, the lower the risk, the higher the discount rate, the higher the risk. Is that fair?
That's correct.
And by applying the high discount rate, it lowers the value of the money in present day.
That is correct.
Okay. And how did you come comfortable with the 22% discount rate that you used in this case?
Well, when we determine what the discount rate is, we actually build it up, and I won't get into all the detail, but it's really based on the risk, and it's the risk of added on top of that bank account risk. There's the risk of just having a investment in the company, in a business, and then there's additional risk maybe for the industry, and we build it up that way. But then we looked at the industry data that we had to determine what typical discount rates were, and those would be the data that we have are really, it's an industry average. So it's new restaurants, it's old restaurants, or well-established restaurants, and you can't really disaggregate the information. So we put 12% as a average, and then knew we needed to be higher than that. And so there's a little bit of subjectivity to it, but we used a discount rate of 22% because that seemed most reasonable.
Okay. And after applying the discount rate to the future projections, is that the end of the analysis? You've got your lost profits calculation?
Applying the discount rate over the time period to those cash flows determined what the lost profits were, except for we also understood that there were some we call it mitigation, so a reduction of the loss.
And what do you mean by that, a reduction of the loss? Explain that.
Sure. So we said that, had the business owners been able to open these restaurants, there would have been a certain amount of lost or a certain amount of profits, and they didn't get that. But also they didn't have to pay to have the restaurants built out the rest of the way. And so there was a savings, and that's offset against the lost profits.
And did you ballpark come up with a number for what those savings would have been, or that reduction?
Yes, and it's in my affidavit.
Okay. Do you remember just
I hate to guess. I think it was around $840,000 or so.
Okay. And so that would be subtracted from the lost profits calculation because those are cost savings for the client?
Yes.
Okay. And based upon your experience and the work that you've described, the materials that you reviewed, do you feel that you calculated lost profits for Be Our Guest with reasonable certainty and reliably?
Yes, I did.
Okay. I'd like to put up a demonstrative on the screen. Yep. So I'm going to show. You need a copy? Oh, you need a copy?
That'd be great. Thank you.
Okay. You have what's on the screen in front of you there.
Yes.
Okay. And does the first bullet fairly summarize the work that you did to come up with the lost profits calculations that's in the chart here at a high level?
Yes.
Okay. And then the calculations are there and it says BR Guest lost profits on a 10-year lease are 2.042 million. Its lost profits on a 15-year lease, which is 10 years plus one extension, are 2.89 million. And its lost profits on a 20-year lease, 2 years plus two extensions, are 3.1 million. Did I read that right?
Yes, the last one is 10 years plus two extensions. Correct.
I may have misspoken.
That's right.
And then we have the numbers there for the 10-year, the 15-year, and the 20-year. And explain to the jury again why you provided multiple calculations.
So multiple calculations because it will have to be decided whether that appropriate term is the 10-year lease or if we would consider in the extensions of the lease for those 2 5-year periods.
Okay. And obviously these are aggregate numbers here. Is that right?
Yes, I believe these numbers are both Walker's and Soulshine combined, less the cost savings.
Okay. And we looked at the earlier projections. I think the jury may recall that Walker's was a higher number than Soulshine because Walker's was more of a full-blown restaurant, right?
Yes.
But you added those numbers together to get what we're looking at here in this demonstrative. Is that right?
Yes, these are combined.
Okay. I would like to have the jury take a quick look. Well, first I'd like to have you take a quick look at the exhibits to your report. Can we put it up on the screen, please? This is Plaintiff's Exhibit 196, and we're going to the back of that document. And I'm looking at Exhibit 2.0. The upper left-hand corner says Walker's 1834. No. I think it's 126 on the PDF, Ms. Wilkerson. Well, let's keep going down. Keep going. If we can scroll down to Exhibit 2.0. Go down one more, please, Ms. Wilkerson. Thank you for your patience. Do you see what's up on your screen right now, Ms. Miller?
Yes.
And what is it that we're looking at here on the screen?
This is the discounted cash flow analysis for the Walker's restaurant.
Okay, and explain, when you say it's the discounted cash flow analysis, what does that mean?
That means that we looked at the cash flows for each of those years across the top. And those cash flows were derived from, again, it's revenue that would be brought in, less the cost of those sales, less operating expenses.
Okay. And then obviously, if you scroll down, you've got the revenue on a year-to-year basis, right? And what we're looking at here is a 10-year projection. Is that right?
Yes, on this page.
Okay. And then the cost of goods, it reflects the food costs and the alcohol costs, right?
Yes.
Okay. What is cost of goods sold? Can you explain that to us?
Yes, that is the cost of actually generating that sale. So it is the cost of the liquid in your drink glass and the food on your plates.
Okay. And then below that, under cost of good, is it the operating expenses, right?
Yes.
Can you blow that up one, if you don't mind? A little bit small for everybody to see. Maybe one more. There we go. And then if we can scroll down past the operating expenses. On the next page is EBITDA. What is EBITDA?
So that's really just a measure of earnings. It's earnings before interest and taxes.
Okay. And then there's a column also for, or a row rather, for EBIT. Can you explain that?
Yes, so that's the earnings after depreciation.
Okay. And then there's a free cash flow to invested capital. What does that mean?
Basically, that is the projected earnings less two other items. One is net working capital. So that would be, the cash that you have to keep on hand to run the restaurant. It could also be inventory, supplies that you have in the kitchen. And so as revenues increase, that the amount that you have to have on hand increases. And so you have to spend that money. And then the second adjustment was for capital expenditures, and that is big purchases, so big ticket items like if they had to buy a counter or buy a stove. And of course, that happens over time. And so we estimated the amount of those capital expenditures because they wouldn't be in the ordinary expenses.
Okay. And then you'll see underneath the header that says free cash flow to invested capital, there's a discount rate of 22%. You see that?
Yes,
And is that the discount rate you described earlier as being reflective of a higher risk?
that's correct.
Okay. And that was applied to these calculations, is that right?
Yes,
And the impact of that high discount rate, it lowers the overall valuation or the overall profits that are being calculated, right?
that's correct.
Okay. And then you'll see there's a damage breakout for a 10-year lease, a 15-year lease, and a 20-year lease. Is that an accurate depiction of your calculations as to the lost profits for walkers during the periods that we're looking at here?
Yes, it is. Those are my conclusions based on those three periods. I don't know if it's a question in y'all's mind, but you can see how adding on those extended 5-year periods, because it's so far out into the future and that discount rate is so high that it only increases just slightly for each of those periods.
Right. If we can just look at the similar page for, if we scroll down, there's a similar calculation for Solshine. Keep going down. There we go. And what are we looking at here that's up on the screen?
So it's in basically this same format. We have our revenue and the cost of sales, which is the cost of that food and alcohol that was sold.
Yep.
Or would be sold. And then that's followed by the operating expenses.
And then the cost of goods, EBITDA, and the free cash flow to invested capital. And again, there's that 22% discount rate as well, right?
Yes,
And the damages here for Solshine are 669,500, 776,400, and 831,100, right?
that's correct.
And again, the amounts are lower because Solshine was a smaller grab-and-go type restaurant.
Yes,
Okay. And then wrapping it all up, I think you said you took the calculations that we're looking at here on the screen with the different periods for Walkers and for Solshine. You added them together. And we'll go back to the demonstrative. And that's how we get the numbers that wound up in the demonstrative exhibit.
yes, they were added together and then we deducted that savings.
Okay. That's right. You deducted the savings after running these calculations. And do you believe that those calculations are reasonable and reliable based upon your experience and the work that you did in this case?
Yes. Again, in business valuation and all my work over the past 30 years, it's really hard sometimes to find a good comparable company. Every company typically is unique. We don't often come across a chance where the company, we have a benchmark or a yardstick that is so similar for us to use. So I feel comfortable with it.
Nothing further at this time.
All right. Any members of the jury need a break or want to stretch a little bit before we go? Okay, let's take 5. Let us know when you're ready to proceed.
Lisa, can you stop sharing? Yes, I'm so sorry. You're fine. No worries. Just walked away.
Okay. As soon as that light comes on, I'm calling them back in. We'll wait on it. Please, the rest of them will feel free.
Okay, thank you.
Wake up. All those numbers. Now I gotta ask her. Yep, everything you're doing. Excellent. Yeah. Sorry. Page 3. Page 4. 6, 6, 9, 7, 8. Start 9. Won't be sufficient. And I'm gonna do this. Let's go right here.
Try to keep. And look, it sounds like if you want to know, deep question.
Yeah.
We got a note. Oh. All right. I don't know if I've had this before.
They got some city of it.
So I don't know where it goes. Okay. I'll worry. That's fine. I'm just gonna go ahead and do a lower rating.
Thank you.
Thank you.
May we have a moment, Your Honor, to confirm with counsel?
I also need something I need to put on the record with y'all. So let me do this first because you might still want to confer with them with, I got a juror note. I just need to put that on the record.
You want us to approach or?
No, I'll read it to you and then I'll hand it to you. So if we're ready to go back on the record. Okay, we're back on the record and we're in this restroom break, I received a written note of their own volition. Juror number 5 asks, will we be provided with access to email evidence and all of Miss Miller's number accounting stuff /charts ? I've marked it and I'll turn to that as Court's Exhibit 1 and any party who wishes to can come examine it. And I'll solicit input on how to respond to that if, to the extent we do respond or want to at this point. The inclination would simply be that I don't know if anyone's willing to do a definitive yes or no right now, but it's the exhibits that you'll be provided are determined at the close of the evidence. We could say that, unless we can also just see where things go. So if y'all can talk about it, you can think about it, and then if you got something else to put on the record, otherwise we'll wait for the light. I would think so.
Yeah, I think you want to discuss something.
We do.
And just speak up for the record.
Yes, Your Honor. I think I think we're on the same page of simple instruction. The documents submitted into evidence in the course of the trial will be provided to you at the time of your deliberation.
That's what you'll have available to consider.
I mean, is that accurate though? Because sometimes continuing witness rule is going to keep out admitted documents, right? That's why until y'all sit here and agree of what does and does not go back, I don't know if I can say definitively.
Yeah, we plan to do that, right?
That's fine. If y'all both consent
Yeah.
to send it back, that's fine.
Say the agreed, admitted exhibits will be submitted to you for your deliberation.
Okay, and there's always been that distinction of even if it's admitted, even without objection, it doesn't necessarily go back. And if y'all are now saying that everything that's been admitted can and should go back,
You suggested an instruction to reserve that answer. until-
yeah.
You've done this.
I'm just solely flagging the continuing witness rule, which is just this, Georgia quirk. You can't really make any sense of it mostly. They don't have it federally, but it's how we operate.
I think what the parties had already agreed to, and Ms. Wilkerson and I spoke about this, was that, right at the end of the case, she and I will confer on all the exhibits and we'll agree that what's been admitted and we'll agree that's what's going back. So the plan is if we agree it's admitted, then it's going back with that.
That's fine. That's fine by me. I'm just saying.
We're waiving the continuing witness.
Which would be great. But to that extent, though, the email stuff and charts that are referenced in this note have not been admitted yet. And so,
There will not be specific accounting numbers, I don't believe, from Mr. Lett.
yeah, unless it comes up in cross.
Right.
I don't think that the report or the documented opinion is something that would typically go back.
Right.
So, to that end, then is the consensus, I'll just tell them admitted exhibits go back, and at this time, that has not been admitted as an exhibit?
Yes.
All right,
I agree with that.
Thank you.
all right,
We need 5 minutes just to take up housekeeping matters. That's okay.
okay, that's fine. Well, okay, so we're back off the record. And I want to throw one more thing out, just to throw more chaos into everything. This is off the record, just something else you can powwow about, and doesn't have to be an answer today or tomorrow, but a thought occurred. I'm not obviously going to force this on you because it wasn't in the pretrial order, but I also wonder, since both parties are asking for 13,611 attorney's fees, would there be value in bifurcating the issue of the amount and the reasonableness? Meaning the jury makes the determination on whether there's bad faith and they're justified, but then all the witnesses that go to amount and reasonableness are then deferred until we know if they even think there's been bad faith on the part of either party. So that's a thought out there.
We proposed that's been discussed and it's not been.
Can reach an agreement. No. I think what the judge is proposing is different than what.
No, it's not that I do it. It's that the jury is going to do that in 2 phases. It's a bifurcated trial.
So the jury does that.
So you would come back and do another, 5 or 10 minute closing, assuming we know in phase 1 that they found bad faith on the part of either party.
Well, then, maybe let me just take up the housekeeping matter
Yeah.
writ large here with everybody because.
Because I don't know if your attorneys were this housekeeping matter you're about to take up.
So yeah, it is.
Yeah.
Yeah. So basically, we have gone through today considerably faster than anticipated. And so we were going to bring in is our either next or second to next witness, one of the attorneys to discuss attorney's fees. They've been disclosed, in the exhibits, both 24 and 48 hours in advance, but we were not, obviously we want to stand by you because they were not on today's list, but all the information's been provided either 24 or 48 hours
is it?
ago. Rachel Gage. But that would mean that we're now dealing in front of the jury with quantum and reasonableness. So that sort of subsumes the judge's inquiry, which is why I'm bringing this up out loud.
Yeah.
So maybe we can still figure out if that's a possibility for the parties about how.
And these attorney witnesses, depending again on whether, I see those as being very short witnesses, potentially.
Certainly.
We hope so.
I
Right.
think Mr. Wilco may have some questions for that.
And, so let me just plot out, I'm just going to jump in here and the lineup though, for today, you're saying Gage. Did you have anyone else on deck?
We do Kimberly Peak,
Okay,
then that would round out who we had expected for today.
right.
Counselor,
Let's say,
disclosure of Mayor Abed, is he not coming?
He is not.
well, I mean, we still have the cross of Miss Miller here. That's going to take some time. So perhaps, maybe not, but, and then going into tomorrow, what are you looking at?
So, let's see here. I think tomorrow we're looking at possibly Jennifer Ide,
Right.
Chris Lewis. I don't have my list in front of me. I wish do we have it? Can we get Anna sitting in here? They have one of them has the operative list. Oh, we need the operative witness list. Thank you. Yes, we'll answer that precisely. Mm-hmm.
The rest of the attorneys, huh?
Well, the rest of the attorneys, that's right, the rest of the attorneys.
You have a, yeah, then from there, I just see on
I
the,
think that's three
as Mr.
attorneys.
Lett as,
And
Yeah,
the
we have
question
Ms.
for you is what do you want to do?
Mr. Lett and then
The
Mr. Hag.
question for you is Hagberg either
Hagberg.
tomorrow afternoon or Friday morning.
Well,
I think
that's
we
one
already
question for us,
discussed
yes.
Friday morning.
Well, I have to talk to him
Well,
about that.
right, because we need to discuss that.
She needs to tell him which days.
I understand,
Yeah, yeah.
yeah.
Well, given the number, I don't know if y'all want to use all those exhibits with Mr. Led, but that looks like that's gonna take.
It's gonna take a while, that's right, yeah.
Probably spend all day just
Yeah.
with her, so.
Well, I know, but that is sort of the question, what yes, we have to come to ground on is whether it makes more sense to get Mr. Hagberg in and out before we get that started.
which one are you saying is a longer one here?
Mr.
Yeah.
Lett, our client.
He's available tomorrow afternoon
Okay.
or Friday
Instead
morning.
of, dirty laundry for the court, can we have 5 minutes? Maybe we can come back and give a more specific answer for tomorrow and Friday.
Yeah, that's fine. But again, I would say that, and put it out there that this whole block of 5 attorneys, we could, this would only, if you could give me an estimate of how long you think the direction crosses for that whole block of 5 on the behalf of the plaintiff and how long that block is on behalf of the defense, I guess it's just one, how much time that is, that could determine whether it makes sense to bifurcate.
Okay, if you can give us a moment, let us
Right.
for a moment, then we can come back with answers to all the questions.
All right.
for everybody.
Well, can we just go ahead and do the cross of Ms. Miller and then we'll take another break?
Yeah,
Right?
sure.
Okay. All right. Then with that, we'll go back on the record and we can bring in the jury now.
If we could get the pleasure of Chris Lewis.
Yep.
He's coming tomorrow.
Yes. Yeah.
And are you ready to say, John, that he's definitely coming? I feel like we spent time getting ready for City of Atlanta witnesses who all of a sudden aren't coming.
He's not my witness, but I'm 78% sure that's right.
I'll ask for the jury.
Thank you, Deputy Scott. Defense may proceed with cross-examination.
Well, good afternoon, ladies and gentlemen. Been a minute since I got to speak with you. Ms. Miller, good afternoon. We met a moment ago before we all came back in. But again, my name is Brett Mason. I'm one of the attorneys that's representing the Conservancy in this case. And you understand it's my job this afternoon to ask you some questions about your opinions and your testimony. Do you understand that?
Yes.
And I just want to make very clear from the very beginning, it is undisputed in this case that Be Our Guest, the entity that is the plaintiff asking for lost profits here, has zero history of earning any profits, correct?
I don't know that. I'm sorry. Are you talking about the specific restaurants?
I am talking about Be Our Guest, the plaintiff in this case. They have
Yes.
zero history of earning any profits.
My understanding is that they've earned profits at the Nook.
Okay. And are you telling the jury that Be Our Guest is the owner of the Nook?
It is similar ownership.
Be Our Guest is a legal entity, does not own the Nook. You know that to be true, correct?
Yes,
Okay. And you gave a deposition in this case, did you not, Ms. Miller?
I did.
And you told the jury you've been an expert witness in what, 10 to 15 cases?
Yes,
And in about 5 of those, you've given testimony?
that's correct.
And every time you've given testimony, whether it's here in front of a jury or whether it's in a deposition, you've sworn to tell the truth. You've given an oath to tell the truth,
Yes,
correct? And so I want to make sure I understand your testimony here today. It is undisputed that Be Our Guest and the two restaurants Be Our Guest plan to run, Walker's and Soulshine, has zero history of earning profits.
That is correct. They never opened.
Thank you. And rather than a history of actual profits, your analysis, the projections that you talked about, the spreadsheet that Mr. Moy put on the screen, that relied on Be Our Guest owners' estimates of what their profits could be, correct?
Yes, that's what they shared with the bank and the lessor.
Because neither Walker's or Soulshine ever operated?
That's correct. They didn't open.
And in fact, Ms. Miller, you're aware that the parties have actually stipulated, there's two stipulated facts that the judge will read to the jury. That one, Be Our Guest never completed construction on the restaurants, and two, that Be Our Guest never opened those restaurants. Were you aware of that?
I wasn't aware of the legal terms, but yes, that's my understanding of the situation.
And you mentioned a little bit about conversations you had about why Be Our Guest was not able to open restaurants on the premises at the Conservancy building. Do you remember talking with Mr. Moy about that?
Yes,
And to be clear, you have no opinions about those problems and who's right or who's wrong in the landlord-tenant squabble, right?
that's correct.
You weren't asked to come here and tell the jury anything about that.
No,
Now, Ms. Miller, you were asked to come here today as a paid expert witness for Be Our Guest, right?
yes,
And you mentioned that Mr. Dooley was the one who originally reached out to you and retained you. And if you can recall, that was back in December of 2021.
yes.
And you charge $460 an hour for the work that you do.
At that time, yes. Yes.
Do you charge more now?
Our rates increase every few years.
Understandable. For all of the time that you've spent working in this case, have you charged $460 an hour, or have you increased that rate over time as well?
I think we stuck with 460.
Well, at the time of your deposition, do you recall there were a couple invoices that you had provided?
I don't recall. That was about 3 years ago.
Okay.
But if it was requested of me, I did.
Yeah. Well, based on those invoices, at the time of your deposition, which was back in 2022, you had already billed $31,000 for the work done in this case. Do you recall that?
I don't recall the amount.
Does that sound about right to you?
I wouldn't know.
Okay. Your Honor, may I approach?
You may.
Now, Ms. Miller, the document that I've just handed you, do you see at the top there, it says Bennett and Thrasher?
Yes,
And that is the firm that you work for, right?
that's correct.
And you could see here that this is a letter from Neil, or to Neil Wilcove. Do you see that?
Yes,
And if you just take a look at that first page and then the second page, do you see these two documents and do you recognize what they are?
yes, these would be the invoices that we sent for our work.
Okay. And does this refresh your recollection that at the time of your deposition, as these are dated before the deposition, you would billed about around $31,000 for this case?
Yes,
You can put that to the side, ma'am. And have you continued working on this case since February of 2022?
I have.
Can you estimate for me about how much time you spent working on this case?
I hadn't spent much over a period of time until just recently.
And just recently, did you spend some time preparing for your testimony here today?
I did.
And about how much time did you spend doing that?
10 to 15 hours.
So math is not my strong suit, which is why I'm a lawyer and I don't do what you do. But if it's been another 10 hours at $460 an hour, that's around $4,600, right?
Yes,
And then are you charging that same amount for your testimony here today?
I am.
Okay. I'm hoping to get you out as quickly as we can, but I'm going to estimate maybe you'll be here for 2 hours, 2.5 hours. So that would be another, what, around $1,200?
Yes,
Okay. So in total, by the time you step off the stand here today, the amount that you're going to be paid to give your testimony to this jury is going to be a little bit under 50 grand. Is that fair?
I don't think it'll be that high, but it could be.
Now, we talked about the fact that the Be Our Guest restaurants never opened or had a history of earning profits. And you are not aware of any sufficient database of actual profits and loss of the Be Our Guest restaurants, correct?
That is correct.
And because you did not have a sufficient database upon which to base your analysis, you started your analysis with the income statement projections for the restaurants that were prepared by Mr. Ouellette and Mr. Dooley, right?
Yes, in the ordinary course of business.
And one of the things that you mentioned during your direct testimony is why you found those projections to be reliable. And one of the reasons you talked about was the fact that those projections were provided to the bank in order for Mr. Ouellette, Mr. Dooley, and Be Our Guest to obtain a loan. Do you remember talking about that?
Yes.
And so you were comfortable with Be Our Guest projections of profitability because they were given to the lender and the lender gave them a loan. Is that fair?
Yes.
You've not seen any documents from the bank or the lender saying, these look good, we like these, let's rely upon these projections. You've not seen anything like that, right?
I haven't seen anything like that, but that is the reason that projections are given to a bank, is for them to do their due diligence so that they can be comfortable making a loan.
But your testimony today is just based on the fact that the projections were given and a loan was made. No other documents or assurances or evidence from the bank itself.
No, I only know that they did lend money.
And you said that gave you comfort because the bank would have wanted to make sure there was revenue available to help secure to repay the loan, right?
Yes, it's in the bank's interest to make sure that the loan can be repaid.
So in this case, though, Ms. Miller, you know that the loan that Be Our Guest received was from the Small Business Administration, right?
Yes.
And the Small Business Administration gives out the loans. They guarantee 75% of the ACB, and that is based on the Nook and Mr. Ouellette guaranteeing that loan. You know that, right?
I wasn't aware of all of those factors, but yes, that a personal guarantee is not unusual.
Okay. So you were not aware when you were deciding to use those projections that the bank not only looked at the projections in deciding to make the loan, but they also had a guarantee both from the Nook as an asset and from Mr. Ouellette personally on that loan.
Yeah, I don't recall if I knew that information at the time, but I'm not surprised because personal guarantees go a long way.
Right. But that's not including any of the materials that you reviewed. That's not information that you had until I just told it to you right now. Is that fair?
I just don't recall hearing it.
And would you agree with me that might lessen a little bit of your comfort with those projections, given that the lender was also relying on getting its money back from the Nook or Mr. Ouellette if Be Our Guest failed?
No, I think that the bank still relied upon the projections.
You do know that the Small Business Administration exists and was created by Congress because it was so difficult for new small businesses like Be Our Guest to get loans from banks. You understand that's one of the reasons it was created.
Yes, I mean, it's important to us, yes.
Generally, banks, until that was created by Congress, banks were not willing to lend money, especially $1.5 million, to new unestablished businesses like Be Our Guest. You know that.
Yeah, I imagine that, yeah, banks have to think twice about loaning that kind of money. And so those, the projected outcome is really important.
Now, I want to talk to you a little bit about Mr. Ouellette and Mr. Dooley. The jury hasn't gotten a chance to hear from them yet in this case, so they've heard a lot about them. But I want to make sure that they understand why you were comfortable relying on the projections that were given to you by these individuals. Does that make sense?
Okay.
Okay. Mr. Ouellette, for example, is a lawyer. You're
Yes.
aware of that? She went to Emory Law School. Is that right?
That's my recollection.
You reviewed her deposition in this case, right, Ms. Miller?
I have, yeah.
And she has worked at a handful of law firms here in the city of Atlanta during her career.
I believe that to be true.
And in more than one of those law firms, she has worked as a real estate associate or a real estate lawyer. Are you aware of that?
Like a closing office, yes.
Right. So she's familiar with law and issues surrounding real estate. based on her experience as a real estate lawyer.
I would think so.
And you also understand from reviewing Mr. Ouellette's deposition that when it came to this lease, which you talked about during your direct, Mr. Ouellette understood what as is, where is mean when it comes to the building, correct?
Yes, the lease was signed. I assume that everybody.
Okay. And just to make sure we're on the same page, this is what was in Mr. Ouellette's deposition that you reviewed. Question, do you understand that the meaning of an as is, where is lease? Answer, I do. Question, what is your understanding of it? Answer, that you take the premises as is, where is. So you take them as they are, the premises. That's something that Mr. Ouellette expressed that she understood when she was signing the lease with the Conservancy. That's what you saw in the deposition, right?
If you say that that's in the deposition, it's been a while since I've read it.
And based on your interactions with Mr. Ouellette and Mr. Dooley and what you know about them from this case, you felt that they were competent business people such that the projections that they made for their business was something you were willing to rely upon. Is that fair?
Yes, I believe that they are competent business owners.
And do you have any reason, or have you seen any evidence in the record that leads you to believe that Mr. Ouellette or Mr. Dooley were not sophisticated or not able to understand the lease terms in the lease that they signed?
It's asking what they understood.
I'll rephrase that, Your Honor. Actually, I'll just withdraw that. Let's move on. We've talked about them enough. So your analysis, as you talked about during your direct, relied upon conversations you had with Mr. Ouellette and Mr. Dooley. And so we just talked a little bit about Mr. Ouellette's deposition. You're also aware Mr. Dooley gave a deposition.
Yes.
And that's something you also reviewed in forming your opinions for this case.
Yes.
Okay. And I want to ask you about that, about some things Mr. Dooley said. You're aware that Mr. Dooley agreed that Walker's and Soulshine were not a chain, they're not chain restaurants.
Objection, hearsay.
Okay. Your Honor.
I mean, she reviewed the deposition. She based her opinion on it. It's on cross, overruled. You can proceed.
Okay. All right. Mr. Dooley testified that Walker's and Soulshines were not a chain.
I'm sorry, we're not.
Were not a chain. They were not a chain restaurant.
Chain. If you say that that's in the deposition, I haven't looked at it recently.
Okay. Well, here's exactly what it says in the deposition. This was when the questioner was reading from a business proposal that they had submitted for these restaurants. Question. And then I'm looking towards the middle of the page here. There's a paragraph that starts, "We are not a chain," correct? Answer, yes. See that? Mr. Dooley agreed they're not a chain.
I hear that you say that, yep.
Okay. And he actually agreed that they are completely original restaurant concepts. You aware of that?
Again, I'll have to take your word for it. I haven't looked at the deposition.
Well, let's go ahead. I have some slides with this testimony, so I want to just pull it up so you can see it, the jury can see it. And so we're looking at Mr. Dooley's testimony here for his deposition in January of 2022. Question, this is again reading from that same proposal that was submitted by BR Guest for their restaurants. "We do not have several outlets throughout Atlanta. Is it fair to say that Walker's, and at the time the Sam and Sarah concept, were completely original restaurant concepts?" Answer, I think so. Did I read that correctly?
Yes, you did.
And when we talk about Sam and Sarah's, that's the Soulshine space, right?
That's my understanding.
Originally, there had been somewhat of a different concept in the original business proposal, but it morphed over the years and went from Sam and Sarah's to Soulshine. You're familiar with that, right?
Yes.
Let's go ahead and look at the next slide. We can see here Mr. Dooley has agreed that the new restaurants proposed for BR Guest are not franchises of any other restaurant. You see that?
I do.
And let's go ahead and take a look at the next slide. Mr. Dooley also agreed that these restaurants were going to be unique to Piedmont Park. Do you see that?
I see that.
And you are familiar with where the Nook is situated in relation to the park?
I am.
Okay. Would it be fair to say that the Nook would be a block, maybe 2 blocks from where these 2 new restaurants are going to be located?
That's fair.
And it makes sense that they would want to have unique, distinct, different restaurants just 2 blocks from the Nook, right?
Right. I'm just not sure. I certainly don't know what Mr. Dooley was saying when he was talking about it being unique or not a franchise, not a chain restaurant. I don't know what he meant by those terms.
You don't understand what it means for a restaurant to not be a franchise or a chain of another restaurant?
I certainly understand a franchise agreement and certain franchises, of fast food restaurants. I don't know if that's what I don't know if he was thinking like I think of them when he said that.
You talked about the two Chick-fil-A's,
Mhm.
one stopped, or compare the two. That's not what the situation we have here, right? These are not two identical franchise restaurants with the same menus, the same food, the same contract, same supply. That's not what we're talking about.
No, these restaurants have many similarities, but they're not franchised, which is indicative of having a franchise agreement.
And let's go to the next slide. And then finally, Mr. Dooley agreed that these two restaurants would be distinct from the Nook. So specifically, the question asked of him was, so again, the intent was that the concept for the restaurants at the community center would be distinct from the Nook, right? Answer, I think at this time, yes. Do you see that?
I see that.
And you understand that from reviewing his deposition, that this was the proposal for the restaurants that Be Our Guest wanted to open at the community center.
Yes, I don't understand when he says distinct exactly what he was thinking.
And we'll ask him exactly what he means by that, but I'm going to go with the usual dictionary definition of distinct, which means different from. Does that make sense to you?
Right, but when we're doing, business valuation or lost profits, they can be distinct restaurants, and this restaurant is distinct from this one in that they're two separate restaurants, or they can be distinct, like, this is an IHOP and this is trying to think of a nice steakhouse or something like that. That kind of distinct.
Right.
These are not distinct like IHOP and a nice steak restaurant.
You would agree with me that a nice steak restaurant sells food and alcohol?
Yes.
And you would agree with me that a burger joint can sell burgers and beer. That's food and alcohol, right?
Yes.
Okay, you wouldn't base the projected lost profits off of a nice steakhouse, let's say maybe Marcel over on the west side, based on something, the profits and expenses of a Yeah Burger, right?
Exactly. That's why we were in a good situation that we didn't have to do that.
Right. Well, and you just testified though, Ms. Miller, that to you, the Nook and these restaurants Be Our Guest was opening were similar because they were both selling food and alcohol. That's what you just said on direct. Do you remember saying that?
That was one of the characteristics that made them similar, yes.
We can go ahead. We'll just keep that there for a second. Now let's go back to the projections that we saw, right? The Excel spreadsheets with the projections. You are aware that Mr. Roulette has agreed that those projections and the expected profitability of those spaces fluctuated significantly over the years as they were working on the projections. You're aware of that from her deposition?
Yes, I'm aware that there were earlier projections.
Okay. And let's go ahead and take that down. That's good. And Ms. Miller, are you also aware that Mr. Roulette has stated that there were a lot of holes in those projections when they first made them?
I don't recall that comment, but I'm not surprised.
And this is going to be tab 4 in your binder, Ms. Miller and Mr. Moy, tab 4. Tab 4 in the binder, Your Honor. And do you see that in front of you, Ms. Miller?
This email?
Yes, you can see this is an email document from Catherine Drolette to Penelope Cheroff, Mark Banta, David Dooley, and Debbie McCown. Do you see that?
Yes.
Okay. And this is from earlier in the timeline than we've really been hearing about a lot in the trial, but this is from April of 2014. Do you see that?
Yes.
And were you aware that that was the first time that Be Our Guest?
Did she review this? Has that been established?
Not yet, Your Honor.
Okay.
Okay. So you see this document is from 2014.
I do.
Okay. And just not even looking at this document, were you aware from what you haven't reviewed in this case, that Be Our Guest first proposed to rent space at the community center all the way back in 2014?
I understand that they were working on a concept.
Okay.
Yes.
And Your Honor, at this time, I'd like to admit this exhibit.
Objection.
On the grounds of, let's just start there. Okay, unless it's been established that she looked at this to form her opinion or has any knowledge of this, I don't see how we get it in through
Well,
her.
Your Honor, this is cross-examination and this is not a hearsay document as it's a statement by Mr. Olet, so it's an admission. So I say that's admissible. It's not for impeachment, it's
Okay.
admissible for all purposes.
And so have you authenticated this is the correct email and that,
I'm
as
not
well?
hearing an authenticity objection, Your Honor, just a hearsay objection.
yeah, well, and then at this point, if it didn't go into forming her opinion and all else, I just wouldn't know the relevance of asking her
Okay,
these
I'll ask
questions.
Mr. Olet about it when we talk to her tomorrow. But regardless of what's said in the email, you are aware Mr. Olet has said that there were holes in the projections that they put together.
Yeah, I don't remember that exactly, but projections tend to develop over time, especially as you get closer to opening a restaurant and really understand what expenses. So I would expect that they improved over time.
And I think I heard you say on your direct examination that the projections you received, you believe that those were put together sometime in 2018, close in time to when the restaurants were intended to be opened?
I don't know right now if it was 2017 or 2018, but not 2014.
If in your materials that you reviewed, one of the items that you have in your appendix says Walker's Soul Shine projections 2017, would you have any reason to disagree? Those projections are actually from 2017, not 2018.
That's probably correct then.
And at that point in 2018, when the construction halted at these premises, you know that Mr. Olet and Mr. Dooley were already seeking rent abatements because they planned to not open until the summer of almost 2019. You're aware of that?
Objection, lack of foundation.
Or you're not aware of that?
Let's start there. You can answer the question. if you
Sorry,
can.
I don't know the details of that.
So you began your lost profits analysis in 2018, even though you were not informed that those restaurants likely were not going to open until the summer of 2019.
Right, which is fine because they were still under a 10 plus 2 renewals of 5 years. So the term of the discount or the lost profits would have been the same.
Right. I just want to make sure the jury has accurate information, Ms. Miller. So you were not aware that those restaurants were not going to open at any point in 2018.
I became aware that they weren't going to open.
Okay, just making sure, because your direct testimony, you said they were going to open in 2018, projections were close in 2018. So now we understand the projections were in 2017, restaurants were going to open in 2019.
Right, I may have misspoke on the date of the projections as I get those years mixed up, but the restaurants were going to, initially, those restaurants were going to open up at the end of the year, beginning of the next.
You're also aware that Mr. Dooley has agreed that those projections were just informed guesses. You're aware of that from his deposition.
Which projections were those?
The projections that you've relied upon in this case.
Okay. If it was in his deposition, I don't recall sitting here.
Okay. Well, let's just take a look at that. And again, question and again, numbers that you put into a pro forma for a restaurant that doesn't exist yet, those aren't based on an actual track record of income for those restaurants, right? They are informed guesses as to what the income and expenses would be. And Mr. Dooley said, only informed by having a restaurant of similar size and similar location. That's something you saw in his deposition, right?
I reviewed his deposition years ago. I didn't review it in preparation for this.
Okay.
So I would take your word. I work with a lot of business owners and I ask them to help develop projections for business valuations and the like. And we always have a conversation about, well, how am I supposed to know? Well, and sometimes business owners will casually refer to it as an educated guess. We look for the word educated.
And so I just want to make sure I understand. You spent about 10 to 15 hours preparing to come in for your testimony here today. Is that right?
I think so, yes.
And during that, you did not take the time to review the depositions of the two plaintiffs who were asking for the lost profits before you came in and talked about?
I did review Mrs. Drolet's
Okay, got it. Did not review Mr.
but not
Dooley.
Mr. Dooley's.
All right. You would agree that sometimes a company's projections are very accurate and sometimes they are not.
Yes, it's a prediction.
Right. They're projections, not facts.
Correct.
And in fact, you would also agree there is no way to know how accurate a projection is until you see the actual profits and losses, right?
Right. The purpose of a projection is to help plan a course, to help look ahead to see what might happen, to get financing, to get a lease. I mean, there are lots of reasons to have projections, but certainly you have to wait to see if they pan out, and then they become historical financials.
And you've worked with companies that have had projections that later turned out to be very inaccurate, right?
Yes, we typically, after vetting projections with management in the industry, if we're still unsure about, that they might be risky, then that's when we go back to that discount rates and we apply a higher discount rate for the fact that they may not pan out.
Now, you mentioned during your direct examination that the reason, well, actually, let me back up. There's two methods by which you can do your analysis. There's the before and after method, right?
Yes, that's one of them.
Before and after, you can only do with a business that has an actual history of operating with profits and losses, right?
That's correct.
Could not do that here.
That is correct.
There's also the yardstick method. That's the second method you discussed, correct?
Yes,
And that is where you compare the potential business to a similar business, right?
yes,
And so in this case, you compared it to the Nook.
yes,
And you mentioned that you compared it because it was such a comparable restaurant in the area, same ownership management, all of that, right? You remember talking about that?
yes,
Okay. But you also used the Nook because it was the only restaurant in the area you had data to compare to, right?
yes, even if I had other data. I mean, part of what makes it similar is that we have similar ownership and management.
But at the end of the day, it was the only one available.
Yes, otherwise I would have industry averages.
Now, one of the things that you looked at on your direct was kind of that spreadsheet with your discounted cash flow analysis. I want to ask you about some specific data endpoints on that, which Mr. Moy didn't really go over the specifics with you, but I'd like to.
And can I pause you there, Council? I realized I didn't address the juror note. So let me do that.
Sure.
So members of the jury, I received a written note from one of you that asking whether you would receive, as I recall, the charts/stuff from Mr. Miller. And to that, I respond that during your deliberations, you'll be permitted to review evidence that are admitted into evidence, and that has not yet been admitted into evidence. So you may proceed.
Thank you, Your Honor. Just to orient again, we're pulling back up onto the screen this discounted cash flow analysis for walkers that you had looked at on your direct exam with Mr. Moy. This is the same of what we were just looking at, right?
Yes.
Okay. And I specifically, you talked about what was the percent that you applied for the discount, right? You did the 22% for the discount because it was a higher risk venture than some other ventures. Do you remember talking about that?
Yes.
I want to talk about some of the other numbers that you plugged into this analysis. And if we look here, one of the categories that you looked at was gross profit percent of revenue. Do you see that? It's going to be a little difficult to highlight.
Yes.
Yes. And we can also zoom in if folks aren't able to see it. But one of the things is for all 20 years that you were projecting the profits for walkers, you gave walkers a gross profits, the percent of revenue, right? You did a percent revenue. Do you see that you applied in this
I
analysis?
calculated a percent
Right.
of revenue, yes.
Right. And just for my education and for the jury, what exactly does that mean, that gross profit percentage that you put in for each year?
So that's revenue less those cost of goods sold.
Okay. And the number that you applied for walkers is around 73% for every year. Do you see that? We got 73.21, 73.33, right? You
Yes.
took that 73% number and you applied that to all 20 years, right?
Yes.
Okay. And if we scroll up, just want to make sure the jury can see, that's the number that you applied, 2018, 2019, 2020, 2021. Same for all those years, right?
Right. That makes sense because revenues and cost of sales go hand in hand.
Right. And you didn't put anything in 2020 regarding, how the COVID-19 pandemic may or may not have impacted these restaurants, right?
Right. Couldn't tell.
Right. Couldn't tell. We were in 2022, so we knew it had happened, but you did not include that. You just went ahead and kept it on the same profit as every other year.
So when I looked at the projections, it was as of the date of the restaurant's opening. And so back at that time, thankfully, we didn't know about COVID, but also it would have been unpredictable. Some restaurants have done really well through COVID and some haven't done well.
And so you didn't make a determination as to whether Be Our Guest restaurants would do well or not do well. Although I think a 73.3% profit revenue is pretty good, right?
Compared to what?
Well, explain to me what would be 100% profit revenue?
So I don't understand your question.
Well, I guess I'm trying to understand what this number means.
It means that that is a metric, which is the revenue less the cost of sales. It doesn't have any of the other operating expenses in it. Those are farther down the page.
If a company or restaurant has a gross profit of 80%, would that mean it was increasing more profit than a company that had 73%?
I wouldn't be able to say because people refer to profit as different things. We have gross profit. We talked about EBITDA before and EBIT. So just to limit the confusion, this is not like a final profit number.
Okay.
This is a profit that, after I sell that glass of beer for $10 and it cost me or it cost me $3 for the beer itself. So there's $7 of gross margin or gross profit left.
But we are able to compare this number to how the industry on average runs and how the Nook ran historically, right? We're able to do that.
Yes.
Okay. And that's information that you looked at when you were coming together and bringing your opinions together for this case, right?
Yes.
Okay. And one of the things that you looked at, and I'm happy to pull it up if you need it to help refresh your recollection, was something called the Dun and Bradstreet industry profile. Do you remember talking about looking at industry data?
Dun and Bradstreet, yes.
Dun and Bradstreet, thank you. And from that industry source, you looked at some financial information that's in that industry source, right?
Yes.
Okay. And could we go ahead and pull that up? This is going to be tab 3 in your binder. Again, this is just for demonstrative purposes. We're not seeking to admit this, Your Honor. Now, if you could please scroll down for me, Rachel. Make it bigger. Thank you. You read my mind. Scroll down. Keep going. All right. So one of the things, you looked at the financial information, and one of the items that they explain in this is that they want to identify companies by different sizes, right?
Yes.
And restaurants by different sizes, right?
Yes.
Okay. And so we can see here down at the bottom, it says company size and size by revenue, right?
Yes.
And a large company would be over 50 million. And when they're talking about revenue, they're talking about annual revenue, right?
Yes.
Medium would be between 5 million and 50 million, right?
Yes.
And then a small company would be under 5 million, right?
Yes.
Okay. And the small category under 5 million, you would agree that Be Our Guest would be in that small category, right?
Yes.
And-
And they're projected to be.
Yeah, and actually, just if we're looking just at Walkers, that would be on the very small side, as you projected their annual revenue as right around 1 million a year, right?
I think that's correct.
Now, staying within this same document, if we scroll down, what they did is they looked at the average gross profit, the same percentage that you applied for 20 years for the Be Our Guest restaurants, and they looked at it for the different sizes of companies. And I just want to take a look at what this industry data says. We look here, income statement, we go down to gross margin. And I think if you scroll back up, we can see there we go, kind of the small, medium, large. We've got the small and the medium, the large and the big column, medium in the second to last column, and then small in the last column. Gross margin for the industry for small businesses was 56.4%. Do you see that?
Yes, it may be helpful to show the column headings because to the far right, I think is a combined. Oh, no, it is small. You have 4 columns there. Okay, I see.
Small.
Almost to
Yes,
the
I know,
left.
a little difficult. I appreciate that. So under small, industry data was 56.4%, right?
Yes.
And you agree what that means is that's the industry benchmark for small restaurants' gross profit margins, right?
That is correct. That is an average. There are some that do better, some that do worse.
And so the 73% profit margin that you applied to Walkers for 20 years, that's, a little under 20% better consistently than the average for the industry, right?
Compared to these numbers. And yes, those were absolutely discussions that I had with Mr. Lett as to, how can these numbers be different? Looking at,
And I don't want to know anything Mr. Lett said. I just want you to confirm you gave Walkers a almost 20% higher profit margin than what the industry was reflected in the data that you relied upon in this case.
I relied upon projections that had a higher gross margin. That's correct. And there were reasons to do so.
Right. And you came to that conclusion, and you chose that number based on conversations you had with Mr. Lett and Mr. Dooley.
Yes.
Okay. The grounds?
Just characterize. Go ahead.
All right, I think he's withdrawn the objection. You can ask your next question.
Okay. And you understand that there was a restaurant in the space before Be Our Guest was going to be in the space. There's a restaurant a couple of years back in that space, right?
Yes.
And that was called Park, P-A-R-Q. You're familiar with that?
Yes.
Okay. And, you do not know what happened with Park in that space, right?
I don't know.
You do not know if Park failed and that's why it no longer continued operating. You don't know that.
I don't know that.
That's not something you looked into or thought was important to consider when you were considering the profitability of the new restaurants that would go in that space.
So I don't know exactly what happened, but I know that we had discussions around that. And for reasons I can't remember as I sit here right now, it was understood that that situation was different than the situation going in for Soulshine and Walkers. Obviously, each business has its own unique circumstances.
Right. Well, Mr. Lett and Mr. Dooley don't have any information about Park, right? I mean, you didn't identify any information that was provided to you about Park and how it was performing.
I don't have any financial information or anything like that about Park, no.
Right. So you have no basis to sit here and say that the restaurants that were being proposed for Be Our Guest was any different or a better concept or a better menu or anything than what Park was doing at that space.
I think I did know at the time of Park and kind of what their menu is, but I don't know it as of today. I just recall that we had discussions and that was a different kind of company, a different restaurant.
You didn't Google to see why Park is no longer there?
I probably did at the time. Again, that was 3 years ago.
Right. Well, if you could go to tab 1, it's your deposition testimony in this case.
Oh.
Turn to page 90, please. Lines 15 through 16, if you could give that a look for me, let me know when you're there.
15 and 16, yes.
Right. And if you want to look up for some context, what's being discussed here is the Park restaurant, right?
I'm sorry, what line do you see that?
Go to page 89, look at lines 20. Mr. McCleary asked you, let me ask you this, have you heard of Park? You said answer, I've
I
heard it
see that
mentioned.
now. Yep.
So now the lines that I'm specifically asking about in your deposition, let's look at page 90, 12 through 16. Question, did you make any effort to understand, talking about why Park was no longer there? Answer, just through discussions with Catherine and David. Question, you didn't Google it? Answer, no. Did I read that correctly?
Yes.
Now, you are aware, Ms. Miller, that the National Restaurant Association publishes figures that around 60% of new restaurants fail within 1 year and around 80% fail within 3 years. You're aware of that, right?
I'm aware that there are statistics about failing restaurants, yes.
And you agree that the National Restaurant Association is a reputable source?
Yes, of course.
And you don't have any reason to disagree that those are their statistics as to the success of new restaurants that open?
No, I don't have any reason to disagree. I wouldn't be able to. I have no understanding of how the statistics were developed.
I want to go back to up to the spreadsheets. So these are some of the exhibits to your affidavit. And I want to pause right here for a moment. We talked about the percent gross profit that you put in for the restaurants. But if we go up, one of the items that went into the revenue, right, was alcohol sales. Do you see that?
I do.
Okay. Were you aware that at the time that the sinkhole was found, Be Our Guest had not obtained a liquor license for Walkers?
I'm sorry, I may have been aware of that, but I'm not surprised the restaurants weren't open yet. They had time to do that.
Right. In your conversations with Mr. Dooley or Mr. Ouellette, did they inform you there had been pushback by the neighborhood and that they were going to actually have to request a waiver in order to get their liquor license?
I don't recall if that was part of our discussion.
If they were not able to obtain that liquor license, then this percent revenue that you've given them for alcohol sales, that would have to be taken out of this analysis, right?
Yes, I mean, you could, again, with new information, you could revise the projections and come up with better projections. I would imagine that the Conservancy also thought they could get the liquor
Well,
license.
I'm going to object to any speculation as to what the Conservancy thought, ma'am. My question was simply, if they were not able to obtain the liquor license, which they did not have at the time that the void was found, we would have to take this alcohol revenue number out of your analysis, right?
Yes, and we would adjust the rent expense as well.
Okay. Now let's go
Cost.
to the assumptions. Yep, here we go right here. Now, one thing that I thought, can you just explain for the jury, because I'm not sure that Mr. Moy went over this with them, so I want to make sure they understand. What is this assumption support that you have here in your calculations?
So we're showing the comparison with Walkers and Soulshine to the Nook, and then also pulling in some average industry information for both the capital expenditures and working capital that we talked about before.
And since you just mentioned the Nook, I don't see this here, but what's missing in this calculation as an assumption that you used in your calculations was the gross profit as a percent of revenue for the Nook over the 10-year period. That's not listed in these assumptions, right?
That's correct.
Okay. It wasn't one of the key metrics that you put into your analysis.
That's correct.
And so even though we've talked a lot about the Nook, how you compared to the Nook, the 10-year historical data that you had of the Nook's gross profit as a percent revenue, that you didn't plug that in.
Right. As I mentioned before, there are multiple metrics for earnings. There's gross profit, but there's also EBITDA, which is that earnings before interest and depreciation. And then there's other earnings metrics. So we chose to do a comparison with EBITDA, which is in here.
And you just told the jury on direct examination about how the Nook was so similar, restaurant, menu, neighborhood, all those things. You would agree that the Nook's historical profitability over 10 years, which you had that data, that would have been a better comparison than just the industry generally, right?
Yes.
And let's go ahead and take a look at those actual historical income statements for the Nook. So here we have here, if you could see at the top, this is another item that you had available to you. And I think you actually put this document together, right, Ms. Miller?
I did.
Yeah, so you took what you talked about before, the income statements and the tax documents and everything that you had been provided as to the Nook's historical financial information, and you put it into this nice little spreadsheet we have here, right?
I did.
Okay. And let's look at that gross profit percent of revenue, which we just looked at for your projections. And so what my colleague Rachel is highlighting here, these are actually the gross profit percent of revenue that the Nook experienced from 2009 to 2020, right?
Yes.
Okay. And it fluctuates over the years. Started off 2009 when the Nook first opened, 65%, dipped down to 40%, 2011, back up to 56%, 2013. We kind of got some up and down. But at the end of the day, you agree with me, Ms. Miller, that the Nook's gross profit, percent of revenue, never got over 65%
I agree with you.
in those 10 years of data.
Yes.
And in fact, really the profit was more around 55% or lower for most of the years. Would you agree with that?
Yes.
And for 2020, the Nook's percent of revenue at that year was 35.74%, right?
Yes.
So in a 10-year historical period of data we actually have by a restaurant run and owned by Mr. Dooley and Mr. Olet, the Nook never obtained a profit margin as high as the one you projected for Walker's for 20 years, correct?
So just to be clear, because you've said that I entered that amount. So I'm vetting the projections that were given to me that were used by the bank and the landlord as part of ordinary business. And so just to be clear, while I relied on them, I didn't put in a certain number. But yes, I sat with Mr. Lett and possibly Mr. Dooley at the time and talked about why there are differences and between the Nooks
And
historic performance.
I don't want any information that was told to you by Mr. Dooley and Mr. Olet. I'm trying to have some hearsay here, Your Honor.
Well, no, so I'll just ask the witness, just pay close attention to the question that's asked. And then if to respond to that question, you need to provide more information, you can do that, all right? But keep focused on the question that's asked. All right, if you could re-ask the question.
Sure. In a 10-year period, the Nook never obtained a profit margin as high as the one that is in your analysis for 20 years for Walker's, correct?
That's correct.
And in fact, in a couple of the years, the Nook didn't even obtain half of what you have plugged in for Walker's, right?
I didn't plug it in, but yes, I relied on it.
Okay, so that 73% gross profit rate, I just want to make sure I understand. You're saying that's not a number you chose?
If you look at those projections, they were projecting that gross margin in the first 2 or 3 years that we had projections, and that's cost of sales and revenues move together. So it makes sense to just kind of keep that constant.
Okay. And I guess I misunderstood because my understanding was that your expertise as an accountant in doing these types of evaluations, you chose that 73% profit number. But what I'm understanding now is that that was a number that was given to you by Mr. Olet and Mr. Dooley in their projections.
It was in their projections. I vetted the projections with them and continued that on for the out years.
Okay. And that 73% is very different than what the Nook actually experienced, right?
Yes, and there were reasons that's, which I won't be able to say.
And again, my question is very simple. That was very different than what the Nook actually experienced.
Yes.
I want to take a look now at the expenses. Let's go back up to the expenses that you gave for Walker's. And just so we understand, again, the gross profit is that revenue minus expenses, right?
Yes,
Okay.
yes.
And so I just want to look,
look.
sorry, please clarify if you need to.
Gross margin is revenue less cost of goods sold.
Got it.
And then there are other expenses to get to an earnings margin.
Okay. I just want to look at the total operating expenses percent of revenue. Do you see that there? And we're back up looking at what you plugged in for the Walker's projection. And here you have kind of varied those total operating expenses. We've kind of have a variability between about 46% to 48% for most of the years. Is that fair?
Yes.
Again, we have that industry data. So you're able to compare the total operating expenses that you gave to Walker's to what the industry was doing, right?
Yes.
And let's take a look at that real quick, Rachel, if we could go down to the Dun & Bradstreet industry document again. So this is our same chart. If we scroll back up a little bit, just so the jury can see, we've got that large, medium, small. If we go down for small, we look at the operating expenses. That's at 53.4%. Do you see that?
Yes.
Okay. So you projected that the expenses, the operating expenses for Walker would be lower than the industry average, correct? Or the number that you included in your analysis was lower, right?
Yes, we typically don't rely on that metric out of this research.
And another thing that you looked at, and forgive me, how do we say this acronym? ABIBTA? That's not how you say it?
EBITDA.
EBITDA. All right. EBITDA. I'll work on that. And that's another thing that you looked at, right? For your discounted cash flow analysis, right?
I looked at the projections
Yes.
and they had an EBITDA metric. Yes.
And EBITDA just stands for earnings before interest, taxes, depreciation, and amortization, right?
Amortization. Yes.
Amortization. All right. I'm learning a lot today. Thank you. So for those non-accountants in the room, like myself, that's basically like a net earnings measure, right?
It is one of the metrics that we use to measure earnings. Yes.
So if we go back up and again, look at the analysis that you did for Walkers. And I think if we have to go a little bit down to see the EBITDA. There we go, right at the bottom. Percent revenue, so that net earnings measure. Got 15.96% that first year, and then it kind of lands right around 25, 26% for the rest of the years, right?
Yes, I believe so. I have a bar. Oh, there it is. I see it now. Yes.
And for this one as well, we have some comparable industry benchmark data, right?
Yes.
Okay, let's take a look at that. Okay, and again, if we scroll up, can we see that we have our different categories of or sizes? Or sorry, just go up. Again, all the way up near the very top is where we got that large, medium, small again. So let's go back down. Here we have that EBITDA, that's at 6.7%, right?
I see that.
Okay, so you predicted or based on the projections you received from Mr. Dooley and Mr. Ouellette, they projected a 20% higher net earnings than the industry data we have here, right?
They have, yes, we're expected to have higher earnings.
And again, let's compare the EBITDA that we put in for Walkers to what the Nook actually experienced. Let's go take a look at that. If we look at the EBITDA that the Nook actually experienced, and this is on this bottom line there. Oh, no. Yeah, that's right. Can you highlight it for us, Rachel? In their first year of operating, they were actually at a negative, right? Negative 4%.
Yes.
Is that right? And then we have a lot of fluctuations. The highest that they ever got to was 25.19%, right?
Yes.
Okay, but it's kind of between 6%, 10%, 20%. So again, you're projecting that Walkers is going to do better every year on net
Yes.
earnings than the Nook did.
Yes, we are.
Okay. And so now that we have looked at the different numbers that you put into the analysis, I just want to confirm, those are the percentages and the data that you've plugged in order to reach a conclusion that over 20 years, there would be $3.1 million of lost profits for Walkers, right?
I didn't plug in the numbers to reach a conclusion. The numbers, I used the projections and did the analysis and determined what the overall conclusion was.
All right, the opinion that you have been tendered as an expert in this case to give to this jury so that Mr. Dooley and Mr. Ouellette and be our guest can ask this jury for $3.1 million in lost profits for Walkers. That is based on all of the data that we just looked at and went over, right?
Yes, this is my analysis.
And the last thing I want to ask you, just two more questions, Ms. Miller. You're aware that Mr. Dooley has explained that Be Our Guest, the company, was formed to explore new restaurant opportunities, right?
That makes sense.
Okay. And to your knowledge, in the 6.5 years since the void was found, Be Our Guest, Mr. Olet and Mr. Dooley, they've never made an effort to try and open these restaurants anywhere else so that they could try to get some of these profits that they anticipated to receive, right?
I don't know that they have. I don't know I don't know how they've expanded their Be Our Guest business.
But you would expect if Be Our Guest was able to open these restaurants, say in 2021, they've been operating, they wouldn't be coming in this courtroom asking for lost profits for those years, right?
And my understanding is that these concepts were really made to fit for Piedmont Park, being at the entrance to Piedmont Park. And so I don't know that they could pick that up and put that somewhere else. Not being a restaurateur, I don't know. But I also don't know if they have looked into or researched any other restaurants.
Whether they could or not, you do not know if they've even tried. Fair?
Yeah, that wasn't part of my analysis.
Those are all the questions I have for you. Thanks, Ms. Miller.
Redirect.
Ms. Miller, thank you. Just to be clear, I think we've exhausted the point, but you didn't just rely on projections that were given to you by Be Our Guest in this case, did you?
No, as with any projections, if I'm handed projections, there's a vetting process that we go through. In this case, we looked at the industry, we looked at the Nook. We noted that there were differences. We discussed those with management. Why would these differences exist? And we were satisfied with the answers.
Okay. And in looking at those projections, you testified earlier, it was important to look at the most recent ones, not the ones from 2014, right?
Oh, yes.
And the most recent ones you had available were the ones that were prepared in 2017 at the time the lease was signed. Is that right?
That's correct.
Okay. You don't have at the time you prepared these calculations, you were projecting out from 2018 forward, which was the commencement of the lease, right?
Yes.
Okay. You were asked about the impact of COVID-19 and whether that could have changed your calculations. Do you remember that?
Yes.
Do you have any knowledge whether the Nook obtained any sort of PPP funding or a PPP loan during the COVID-19 pandemic?
My understanding.
Object, Your Honor, as to relevance and speculation.
Well, she either knows it or she doesn't as part of determining lost profits. So
Also relevance, Your Honor.
She opened the
if
door.
she gets, I'll overrule it. All right, you can answer.
Yes, I believe that they did get the government money at the time of COVID.
Do you know whether the Nook performed well during 2020?
I know that they had opportunity to open up some outside tables and yes, we can see how they performed in their financial statements.
Okay. You were asked about the gross margin and the fact that it was a 73%. And it was pointed out to you that that was higher than I think the 65% number that was shown for the Nook. You recall that?
Yes.
And you didn't get to explain your answer, but you said there were reasons that we had a higher percent gross margin on profit for these businesses.
Yes.
Can you explain what those reasons were?
Sure. I mean, based on conversations, there were.
Object is here, say, Your Honor, to the extent her reasons or conversations with Mr. Dooley and Mr. Lett.
All right. Mr. Moore, are you able to articulate those through proffer for the record so I can actually make a ruling on this?
Articulate
Do you have an understanding of what she's about to answer?
at a high level, but
Can you just approach and so I can make a determination here? All right.
I think she.
All right. The objection is overruled. However, members of the jury, I'll give you this instruction. In answering this question, the reasons for the opinion here are admitted solely for the purpose of assisting you in evaluating the opinion, if any, and not to prove the truth of the evidence by itself. All right. So you can use this evidence to evaluate the opinion itself. You can proceed, Mr. Moy.
yes, to repeat my question, what were the reasons that you applied or that you had a higher gross margin in the projections for these new businesses compared to the Nook?
Sure. So while the businesses are very similar, there are some differences. When you expand a business to add on 2 more restaurants in the group, a lot of times you have more buying power with your vendors. You've got them coming to the Nook to drop off whatever you ordered. You get some quantity discount. And they're also going to these 2 new restaurants that are nearby. I recall that that is one of the things that we discussed.
Do you know whether there was better parking availability at the new business compared to the Nook?
Yes, I understand that there was. The
No, if it
Nook-
was, do you know if the new location was in Piedmont Park, whereas the Nook was on Piedmont Avenue?
Correct. My understanding is the Nook doesn't have much parking at all, especially since they've been able to use some additional outdoor space,
Okay.
but Piedmont does.
You were asked about the business that was at this space before Mr. Alette and Be Our Guest pursued these businesses. Do you remember that? It was a restaurant called Park,
Park, yes.
P-A-R-Q.
Mhm.
Do you recall if that was what type of food they were serving at Park?
I don't, right as I sit here. I think at some point I knew, but
Okay.
I think it was a different concept though.
And you were asked why you didn't look at any financial history or performance for Park. Is the reason because Be Our Guest didn't have any ownership overlap with Park?
Correct.
And so there was no connection between Park and, for example, these businesses, which had a connection to the Nook. Is that fair?
That's correct. They didn't have any ownership in Park.
Okay. You were also asked about a liquor license, and it was asked in a way that suggested there was difficulty obtaining a liquor license. Do you remember that?
Yes.
Do you know whether the liquor license issue was specific to Walker's, the larger restaurant, or Soulshine, the grab and go facility?
I'm not sure which one.
Okay.
If-
You were asked about the operating expenses and the Dun and Bradstreet numbers that were shown,
Yes.
and you said that you ended up not using them, and you had a reason why. I'd like to understand why, if you recall.
Oh, the operating expenses as part of that research,
Yes.
because it's too difficult to tell what numbers go into that. It's just that line item. Different companies have different ways of classifying information for it to be in operating expenses. And there's just no way to tell. It's not enough data.
And the Dun and Bradstreet obviously is pretty general in the sense that it's the restaurant industry, right? It's not as targeted as other data you were looking at.
That's correct.
Okay. Your Honor, may I approach?
All right, any further questions?
No further questions. Thank you, Ms. Miller.
Any recross on those points?
No, Your Honor.
All right, can this witness be excused? Thank you, ma'am.
Yeah.
All right. Unless anyone needs a break, I know that, as I understood it, there were at least 2 witnesses on deck. And so I think with an hour left, if we can get through 2, that's a day. So why don't we just go ahead and move forward? I don't think we need a break to discuss logistics at this
That one
point.
relates to one of the questions the court had asked. us.
Right. Can we start with the other one?
No, we cannot.
Okay.
Yeah.
Not here, Your Honor.
Pretty sure he's not.
Okay. But let me just have counsel approach. Yeah. All right. Feel free to keep stretching in place. I think we will have at least one more witness to get through. I think we will still be finishing before 5 today.
I have to read.
All right, plaintiff may call the next witness.
Your Honor, plaintiff calls Rachel Gage to the stand.
Do you swear affirm that testimony should give court the truth and the truth will be not?
I do.
Would you please state and spell your name for the court?
Rachel Gage, Rachel Gage. Miss Gage, thank you for coming in today. First, I want to take a moment to introduce myself to the jury, as this is my first time speaking to you all. My name is Anna Whitaker. I represent plaintiff and counter defendant, and I'm with the firm Barnes and Thornburg. So, Miss Gage, what is your occupation?
I'm a partner at the law firm of Robbins, Alloy, Belinfante, Littlefield.
So, are you licensed to practice law?
Yes,
Okay, in which jurisdictions?
Georgia and North Carolina.
And how long have you been practicing law?
Since 2008.
And what's your primary focus?
Business litigation and land use and zoning litigation.
Are you involved in your firm's billing process?
Yes.
Can you tell me more about your involvement about that?
Sure. So each of the partners at our firm handles billing for their clients, for which they're the main contact. So let me back up. As a timekeeper, so as an attorney at my firm, we bill by the hour. So I have a software where I and other timekeepers put in how much time we're spending on what tasks kind of contemporaneously while we're doing it. It goes into the software. And then at the end of the month, the software will pull all the time for all the timekeepers that worked on that matter and generate an invoice. So my involvement is putting in time as a timekeeper. And then if I'm sending the bill under my name, I'll review it each time entry and make sure it's accurate. And then I'll sign the cover letter for the bill.
Got it. So you just mentioned that you and other timekeepers with your firm normally charge per hour. Can you tell me more about your familiarity with the rates your firm charges?
Sure. Yeah. Our rates, I think, are pretty standard for a firm of our size and reputation. We have about 30 attorneys. The rates are set per timekeeper based on the level of experience. So more senior and experienced attorneys have a higher hourly rate than younger attorneys.
Okay. And so I just wanted to bring your attention back to this case here. Did you ever represent plaintiff via our guests in this case?
Yes.
Okay. And when were you retained to represent the plaintiff in this case?
It was about mid 2019, June or July 2019.
And do you know what stage of the case, was at that time?
Yeah, we assisted the plaintiffs very early on. No complaint had been filed. So that was the stage. It was a pre-litigation negotiations.
And when was this about?
We started in mid-2019 and we worked on it for about 6 or 7 months.
Okay, and what type of work did you perform for Be Our Guest?
We met with the clients a few times, understood kind of the background of the dispute. I think we reviewed the lease that was at issue. And we ended up writing a demand letter to the landlord regarding the lease dispute.
And you just mentioned a lease dispute. What's your general understanding of that dispute?
I think at the time, our client was the tenant in the space, and the landlord was asserting that the tenant was in default of the lease, which we disputed. And so we worked on analyzing, the justification for disputing the default. I don't remember the details anymore, but I know that we disputed the alleged default, and then we also asserted that the landlord was in breach of the lease as well.
And do you understand that the active claim in this case is plaintiff's breach of contract claim?
Yes.
Okay. And did you enter into any fee or payment agreement with Be Our Guest when they retained the Robbins firm as counsel?
Yes, we had an engagement agreement with Be Our Guest, and it was just that they would pay us hourly for our work.
And did Be Our Guest agree to the terms of this agreement?
Yes.
I'm handing the witness what's been pre-marked. It's Plaintiff's Exhibit 231. It's a subset. Bates numbers Be Our Guest 4353 to 4368. And Ms. Gage, do you recognize what I just handed you?
Yes.
And how do you recognize?
These are bills that our firm sent to Be Our Guest.
And what do you understand the time frame on those invoices to be?
It looks like from spring of, I see time entries from April of 2019. So that was billed in July, but we started working on this, it looks like in April of 2019. And I think it goes through January 2020.
Does your firm regularly issue invoices to clients to charge for the work performed?
Yes.
And can you briefly describe for us the process your firm undertakes in generating these invoices?
Just jump in here. Is this an issue that's contested? Has there, we raised this later about the amounts?
We've made an effort, Your Honor, to streamline that. We've not heard from the plaintiff.
All right. You can proceed.
Counsel, your effort was sent late
All right.
last night.
That's, we're not, I'll direct the jury.
Question was yesterday
They
afternoon.
don't need to take any thing from representations of counsel on this point. So plaintiff, you can proceed.
Okay. Ms. Gage, can you please just describe for us how the Robbins firm generates invoices?
So as I mentioned earlier, we have a software, it's called ProLaw, and we put in our time as it's incurred. And the invoices are generated where ProLaw can pull each time entry and aggregate it and add up the total amount so that the client receives an invoice that shows each time entry so they can see the work that they're being charged for. And then it shows the total amounts that's owed to the firm. We send those each month.
And earlier you mentioned that these time entries are reviewed. Can you kind of walk us through more of that review process?
Right. So the billing partner on a matter will receive what's called a pre-bill, which is just a draft of an invoice with all of the time entries, and we'll review each one, and if it's appropriate, write the amount down. If in the partner's judgment, a younger attorney has maybe spent too much time on something, they'll cut that down, or see if any changes need to be made to the billing entries to make them more clear, things like that. And then that goes back to our billing department, which will make those changes and then generate a final invoice, which looks like the pre-bill but corrected.
And I just handed you a subset of invoices, but are invoices generally maintained as part of your firm's regular business practice?
Yes.
And do you have any reason to believe the invoices handed to you are not trustworthy?
No.
Your Honor, I would like to tender into evidence the subset of plaintiff's pre-mark exhibit 231, be our guest, 4353 to 4368.
Any objection to that portion of 131?
No objection.
Submitted.
Ms. Gage, referring your attention back to those invoices, and let's publish those to the jury. So. What amount do you understand the Robbins firm billed Be Our Guest for legal work relating to this case?
I believe the total amount was close to $15,000.
Okay, and that number would just come from adding up all the fees that are shown in those invoices?
That's right.
Okay, so are those invoices a true and accurate representation of the time worked and invoiced to Be Our Guest for this case?
Yes.
Okay, and looking through these invoices, Ms. Wilkerson, if you scroll down a little bit, I see some initials next to some time entries here, RG. Can you tell me what those mean? Those initials stand for?
RG, that means that I was the timekeeper. That stands for Rachel Gage.
Okay, so I understand that you're one timekeeper on this case. Were there other timekeepers staffed on this case?
Yes, Josh Belinfante was the partner on the case at the time. And we had a couple of associates working on it. Emma Bellamy and I believe Andrew Swindle did a little bit of work.
And is it normal to involve more than one attorney to work on a case?
It is, yes.
Can you walk me through, you just mentioned a few of those timekeepers. Can you, and I see on the screen there, Emma Bellamy, can you talk about more of her role?
Emma was a really young associate at this time. And so as I recall, and again, I don't recall specifics, but I believe that what she was doing around this time was a lot of legal research and doing first drafts of documents.
And what do you understand her rate to be at that time?
Her rate was $2.75 an hour.
And do you consider this a reasonable rate?
Yes.
And I also see, and I'm referring back to 231 on the screen there. I also see your rate is up there for $280 an hour. Is that right?
That's what that reflects. Yeah, that's a lot lower than my normal rate.
Okay. So, Lisa, if you keep scrolling down a little. I believe you mentioned another timekeeper on the case. I think Andrew. Can you talk me through his role on the case? Or maybe I got their name wrong. Let's just.
Andrew, that's right, Andrew Swindle. He was also a young associate, and I only saw one entry for him, but he was, I believe he did some legal research, which he's quite good at.
Okay, so I understand, again, I just want to adjust ourselves through the time frame, that your work was predominantly done prior to the filing of the complaint of this case. Is that right?
Yes, I think it was done entirely before a complaint was filed.
Okay, and you mentioned some research tasks. Can you talk about, if you recall, some of those tasks you performed or what you would be researching?
I honestly can't recall specifically, but it would have been related to the lease dispute, landlord-tenant law.
Okay. And do you believe that the work performed on this case contributed to the overall efficiency and success?
Yes.
And in your professional opinion, were the fees charged reasonable and necessary?
Yes.
Okay. No further questions. Thank you for your time.
Hey, Cross.
Good afternoon, Ms. Gage.
Good afternoon.
Nice to see you. It's been a while.
Yes.
I'll be brief with you, Ms. Gage. I have just looked through all of the materials that Ms. Whitaker just submitted. If we wouldn't mind, we'd put it back on the screen. I just want to understand a couple things. If we could go down to the Bates label ending 4356. It looks like, what are we looking at here, Ms. Gage?
This would be the summary invoice reflecting total amounts owed.
Okay, and there's also, I'm curious about this line. It says payments and credits since last invoice. Do you see that?
Yes.
And on this particular invoice, this one's dated October 17, 2019. There have been no payments since the last invoice, right?
That's what that reflects.
Okay, and take a minute, if you will, and just look through all of these documents. I'll represent to you, Ms. Gage, that I've seen a single time when that particular field is entered, and it's on the September 23rd, 2019 invoice, indicates that a payment of $10,000 even was made.
I see that.
Do you see any other indication in any of these documents that anything more than that was paid to the Robbins firm?
On these pages, I do not, but I did confirm with our billing department that $15,000 was paid.
In total?
Yes.
Okay, so am I understanding correctly? You just put about $45,000 worth of bills into evidence and only $15,000 total's been paid?
I don't think the $45,000 figure is correct.
I'm just rounding. I added up quickly here. But let's see, we've got a bill for $10,500. I'm going to use round numbers, 10,000. I'm going from the back.
All right, let me catch up with you. Okay.
Okay. Then we've got 16,000. That's 26,000. Then we have got 1,650, so call it 28,000. 6,000. So that would bring us to roughly 34,000. $7,000, so that would bring us to about 40,000. And then another for 1,100. So let's just call it 40,000, Ms. Gage. You agree with me that your firm, and these were at discounted rates, right?
Forgive me for not being able to keep up with you completely, but I believe some of these are cumulative. So I really don't know if your numbers are right. I do know that we discounted the amount that we billed.
Well, Be Our Guest didn't pay all of the bills, right?
We negotiated a rate with them. They ended up paying us $15,000. If they had paid every hour that we billed, it would have been more than that. How much more? I actually don't know sitting here today.
Okay. So they stiffed you to some extent?
No, not at all. Not at all. It's very common to come to an agreement with a client that, you're going to, for whatever reason, this is the amount that we're going to agree on. We left on good terms.
it's common in your experience to discount to a client, not off of standard rates, but off of bills sent, to discount more than 50%?
I don't agree with you that it's more than 50%. I just don't know how much the total was, but it is standard to discount, yes.
Okay, but putting it aside, the evidence is $15,000 was paid to the Robbins firm.
That's correct.
And who paid it?
I don't know. I assume it was Be Our Guest.
You assume, I don't want you to assume. Who paid it?
I don't have that. I don't have copies of the checks.
Well, that was going to be my next question. Where are those checks?
I assume they're with our bank.
That's all I've got. Thank you.
Any redirect?
Ms. Gage, I want to redirect your attention to the invoices Mr. McClary was so generously adding up for us. And I'll start at the Bates number on the bottom right page, 4353. And we look at the top, that invoice is dated October 22nd, 2019. Do you see that?
Yes.
Okay, and let's go to the second page, 4354. Let's go down. And do you see there? You can go down another page. Okay, what is the amount you see listed next to total current billing?
I'm sorry, are we on 353?
Oh, yes, sorry, I'm looking at the screen and not directing you. 4355.
55, okay. Bear with me, I'm afraid I mixed up my pages. $1,000.
Okay, 1,000. Now let's go to the next document in the packet I handed you. It's an invoice dated September 26, 2019, with Bates stamp to Be Our Guest, 4357. And I'm going to direct your attention to, give me a second here, make sure I have everything right. To the page Bates stamped 4358. And I want you to take a look at the next, at the bit that says total current billing. And can you tell me the amount of money listed next to that?
Well, $1,583.50.
Thank you. And let's go to.
Counsel, other than just having this witness read what's already been admitted into evidence, do you have any other questions? Could you not do this math during closing argument or through some other witness?
Yes, sorry, Your Honor. Mr. McClary was undergoing mathematical calculations, so I felt the right to be entitled to as well.
Well, you can have another minute to do that, but we're not going to do that all day.
Okay. Ms. Gage, do you agree with me if you added up all the total current billings for each of the invoices I handed you, that would add up to $15,607.74? Or let me ask differently, do you have any reason to believe the invoices, as I just discussed, wouldn't add up to that amount, $15,607.74?
I do not have any
Okay.
reason.
And it's still your testimony that Be Our Guest paid in full for the work reflected in these invoices?
It's my testimony that Be Our Guest paid a negotiated bill in full, that we are satisfied with the amount that they paid. They paid us for our work.
Okay, and you and Be Our Guest left in good terms?
Yes.
Okay, no further questions.
Any recross?
Just one. Ms. Gage, I just want to clarify one point. You don't know who paid these invoices, right? You know that $15,000 was paid.
That's right.
Okay, thank you.
All right, can this witness be excused?
Yes.
All right, thank you, ma'am.
Thank you, Your Honor.
Take care. Okay, members of the jury, we've covered a lot of ground today, as I understand it, we're on track, if not a little ahead of schedule. So with that, we can let you go early. Please be back at 9 o'clock again. Make your best effort. Let's try to start at 9 if we can. I know that's more difficult for some than others, but we'll do what we can. Please don't discuss the case with anyone, including amongst yourselves, and don't do any research about the case. Does anyone have concerns before you break? See you tomorrow morning. All right. So let's use this time to plan out, perhaps forecast the rest of the week. The first thing I would say is that I would ask counsel in this most recent incident, this would fall on Mr. McLary. Let's keep evidence that is not being tendered for the record, stuff that's happening outside the juror's presence in terms of interactions between counsel, either on sidebar, but they shouldn't be hearing about emails being exchanged, the status of things, whether they've agreed to things or not. So those kind of extraneous comments, jury doesn't need to hear that. On the issue of attorney's fees, I think there's room here where we don't have to go through that same exercise 4 more times with everyone else. So again, I'm really going to be pushing the parties to see what exactly we can streamline there. And it may be the way to streamline it is you'd have a very, very short direct, and then on redirect, then you get into whatever it seems to be the issue is. I think that's one proposal. You don't need to, lay out, and this isn't directed to Ms. Whitaker or anything like that, but cover every base unless you know which one's actually, trying to, which direction they're coming at. So that's one idea. But then I think there's still that issue of bifurcation. I understand that something the defense may want to talk. By the way, you can be seated. I think we might be talking for a while. I know that's something you still wanted to discuss with your client. Are you saying that's not an outright no interest, or is it just a very low percentage?
Low percentage, but it's not an outright no.
And I just want to make sure I was making myself clear. It's just the first phase. I could even tell the jury that we've decided to split that up. Would be a verdict form. It's where both the jury would make a finding as to whether the 13,611 elements of bad faith in the underlying litigation have been established on the part of either party. And if so, then the side where that was found in favor of would come back and be able to prove the amounts and the reasonableness and that sort of thing.
One point of clarification. To be clear, the conservancy is seeking damages for attorney's fees
and on the contract. That's fair.
Under the contract.
No, I forgot about that.
Also, with respect to your suggestion yesterday, I thought it was a good one. Again, I did reach out to counsel and with a proposal, have not, well, I may have heard back today, but I haven't received it. But I'm a little concerned based on what we just saw in terms of getting in the attorney's fees cleanly. Maybe I'm misunderstanding these invoices, but
What aspect? It seemed clean to me. It just was taking too long. That's all.
no, I mean, this is $40,000 in legal bills that were put into evidence, and the evidence is only $15,000 was paid. So I don't have any trust in just adding up invoices and agreeing to an amount.
Okay, and to that end, I mean, I think I would understand that. I didn't know if I don't know what's going on in the background. If you've actually touched base with these attorneys or had discussions about what is in their documents, so I get that. And if that is something that you don't have confidence in, then yes, it'd have to be through formal proof. So we can leave that as it is, or see what effort is made there.
I'm willing to accept, proof of payment, but just invoices is, in my opinion, not what is necessary to prove damages.
Okay, now I hadn't heard that one before, and so I think that would ultimately be a jury question. If you're going to say that the evidence produced through the testimony wasn't sufficient. All right. But in terms of mapping out Thursday and Friday, I would say, 30 minutes today, that's fine. But, you know, if it got to a point again where we've got an hour or more, that's when I start wanting to call people who are sitting right here ready to go. And so it may not be the order that a party would prefer, but that's always going to be a way that I'm going to a switch I can pull to fill time. But let me just hear from plaintiff counsel first to kind of map out what we're looking at tomorrow.
Thank you, Judge. And before we get there, just on the attorney invoice piece as well, I mean, we would like to shorten our direct just for the court's awareness. We haven't been able to reach agreement on business records exception, so it's stilted, but there we are. And then regarding witness order, so where we are is, you know, we had a conversation this morning with Mr. Peak, who was supposed to be here at 4 o'clock. He's not. Obviously, we're in court, not able to figure out what's going on. Just know that we haven't heard from him. For all we know, maybe the city attorney shows up with him again tomorrow. We don't know what's going on. So we got through Ms. Miller, Ms. Gage. So where we are is this. We have on tap, I think what you're asking me is the remaining witness order at this point.
And let me be clear, I'm not trying to say I need the exact numerical and I'm holding you to this. I'm just trying to get an idea of just how many more witnesses are left, you would think, and if we think we have enough to make sure we've got a full Thursday.
So we will absolutely have a full Thursday. No question about that. We probably will get into Friday. I don't think we're going to get past Friday. I think we'll be wrapped up by Friday is our best estimate at this point.
Okay. You thinking Friday before lunch or after the lunch break? Lunch break being somewhere around the noonish.
If the attorney's fees thing goes like it just did, probably after lunch on Friday.
Okay. And that's looking like 4 more attorney witnesses. You're still trying to track down Mr. Peak, and we've got a Jennifer Ide, and we've got Mr. Roulette, and you had Mr. Hapberg.
That's right, Mr. Hagberg, and then a Mr. Chris Lewis.
Okay. And at this point, is that looking like?
I think all of that will easily take us through tomorrow.
Sure, I would agree with you there, and that does take you through most of the witnesses listed in the pretrial order. There's a few others here and there, but at this point, do you see yourself calling, for example, who does that leave? That leaves
The
Chris
people-
McDade.
McDade and
Abed.
Mr. Banta, of course, and we can make a.
Oh, you're still looking at calling Mr. Banta then?
We'll talk. Yeah. So the 2 remaining people that we haven't talked about with Your Honor just now were McDade and Banta, and we can let the court know tomorrow whether those are going to be witnesses for us in our case in chief.
Okay.
Your Honor, I can answer one of those questions. There's been a request that Mr. McDade be made available. I have received an email, quite an upset email, while we've been in court today. Mr. McDade is out of town. He will not be returning in the next week or 2. Apparently a process server is being very aggressive with his wife. They have called 911. So I am unavailable. I cannot make Mr. McDade available.
Okay. Is there anything you're asking of me then, plaintiff?
Not at this point. If we have an issue, we'll take it up with the court tomorrow. Again, we need to huddle on some of these issues. And I appreciate Mr. McCleary sharing that.
All right. Okay. So yeah, I do certainly think that takes us through Friday. And again, so just for the purposes of tomorrow, for whatever reason, you know, we're at 3 o'clock and there was some other witness you were thinking was going to be here. I think it's going to be Mr. Let's turn to just go ahead and fill that time.
We understand.
Right. Okay. And from there, do we think that the defense is going to be able to have a few witnesses available Friday or on call?
I finished.
Sure. Yes, sir.
So the question has been raised and we don't know the court, but about Mr. Hagberg tomorrow versus Friday, we prefer to have him tomorrow afternoon, please. Yes.
Afternoon.
All right. Thank you.
For sure.
And I mean, is that a commitment that you're going to, I don't want to bring him here tomorrow afternoon and then have to.
I mean, there's probably going to be some waiting involved because we can't get an exact time.
Yeah.
But
Well, I'm doing this by cooperation, Your Honor.
Yeah.
There could have been a speed issue.
all right.
We appropriately talked to counsel about this beforehand.
I mean, look, I think,
Hey,
and also worst case, we could interrupt testimony and call in another witness and resume the testimony of what other
Do what we
witness.
need to
I
do
mean,
to make it happen tomorrow.
Yeah.
I mean, I'm just,
Yes,
my
sir.
client's getting a bill from Mr. Hagberg, so.
Yeah, I understand. And that's what my point being is if for whatever reason we need to go out of order or cut and paste, we'll do what we have to do to make things efficient here.
I'm sorry, and we can take this offline, but having gone through this conversation, I still have no idea who you guys are calling tomorrow.
It sounded
Okay.
well that I'll let y'all follow up with.
Yep.
I just wanted to make sure and get a scope of where current projections lie, and it sounds like Friday midday thereabouts, depending on how things shake out with attorneys' fees, witnesses. And so where I was getting at then is the defense going to have some folks ready Friday to fill some the afternoon, assuming plaintiff rests?
If the plaintiff is going to call Mr. Banta in their case, and if he's the last witness, it would be natural. I'll just say he was going to be our first witness anyways. So it would be natural for us to then conduct his direct. So I think that will, yes, is the answer. And if we need to have a second witness ready Friday, we will.
That's what I'm getting at.
Yeah.
Okay.
We'll be ready to fill the day Friday.
Understood. And then we'll just keep making these day-by-day assessments to see where we are. Assuming, let's just play this out as best we can. If you are able to start your defense case Friday, conclude with Mr. Banta,